Srishti ma'am, should I start?
Yes, please.
Thank you. A very good morning, everyone. So, justice today transcends border, discipline, and traditional construct. When law engages with economics, taxation, and global governance, the result is richer, more equitable legal architecture. It is my pleasure to welcome you all to this conference. A very good morning to the respected dignitaries, esteemed speakers, distinguished delegates, and passionate participants joining us from across the globe. A very warm welcome to the inaugural session of Second International Virtual Conference on Reimagining Justice, Law at the Crossroads of Policy, Tech, and Sustainability. Let me begin with a thought that captures the spirit of our collective endeavors today. Justice is not a static destination, but a dynamic constellation of ideals and actions where law lights the path, empathy infuse the journey, and innovation expands the horizon. Today, we stand at a juncture where the law intersects with policy, technology, and sustainability, forging frameworks that not only interprets but redefines the essence of justice in 21st century. Sainoor Nayab, on behalf of Vedseadus Legal in collaboration with Management and Science University, Russia, it is my extraordinary honor to moderate the inaugural session. To ignite our journey, it gives me an immense privilege to invite a beacon of legal education and empowerment, visionary and a catalyst of change, founder of Vedseadus Legal, Ms. Srishti Agarwal, ma'am. Ma'am is a dynamic legal professional from Muradabad, India, who aims towards justice, education, and legal empowerment. She has worked extensively in the national and district legal service authorities, led paralegal training initiatives, and convened the Legal Aid Clinic at Galgutia's University, Greater Noida. Under her leadership, Vedseadus Legal has become a platform for legal aid, awareness, and reforms. Ma'am, scholarship include international conferences, presentations, and contributions to global consultations and mental health and human rights. By being awarded the Vidik Mitra Award for her contribution, she blends scholarship, service, and activism with a deep commitment to the equitable justice. Ma'am, we would be happy to hear you out.
Thank you so much, Sainoor. Thank you so much. Good morning, everyone present here. On behalf of Vedseadus Legal, it is my honor and privilege to welcome you all to the Second International Conference on Reimaging Justice, Law at the Crossroads of Policy, Technology, and Sustainability. Organized by Vedseadus Legal in collaboration with Management and Science University. I'm deeply honored to begin this conference with the presence of insights of our distinguished inaugural guests. A very warm welcome to Dr. Rhishikesh Dave sir, Dean School of Law, Sharda University, Dr. Ajay Kumar sir, Inspector Delhi, Professor Richard Rose sir, Professor of Law, Georgetown University, Dr. Victor Sir, Professor Kutafin Law University, Moscow, Russia. Dr. Nitish Kumar Upadhyay Sir, Associate Professor of Law, Dhirubhai Ambani University, and Ms. Windy Ma'am, co-founder Webcycle, and Dr. Ankita Upadhyay Ma'am, partner at Knowledge Teas EduHub, board member Vedseadus Legal. We are truly grateful for your esteemed presence and setting the tone of this conference. This conference aims to explore how justice must be reimagined and in a rapidly evolving world where law increasingly intersects with public policy and technological innovations to the urgent demands of sustainability. Allow me to briefly introduce about Vedseadus Legal. We are founded in 2023. Vedseadus Legal draws its guiding values by its name. Ved means sacred knowledge, and Sedus derived from the Estonian language, meaning pious law. The principle reflects our commitment to making justice accessible, equitable, and inclusive to all the bridging gaps between law and society and between legal theory and practice. Our work focuses on legal literacy campaigns, community outreach, and capacity building through the three key initiatives, with regards to as cyber awareness campaign, legal literacy rights campaign, and mental health awareness campaign, as each of it aimed to empower individuals in promoting rights-based awareness. Through our vision of clinical legal education, we offer law students a hands-on legal learning through internships, field engagements, and research mentorships, with community visits and numerous legal awareness workshops addressing contemporary legal and social challenges. As we commence today's session, we hope this conference fosters meaningful dialogue and collaborative learning. Thank you so much, everyone. Thank you.
Thank you so much, Srishti Agarwal, ma'am, for deeply inspiring at your words resonate that not only as an insight but to call it as an action, reminding us that justice thrives when compassion meets courage. Moving ahead, every great institution flourishes under the visionary leadership of a confluence of experience, excellence, and ethical scholarships. Respected for his unwavering commitment to the legal education, our distinguished speaker, Dr. Rhishikesh Dave Sir. Sir brings over 21 years of academic leadership, research, and excellence from different forums. As a Dean of School of Law at Sharda University, he champions human rights law, international law, and criminal law. His academic journey included a PhD from Saurashtra University, fellowship training at the Hague Academy of International Law. Sir's leadership extends across the multiple legal institutions, driving research, academic innovation, and establish of a new school. We would like to hear uh, from Sir.
Thank you, Sainoor. Good morning, everybody. It's a privilege for me to speak on this wonderful occasion and on a very important topic uh, that needs to be discussed at this juncture. As we know that we are standing at an unprecedented crossroads. The legal systems that have served us for centuries are being reshaped by forces that previous generation could never have imagined. Artificial intelligence making split-second decisions about bail and sentencing, climate change creating entirely new categories of legal disputes, and digital platforms redefining everything from privacy to property rights. The question before us isn't whether this transformation will happen, it's already underway. The question is whether we will guide it thoughtfully or let it unfold without any intention. Technology offers extraordinary opportunities to democratize justice. For example, Estonia's e-residency program enables entirely online legal services, while India's e-court mission have digitized over 18,000 courts, conducting 2 million virtual hearings during the pandemic time. In Kenya, the mobile courts use satellite technology to reach remote areas, similar to how India's JAM Trinity, that is Jandan accounts, Aadhaar and mobile, has brought financial inclusion to millions. The Legal Aid Society in New York uses AI to produce thousands of cases efficiently, while India's SUPE system assists the Supreme Court in case listing and legal research. Online dispute resolution thrives globally, from Singapore's community mediation to India's Lok Adalats resolving over 100 crore cases. Yet, we must acknowledge technology's shadows. The Compass risk assessment tool in American courts exhibit racial bias, while India's Aadhaar system, despite its revolutionary impact, sparked privacy disputes leading to the landmark Puttaswamy judgment. Amazon had to scrap its AI recruiting tool for gender discrimination. In the 2021 Pegasus revelations show how surveillance technology can threaten democratic foundations worldwide. The digital divide affects all societies. COVID-19 virtual proceedings excluded many without adequate technology, whether in rural America or India's villages, where other biometric failures deny legitimate beneficiary welfare benefits. The balanced path forward requires what I call deliberate innovation, embarrassing technology's potential while building robust safeguards against its risks. Climate justice, on the other hand, creates universal justice challenges with local manifestations. The Dutch court orders for Shell to cut emissions by 45% parallels to India's National Green Tribunal addressing pollution from Delhi smog to industrial river contamination. While Torres Strait Islanders fight rising seas in Australia, Indian farmers face climate distress, 270,000 suicides over 2 decades linked to changing rainfall patterns. Hurricane Katrina's disappropriate impact on minority community mirrors how Kerala's 2018 floods and cyclone Amphan devastated marginalized population. Environmental injustice is global. Wealthy areas have air purifiers where Delhi street vendors breathe toxic air, just as affluent neighborhoods worldwide escape climate impacts that hit the vulnerable hardest. Legal innovation responds differently across cultures. Colombia and New Zealand granted rivers legal personhood, while India's Uttarakhand High Court similarly recognized the Ganges and the Yamuna, showing how diverse legal traditions can address environmental rights. The Supreme Court intervention in Bahurelal versus Union of India mandating CNG conversion demonstrates judicial environmental activism. This isn't about choosing between economic development and environment protection. It's about creating legal structures that ensure both are persuaded justly. Traditional policy making proves too slow globally. The European Union's GDPR influenced worldwide data protection standards in just 4 years, while India's delayed personal data protection bill shows the complexity of balancing innovation with privacy. Singapore's fintech regulatory sandbox enables controlled innovation similar to India's approach with UPI, now processing over 7 billion transactions monthly. Cross-border challenges required coordinated responses. The 2017 WannaCry ransomware attack hit UK hospitals, German railways, and systems across dozens of countries. Similarly, India's 2016 debit card breach, affecting 3.2 million users, show how cybercrime transcends boundaries. We need new models of governance that can respond dynamically to the emerging challenges while maintaining democratic accountability. Consider how we might create regulatory sandboxes for legal innovation, allowing controlled experimentation with new approaches to dispute resolution. Technology must augment, not replace, human judgment. IBM's Watson helps JP Morgan Chase lawyers analyze documents faster, freeing them from strategic work, while Indian courts use AI for research while preserving judicial wisdom. But China's social credit system warns how algorithms without human oversight can become oppressive. The most sophisticated algorithm cannot replace Justice Sim Lake's innovative sentencing of young hackers to community service, or Justice V.R. Krishnayar's empathetic jurisprudence prioritizing the marginalized. When D.Y. Chandrachud ensures quality internet for virtual death penalty hearings, he shows how human dignity must guide technological adoption. Traditional wisdom remains relevant. From Rwanda's Gakaka courts blending community justice with formal process to Indian Lok Adalats and Gram Nyayalai, integrating traditional dispute resolution with modern courts. This calls for reimagining justice, what I call balanced leadership. Leaders who can hold multiple truths simultaneously. We need technologists who understand legal principles, lawyers who appreciate environmental science, and policymakers who grasp both innovation's potential and its limitations. We need technologists like MIT's Cynthia Breslin, designing ethical AI, and lawyers like Brian Stevenson, using data to expose inequalities. India's experience integrating court technology while preserving independence, balancing development with environmental protection offers valuable lessons. Consider how Right to Education Act used both constitutional mandate and technological tools like school mapping, or how Forest Right Act balanced conservation with tribal rights, showing that justice required holding multiple perspectives simultaneously. We need institutions that are simultaneously stable enough to provide predictability and flexible enough to adapt. We need processes that are both efficient and fair, both innovative and grounded in timeless principle of justice. So to conclude, the future emerges through daily innovations shaped by deliberate innovation and balanced leadership. A Miami court judge using VR for jury understanding, a Mumbai family court reuniting families via video conferences, indigenous water protectors documenting pipeline construction with drones, Chennai climate change lawyers winning compensation for fishing communities, India's transformation from bullock cart to Chandrayaan, license Raj to startup ecosystem proves dramatic change can preserve core values while embracing necessary innovations. The crossroads we face is not a destination, but a continuous journey. Our task is not to predict the future of justice, but to actively create it, thoughtfully, inclusively, with unwavering commitment to the principles that make justice not just effective, but truly just. The question isn't whether we can reimagine justice. The question is whether we will do so through deliberate innovation and balanced leadership, serving not just today's needs, but generations to come. Thank you so much for your opportunity, and it was a pleasure addressing all of you. Thank you.
Thank you so much, sir, for illuminating such exposition of where deep scholarship meets the practical wisdom, and your reflections on human right and such environmental laws and legal pedagogy sets a foundation of our conversation. And our next speaker embodies a rare confluence of field experience and academic excellence, a leader in law enforcement, a scholar per excellence, a global voice on crime prevention and rehabilitation. It is my honor to introduce Dr. Ajay Kumar, serves as an inspector within Delhi Police responsible for court, jail affairs and concerning under trial prisoners and detainees across Delhi. Beyond policing, he had held senior academic roles and served on the National Commission addressing women's rights, child protection, and his international engagement includes presentations at the UN and invited expert roles with UNODC at Global Congress on Crime Prevention. Sir embodies a practical jurisprudence where law intent coexists with humane administration. We are honored to hear from you, sir.
Thank you, ma'am. My heartfelt thanks and gratitude to Srishti Agarwal and her organizing team for providing me this wonderful opportunity to speak at this international conference. Respected guest of honors, it is always a pleasure to be part of great learning experience like this and listen to great scholars like Davesa, uh, Nitesh, and other scholars. I am from police and I am looking after at present the legal and vigilance matters related to under trial prisoners, convicts, and detainees across jails in Delhi. And I'm not that techno savvy, and for me, this topic seems to be too complex, but I would like to bring forth my own experience in terms of reimagining justice from that perspective. Firstly, I would like to highlight a practice that is very much prevalent across courts in India, and it touches upon the policy, technology, and sustainability, which is the core theme of this international conference. The Indian judiciary's independence or dependence on paper documentation constitute one of its most significant ecological impacts. Despite what we see that now it has become paperless in Supreme Court in High Courts, but a report by E-Committee of Supreme Court in 2023 found that Indian courts use an estimated 12 billion sheets of paper in a year. To put this in a perspective, that is roughly equivalent to 1.3 million trees cut down every year just to keep the judiciary's paper needs satisfied. The Supreme Court alone generates an estimated 70,000 pages of documents daily, considering both filing and internal paperwork. It is more worrying in lower courts where the adoption of digital was relatively late. Please mind that it's not the Supreme Court or the High Court that dictates what is being implemented out of a policy. It is a district lower judiciary which determines or set the tone for these kind of implementation of policies and failure thereof. A report by Ministry of Law and Justice says that district courts in India use anywhere from 1,000 to 3,000 sheets of paper per case depending on the complexity and length of litigation. With more than 3.5 crore cases pending in courts of various levels, paper consumption reaches the staggering proportions. So we need to have initiatives such as e-filing and digital courts proceedings accelerated in wake of COVID-19 pandemic, notwithstanding paper usage remains at high levels. The National Judicial Data Grid reports that only about 15% of courts proceedings currently operate in a completely paperless manner. Now coming back to the job that I actually do. The BNSS came into force in 2024 and recognized electronic evidence in video conferencing, and the same was emulated by Honorable High Court of Delhi Wide Electronic Evidence in Video Conferencing Rules 2025. We produce on an average of 2,000 under trial prisoners in various courts across Delhi, and quantifying the same in terms of what we do in a year, it amounts to approximately 4 to 5 lakhs under trial prisoners annually. Now, looking at dividing this figure, we realize that 50 to 60% of these UTPs are the one who are produced in the courts just for rehnumai or extension of judicial custody, and these are the UTPs that are not required to be brought to the courts, and extension of JCs can be managed by virtual conference only. Transporting these UTPs to courts have its own challenges, not only in terms of logistics, but also poses grave security issues. What was projected as a boon in COVID times to conduct judicial proceedings through VC has all of a sudden got so many challenges, aggravated by lack of willingness on part of judges, lawyers, and not to speak about the UTPs. We held meetings with judiciary, we held meeting with jail authorities 2024 onwards, and it was brought to our notice that what was envisaged in BNSS to create an infrastructure, to have an infrastructure ready for production of UTPs through VC, this infrastructure does not exist, and we don't seem to be reaching that stage in near future either, where we can produce these UTPs through video conferencing. To conclude, I feel that the laws being legislated lacks the practical issues affecting the most relevant stakeholders. There is urgent need of synergy of technology into practice, but on ground level, we, despite being the IT supergiant, seem to be still struggling to put the same into practice in soul and spirit. Thank you.
Thank you, sir, for your compelling address, a narrative where justice is not distant doctrine but lived reality, and your insight brings to a life delicate balance between the law, compassion, and reform. Thank you. In the art of teaching, few have sculpted an enduring legacy, and to who had taught justice as a lived experience. A respected speaker, Professor Richard Elroy, is an iconic figure in the clinical legal education, celebrated globally for his leadership of street law program at Georgetown University Law Center for decades. He pioneered interactive methodologies that bring law to life and teaching practical laws in high schools to the engaging learners and in correctional settings and community environments worldwide. His work transcends traditional pedagogy and model of law as an empowering force for civic literacy, due process, and democratic values. Sir's innovative contributions have shaped that how law is taught, understood, and experienced across continents. Thank you so much for being there, sir, and we are excited to hear from you.
Thank you very much for that very kind introduction. I'm very honored and happy to be here uh, in this presentation and to talk to you tonight, this morning, for you. Uh, um, yes, I have become a practitioner and something of a strong proponent of learner-centered teaching, where we have a saying, talk less, teach more, where we shift the learning the talking and the thinking from the teacher to the learners. However, in the context of right now, I'm asked to give a presentation, a speech, and my intention was to work on reimagining justice, and uh, uh, the fundamental theme of the conference, examining, among other things, climate change and sustainability, uh, issues that face us globally and locally at the same time. Um, my idea was to talk a little bit about learner-centered teaching in an area that I've written about extensively and thought about extensively, and that's risk management and sustainability. Um, uh, and at some future time, I'll be glad to do that. But uh, the other idea that accompanying that was to present to you ideas about applying laws in the context of fundamental principles, and what are fundamental principles, and how do we create laws that operate for ourselves and our posterity. And an example of in the context of fundamental principles is the American Declaration of Independence and its role in the United States Constitution. As you probably know, that the Declaration of Independence preceded the Constitution by 10 years or more. And the Constitution essentially is in some ways a document that tries to put a framework of government into fundamental ideas of justice. And there's, in the process of that, there's some interesting phenomena that the American Declaration of Independence is considered to have aspirational principles that underlie the U.S. Constitution, but are not fully specified in the Constitution itself. A prime example of this is the language in the Declaration of Independence that all men are created equal. Well, it turns out that after the writing of the Constitution in 1787, it took roughly a century before slavery in the United States was outlawed and for women to be allowed to vote. So the idea, it took a fair amount of time and a lot of work and recognition to how do we take these fundamental principles of climate change and the need to preserve our world and make it real. I think in that context, it's worth looking at the preamble to the United States Constitution, which says, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do establish this Constitution." But it took a while and it's still taking a while for these principles to be enacted. But uh, uh, in thinking about exactly what to do or say right now, events of last night changed the focus of my talk. And I'm going to summarize what a reporter named Mary Gedry wrote. And she essentially said, what happened last night in the United States was that without congressional debate, without warning to allies, and without addressing the American public, the US president announced in the middle of the night that the United States had launched a large-scale military strike inside Venezuela and seized its president, claiming Nicolas Maduro and his wife had been captured and flown out of the country. What followed was confusion, panic, and a growing realization that whatever this operation is being called, it is likely to have crossed a constitutional line. The United States forces reportedly struck multiple military and infrastructure targets across Venezuela, including air bases, ports, communications sites. Venezuelan officials say that there were casualties, and the full toll is not known. Uh, the justification for this has been that Maduro faces charges including narco-terrorism, conspiracy, cocaine importation, conspiracy, and weapons offenses involving machine guns and destructive devices. The question is, what principles are involved? What gives a president the authority, or one nation, the authority to launch unilateral military operations inside another sovereign nation, and in this case without congressional approval? The Constitution of the U.S. vests the power to declare war in Congress, and the War Powers Act, which is a piece of legislation passed around the time of the Vietnam War, permits unilateral action only in narrow circumstances, and these are immediate self-defense, rescue operations, or a response to an attack on U.S. forces. Did any of these conditions appear here? Is a major question. The principle does not change simply because the United States is the one who is enforcing it. So I wanted to raise this and say that this presents a challenge to talk about how fundamental principles of justice that apply to the United States, and one which the United States would resist and resent if it had been the recipient of this. How do we deal with this? How is the nation going to respond in a legal way to say that the same laws should apply to anyone? Would the U.S. permit such an intrusion by another nation? And I would put forth the proposition and work towards this idea with learners. How do we arrive for them to examine, can we enforce the law by breaking the law? What are the universal principles of justice and reciprocal understanding that everybody is governed by the same law? I think these are major questions that need to be addressed, and they have also great applicability in the issue of environmental sustainability. I think of the American Constitution saying it's not just the law is for ourselves and our posterity. It's for, we are custodians of the world, not just reapers of its benefits. So I want to thank you for the opportunity to make these comments. I would love to do some activities at some future time around teaching these things in an interactive way. And I look forward to seeing the other presentations and some of the papers today. Thank you very much.
Thank you so much, sir, for your profound and heartening address. And your address is a true testament to show that how justice education deepens not only legal understanding but human dignity as well. Moving ahead, justice today transcends borders, discipline, and traditional construct. When law engages with economics, taxation, and global governance, the result is richer, more equitable, and legal architecture. It is my pleasure to introduce Dr. Victor Machehin, serves as a professor at Kutafin, Moscow State Law University, one of Europe's eminent law institutions with advanced degree in law and economics and decades of leadership in academics and professional tax practice. Dr. Victor McCann's work spans international taxation, legal consultancy, and global research. His insights guide us to appreciate how economic jurisprudence intervenes in sustainability and equitable governance. We'd be delighted to hear from you, sir.
Well, many thanks for this introduction. It's a real honor to be at this wonderful international conference and see people from different continents dealing with different areas of law, management, and education. And I would say that, well, a lot of things are already discussed by guest speakers. So we are already in the middle of our conference, and really it looks like we face a lot of different challenges. If we look at topics of conference, we see many different things, and it's evidence that we are dealing with many things, many new things, and we are really at a crossroads, not just law, policy, technology, sustainability. Well, everything looks like in a change right now. Education as well. But what I would like to say that if you look at the past, at least I think our generation, we may see that it is not something absolutely new for us. And I remember my first jobs when I worked for the ministry, being just a young economist first, then a lawyer. Well, at that time there was no any computer in an office, no mobile, nothing, and somehow we lived, somehow we practiced law, somehow we participated in education. And what happened then? Then we received internet, we received computers first, well, faxes, very simple electronic communication. Then we moved to usage of internet. And I think that that time was the great step done in respect of technology shift. And it looked like, well, we did not pay much attention to that. So there were no the detailed discussions like we have today, but somehow we did that step. And I think that to deal with today's problems and challenges, we really have to look in the past, in particular, looking at the last 20 years of experience of living with new technologies. From practical perspective and professional perspective, when I'm looking at what I did 30 years ago when I worked for the revenue, I just recently realized some new things for me, because I was just a young lawyer helping my fiscal colleagues to audit large taxpayers, including international taxpayers. And that time I just could not see that in reality companies which we controlled already used digital things when we as authorities didn't have any digital things. So there was some sort of time gap. Business always use technologies much faster, and authorities are coming later. And in my area, in taxation and international taxation, the gap was around 15 years. In 15 years, authorities became in line with taxpayers, with companies, with international companies. They used the same methods, the same electronic programs, the same hardware and software, and new game started. And now we live in a transparency. Years in transparent time, because all parties are on the same level of technology. And this starts new area for lawyers and for law and for policy as well. In the past, business received a lot. Received a lot in respect of money perspective, in respect of profit. Nowadays, well, the game is more transparent because everyone can get knowledge, experience, and this is something new. We have more transactions, we have more intensive business, we have more knowledge, our students have more access to international experience, and it was something I have not seen when I was a student in my law university. So it is more intensive life, and we have more challenges from this perspective. We have more questions, and we have to address them without much time. And this is, I think, it is a real challenge, maybe the top challenge for all of us. In my country now, we have like 5 or 6 federal laws every year. So it is huge amount of information. How people can do with this? Probably AI will help us, but today it's not clear how it will be done. So there are some issues like general, let's say, new step in technology. Probably it's not dramatically new, but the fact that life is more intensive right now, it is really new. And I see that my pals who are still doing legal business, they have more intensive life every day. When I worked for the big international legal firm, well, we made big due diligence exercises, analyzing sometimes each transaction done by a company. Now it's impossible. Our clients say, okay, we need your report much more quickly. Just concentrate on real issues. Please ignore minor things. And we have to run much more quicker. So more intensive legal lifestyle, I think it is one of new things in our agenda. Things like AI, well, it is just a tool. Probably we will deal with this as we did with internet, and we did it mostly easily. So looking at the topics of today's conference, I think that all of us will get new knowledge, whether topics are presented by professors or students, or collectively by professors and students. So thank you for your attention. That's all from my side.
Thank you so much, sir, for your deep insights into the intricate tapestry of international law, tax policy, and justice, especially. And your address reflects that how knowledge becomes a power when wielded for fairness and inclusion. And moving ahead, our journey now turns to the voices shaping the future horizons of legal thought, voices that resonates globally, yet remains rooted in scholarly depth and transformative engagement. Please welcome Dr. Nitish Kumar Upadhyay, sir. Sir is an associate professor of law at Dhirubhai Ambani University. Is an international research footprint encompasses the human rights, cyber law, and technology law, international humanitarian law. As a research advisor and a visiting faculty across the prestigious global institutions, Sir's publication and lecture enriches the contemporary legal discourse with the depth of visionary inquiry. We welcome you for your warm address, sir.
So, good morning, good afternoon, good evening at different places. I warm welcome to all of you here, and my regards to all my teachers, my seniors, whom I have worked in past. I was not very much interested to join today's event because there was a cricket match going on in my society, and I was one of the player there. So I thought, okay, I will not join. But once I got to know that Dave sir, Richard Rowe, Victor sir, and Windy ma'am are coming, I was like, okay, I'll come for a small brief. But finally, it happened that we lost the match and the game got over early. So I'm here. So today I will be discussing about something which is almost in the Vessel's talk also, he was mentioning about how Compass and all other AI are being used, how around the globe we are using artificial intelligence and sustainability and everything that you talk in terms the last three speakers have discussed. I will be discussing something very simple. At one place, if you see in India in last 1.5 months, we have our digital data protection privacy law rules are there. We also came across something which is non-consensual intimate imaginary guidelines, which says that if there is any intimate image of any men and women online, then it should be removed within 24 hours. Then we have our AI guidelines in India. We have AI bill in India. We have AI in healthcare guidelines. So there is a lot of development at one place where the laws are coming up, policies are being drafted. But there is a problem. Problem where, if you say the very easy problem, I'll tell you about this. There is a hospital in Rajkot in Gujarat where there was a CCTV footage of maternity ward. Around some 50,000 footages have landed up in porn sites and also on different Telegram and WhatsApp groups. So they were made for sale, whereas the Indian law says that whenever there is a physical inspection at a maternity ward and other places, there should not be any CCTV. But still, where is the problem? The problem lies at one place. We are making laws. We are also trying to implement. We are trying to create regulatory bodies. And on the other side, the normal people do not have any, knowledge and understanding of nuances of these laws. Why these CCTV footage got captured by a hacker or a person who hacked and sailed it on a different platforms is because the password was very simple. Admin@123. The easiest mistake you can do is to keep, so simple password. So at one point of time, we are talking in terms of artificial intelligence, data privacy, fiduciary responsibility. And on other side, people who are day in and out have to manage these data are having no clue what they're doing. So understand a hospital keeping a very basic password, admin@123. All data that is there in the system will be stolen by people. Even you need not to do a brute force attack. You can just try some permutation combination, maybe 4, 5, and 10, and this will work. You do not even require a keystroke login according to cyber laws. It's very simple. So who has a responsibility? So the responsibility is not always on the government, the policymakers. The responsibility is also on our law teachers and student community. That's where, if you see, I integrate the topic. The last sub-theme, which is clinical legal education, remains something of more important than any other. Because if you are delivering CLE properly in your clinics, in your classrooms, then data will be protected. AI related norms, regulations, rules will be known to people and everybody who is using it. People will also come to know about the threats of them. Grook, nowadays, there is an app which can actually remove clothes of people. What are the regulations regarding it? If we are as a clinical legal education, educators, teachers, and students go and talk to different people, we can tell them about what is the problem with the act that they are going to do or they are doing. Also, when you talk in terms of sustainability, so at one place, I'll give you a very simple anecdote. I was there in a conference on Sustainable Development Goals, SDGs, and the major impetus on that day was on environment protection, and also on child education. And the person who came to serve tea to me was a child of 14 years. Understand, an international conference, having a kid who is 14, 15, 16 years maximum is serving tea to me. Having all, you know, every guest is having a plastic bottles. So what happens that we do talk in sense in terms of law and policy, but when it's about to implement, we fail at all things. So we fail as faculties, we fail as students, we fail as law enforcement agency, we fail as judiciary at times, and common people just do not talk much about them because they can take any time, which is not no doubt not an alibi that okay, I was not knowing the law. Ignorance of law is no excuse, but most of the time they have no clue what they're doing. So around in terms of when you're talking in terms of clinical legal education, I think we should have certain programs where students are going to different places and talking to all the people about sustainability, about let's take data privacy and all other things. No doubt when you talk in terms of data privacy laws, in India it is basically civil offense only. There are only 5 countries in the world which have criminal provisions for data privacy in their data privacy laws. No doubt in India, if you say, do we have any criminal provision for data privacy violation? We do have in IT Act 66 section. We have it. But we do not have any criminal provision in DPDP, our data protection laws. If you talk in terms of GDPR, it's almost similar. They also do not have any criminal penalty. PDPA, which is Saudi Arabian law on personal data protection law, they have up to 2 months of imprisonment. CPPA, HILLA of United States have, but they are again not data privacy laws. They are a sectorial laws for health promotion and all other things. Switzerland data privacy laws has criminal offenses there. So also we need to understand and we need to make everybody understand that okay, if you're talking in terms of data privacy, if you're talking in terms of artificial intelligence, there may not be a specific law which governs and you can teach and train everybody about that, but they can squarely also protection lies in your domestic laws, other laws which are more general in nature, not very specific. Let's take Bharatiya Nyaya Sanhita in India or Information Technology Act or something similar. So after going through all, once I was there in class and I was discussing all this, one of my students asked, let's imagine, sir, what will happen? Our law says it's extraterritorial. GDPR in Europe also says data violations, if you are doing any person who stays in Europe and if you're violating their data, GDPR can have extraterritorial implication. And he asked me, what will happen if, let's take, imagine a person sitting in, let's take, country X, violates data privacy. So I was like, okay, let's discuss on it. What all you think could happen since the person is not here? No doubt we can take help of red corner notice, blue corner notice, lookout corner notice if the person is still in India. But what's beyond? Is there an international law regarding it? There is only one international law when you talk in terms of AI and cyber. That too has not received a number of ratifications and is still not in force regarding cyber law. By the time this will received the requisite number of ratifications, the world must have moved so far from this that this act will have no, kind of importance. So, in totality, what I want to make a point here is that's just our duty as teachers, as clinical law professors, and students, that we talk about all these issues that are discussed, the sub themes that are there, and also somehow we should incorporate them in our courses. If you say that a legal aid clinic will be there and will be able to do everything, then I think that's not the right approach. Maybe every subject can have a clinical component into it, which can be marked. And at least in India, students take marks very seriously. So let's take if there is a IP, intellectual property rights, why not our kids go to different engineering colleges, because engineering college not necessarily have always law schools there, and train them about patent, copyright, trademarks, and all those things. If it's, let's take about human rights, why don't they go to NGOs and talk to them about, let's take sustainability, gender, and other issues. If we're about cyber, why not go to schools to make, you know, students aware about cyber crimes and artificial intelligence and things. So we need to have a deliberation on this, that which all subjects we can incorporate certain activity which will impact all the other substance of the conference, and what kind of activity. So maybe in human rights, IHL, refugee law, more activities are possible. Whereas when you talk in terms of company law, people may say that there are less number of activities which is possible in this. But why not go and talk to companies, small companies about, labor welfare laws, sexual harassment at workplace, and so on and so forth. So we need to work on this dimension of clinical legal education, and if that we are able to provide properly to students and faculties and train the other people around, the other stakeholders, I think we will be able to protect sustainability, data privacy, AI usage, and all those issues will not be there. With this, thank you very much. And again, thanks to all my teachers and my seniors for the kind words.
Thank you so much, sir, for your insightful, forward looking address, and your commitment to global scholarship reminds us that justice is just much about integrity and it is about innovation, of course. And moving ahead, justice is most powerful where it meets the community and the conscience. Our next speaker is a global champion of the access to justice, legal ethics, and community legal education, whose work has touched thousands across Asia and beyond. It is my honor to introduce Ms. Wendy Morris, co-founder and co-director of Bridges Across Borders Southeast Asia Community Legal Education. Ma'am has dedicated her career to developing communities legal education programs across Southeast Asia, Australia, Europe, and beyond. With over 18 years of public service as Justice of the Peace, Ma'am transitioned into legal education, strengthening clinical legal education pro bono initiatives across nation. She actively serves on international committees advancing justice education, enriching legal practice with community engagement with ethical responsibility. We would like to hear from you, ma'am.
Thank you so much. And hi, everybody. So many wonderful friends and faces. It's just fantastic. And thank you. Today is a little challenging for me as we go through this. My husband, who many of you know, Bruce Lusky, is going in for surgery. He's okay. He's getting his spine done. And it's a little emotional. But with that said, I just wanted to start with something quite simple and but I think quite fundamental. And in my experience, justice and human rights, they just can't be separated. Justice for me is really is what makes these rights real, or if they fail to, perhaps. And the human rights is what gives justice that meaning, that dignity, fairness, participation, respect, these kinds of very emotive, ethical words that come up. But over the years, I've also come to believe that justice is not only about the present, but it's deeply, deeply about the future. And more I find myself thinking about terms like these NGO terms, I call them the intergenerational rights, these kind of words. But whether we're asking about systems that we're building today, I think we genuinely need to protect the rights of those who will inherit this tomorrow. And that's what a lot of you have been talking about here. And it really resonates with me. But if I can, in true interactive methodology, as you all know that I just love, I'm going to pose a question in the chat, if you don't mind. Hopefully it'll work. Okay. And this chat, okay, you can add more, but just yes, no, or not sure would be wonderful if you can see that. So the question is about the world, how the world today and how much this is shifting and how we're all being pulled along in all these different areas that we've all seen, and how we don't necessarily have a framework. And so I tried to think about, where are we going with this? And I keep coming back to that, like, what is it? 77 years ago, this Universal Declaration of Human Rights was put in place, yeah? And I don't know if it's still relevant. I don't know if we need to rejig it. I don't know if we need to have think tanks that start back there, because so much of all of this awareness and all of these things that we have all done together, including these great clinical legal education programs and the legal sector, is connected to this. So I'm sort of still pondering, is it still relevant? I think it's relevant, but perhaps maybe we need to, tweak it a little bit. I don't know if tweak's a real word, by the way. But with that, in our work at Babsicle, it really is about listening to the community. We have the privilege of working with law students, all over the globe, and engaging with justice institutions. And I've seen how the choices that people make, how law students, and then they grow into, teachers and strong advocates and judges and others, that this very beginning and listening to that community really shapes what their decisions go and how that kind of moves along. And so I just wanted to share one of the examples that we do in Laos. Now, Laos is a very tiny little country, very pivotal part of the world, but it's got villages everywhere. It's very hard to get to. And then you have, all the challenges that go with a country like Laos. So one of the things that we did, mindful of listening to the community, and that as a law student, if you listen to what that community says and you're engaged with it, and you also are in a position where you follow that through all the way to the ministry level, who then makes policies, as a law student who followed that through that system, that imprints on you. It imprints very solidly, and how you use technology today in order to do that. So one of the things that we have the great privilege in supporting the Lao government and the law students to do is it's an access to justice or access to legal services survey. So the students, the teachers, the legal aid officers, the ministry, government all come together. I'll just try to do this kind of quickly. And they go into different community villages in different districts, where the students ask the villagers a series of questions in this questionnaire. They can, they use their phones to put I don't know if my phone's here, my phone, to put the data in. So they've got IT, they're able to use their IT if they want. They can do on paper, all these kinds of things. But what they're doing is they're asking questions about, do you know where would you go if you had a problem with a legal problem? What stops you from going? If you had a problem, would you ask? Those kinds of things. And each village is slightly different. Each village has a different leader community people that are there. So it kind of shifts and changes as they go through. Once those students have collected all that data from going around, and it's not an easy job to do that, and they're living rough, dare I say, as opposed to law students in Vientiane, apologies to those who don't live quite as rough as what they do when they go into the villages. They then gather this with their teachers and the district legal aid officers, and then they go through all the data and they put together the findings. What are the findings? The law students are involved at that level as well. Then those findings are then presented to the government, and it's mapped up against whatever the government mandate is. What are they trying to achieve? The law students see that. They see it all the way through. And then they see the change, the policy change, the different things that government will then put in place going down. So they may put in place that they want the legal aid officers to do more awareness of this particular area, of this particular, but they get to see how it works and then how it doesn't work, or where those gaps are, or how people in the village don't know how to communicate on this. They don't know where to find these things. And it is really through listening in all of this that I kind of drew on this. How do they, what's really going? It's not just that theory, but it's real life, and it's real justice reform by listening and not top down. And it's really that listening that will, sorry, it's really that list. Sorry, people have just come in to check on my husband. So sorry, there's a lot of people just walked in. But it's that kind of law reform that really comes from listening to the community, and then having not just the government making policy, but other people listening to what they're also doing. So with all of that said, I have a whole lot that I could go on more and more with this, but I think the biggest problem that we're all talking about here is how we don't have a say. How do we get that say? How do we move this into digital justice systems where there is good governance, where there is people that are in those positions who are listening to the community, who are aware that whatever we are following, whether it's AI or whether it's whatever it's, fake news or whatever that is doing, does that mean for the future? What is actually really going on there? And where can we, in our legal education programs, really come in to stop this, or at least, make those students fully aware of the decision that they're making out there? Okay, so now I'm completely distracted with people in the room, so I do apologize. It's lovely that they're all here. With that, I'd just like to probably finish up. Thank you all for allowing me to pose that one question. I hope you keep reflecting if it should be or shouldn't be. 77 years ago, it was a very different time to now. And the core of it, I still believe, is very, very strong, but maybe there's some tweaking that may be needed. So thank you so much.
Thank you, Wendy, and prayers with Bruce, and hopefully everything will be fine.
If anybody knows Bruce, he's very, very strong. So I'm 100% sure he'll be all very fine. So yeah, thank you. I'll pass on your good wishes.
Thank you so much, ma'am, for your deeply moving and empowering address. And your work exemplifies that how justice is not only interpreted in courtrooms but lived in communities. Moving ahead, distinguished guest, we have now reached to the concluding part of our inaugural session. To extend our heartfelt gratitude to all the speakers, partners, and participants, it is my privilege to invite Dr. Ankita Upadhyay, ma'am. Ma'am is a partner at Knowledge Trees Edu Hub, board member of Vedseadus Legal. She has driven a campaign promoting gender equality, organ donation awareness, and delivered lectures on law and management across the global platforms. Her scholarship extends to publication in Scopus Index journals, reflecting a deep commitment to fostering student growth and mentorship. Over to you, ma'am.
Thank you very much, Sainoor. Today you've kept the introduction short. I'm happy because people present over here in the inaugural are much more experienced, and I really look forward to all of them. Hello to Wendy. My wishes and good wishes for Bruce. First off, I would like to speak about the host over here, Srishti Agarwal, and congratulate her for the conference and for the organization that she has created. Srishti has literally been, it's like she has grown in front of us. And her organization and her initiative is a noble one. And since last year to this year, we can see that Vedseadus has improved quite a lot and has made some mark at least by now. And the best part about Srishti and her organization, which she is going to make big, and I am sure she will do this tirelessly, is that they stand up to their name, which they have kept, which has an Indian meaning. And I also want to especially point out one thing, which is that Srishti, in her organization, the founding member or the founder at Vedseadus Legal is her father. And she has kept him over there and everywhere on documents and otherwise also. I think he's not present over here today, but she tries that he should be present anyhow. So that was about Vedseadus. I would really like to thank everybody present over here and who have given their great insights on governance and policy making. Rhishikesh Dave sir, Adir Dave sir has again spoken today and given his practical insights, literally with international cases worldwide, and spoken about policy making. Dave sir, I would just like to say thank you to you over here, not for this thing, not just for this thing, but also for working so hard towards every university the Visser goes to in terms of every respect. And after that, it definitely prospers for the next decade. Thank you very much, sir. Ajay sir, I don't know if he's listening or not. Ajay sir, one must definitely admire his honesty. If you don't know, then I will tell you that Ajay sir has represented the police department on various platforms and continues to do so wherever he gets a chance to. So thank you, Ajay sir, for doing that. Victor sir, I'm sorry, going in the line, Professor Richard Rowe, again, our dear Professor Richard Rowe, who has somehow become close to us through Gage as well as through other events. Thank you so much for connecting the policy making and changes required through ethics and the importance of legal aid in the same. Victor sir, over here has again now become a part of many of our events. And it's really nice to see him working hard over international relations to change and bring about a significant event and have workplaces change the importance and the various policy making decisions. So, and he works tirelessly. His energy is remarkable. Moscow University is indeed quite good in making endless relations, and he works pretty hard for them. Dr. Nitish, for his suggestions, as usual, great suggestions for improving policy at an individual level and giving those suggestions which always thinking out of the box and giving those suggestions which after thinking to people think we could have done, but we didn't do up to now. Thank you very much, Dr. Nitish, for all of that. Wendy, I think it is great of you to wait over here up to so long when you are in a family situation, and especially when Bruce is undergoing the surgery. Tirelessly working for an organization for years altogether is not something very easy. And also not just working, but contributing equally and maybe sometimes more with the founder is something that needs to be, I guess we should clap, everybody should clap for that matter for Babesicle. And she connected again the importance of it with legal aid, and her energy at this level, also at this age, is remarkable. Always morning to night, you can make Wendy work, and Wendy will work um, with some leadership skills. So thank you very much, all of you. It has indeed been a pleasure for me to attend this inaugural, and I wish all the participants and the presenters all the very best today. And again, I wish more luck to our Srishti. I would also just like to say that Srishti's organization is going to have a link uh, in the footer of our website, which is Knowledge Teas. So she's going to get linked to us over there also now. Those of you who want to join her organization can message on the group that you people must be in, the presenter group. Thank you very much, all of you. I really request everybody who is over here to switch on their videos so that they can have a photo, and we can proceed.
I request
Good morning,
everyone to
ma'am.
please switch on your videos. Okay, ma'am, I'll be taking the screenshot and I'll be taking the.
I think.
Okay. I have taken that. Thank you so much, everyone. Thank you so much, ma'am, for being here. Thank you so much, everyone who have been here today. Thank you so much, Wendy, ma'am. My best wishes to Bruce sir, and I am very grateful that you are here today despite all of the happenings. So thank you so much. Thank you so much, everyone. Thank you, Stavi sir. Thank you, Victor sir. Thank you, Richard sir. Thank you so much. Thank you, Ajay sir. Thank you, Ankita ma'am, and thank you, Nitish sir. Thank you so much, everyone who has been here today. Over to you, Sainoor.
Thank you so much, everyone, and thank you to Dr. Ankita Upadhyay, ma'am, and a profound thank you to every speaker, participant who had made this session exceptionally insightful and inspiring. Today's inauguration has not merely opened a confidence, but it has opened a conversation of conscience, dialogue, and ideas, and a vision of justice that embraces innovation, inclusivity, and impact. May these insights guide us that we continue to explore, engage, and elevate justice in the space it touches. And thank you once again. And here's wishing a transformative and thought provoking conference ahead.
All the participants for the first session, we will be starting the session in just 2 minutes. I request all the participants for the first session to be here.
Ritika and Gaurav.
Yes, sir. Yes, sir.
We will be starting with the presentations in just 5 minutes until our guest, our resource person joins in. So, everyone of the first session, please be ready with all of your presentations with your research. So, we'll be starting in just 5 minutes. Ritika? Good morning, sir.
I'm so sorry for being late. My apology to everyone.
Ritika, you may start now. You may start, Ritika.
Very good morning to all the respected resource persons and participants on behalf of Vedseadus Legal in collaboration with Management in Science University, Russia. I am Ritika Kaushal, a core member at Vedseadus Legal and will be moderating today's session with coordinator support Gaurav. And I am delighted to welcome you all to the second international virtual conference on reimagining justice, law at the crossroads of policy, technology, and sustainability. This conference aims to foster meaningful dialogue on how law continues to evolve in response to policy innovation, technological advancement, and sustainable developments. We shall now begin our session 1. It is my privilege to introduce our esteemed resource persons for this session. Dr. Sulakshna Banerjee Mukherjee is an associate professor at the School of Law, Sushant University, Gurugram. She is a distinguished academician with significant contribution to legal research and scholarship. With publication in Scopus and UGC Care listed journals, and has been recognized with several prestigious awards, including the National Teachers Award and Women Leadership Award. We are honored to have her with us today. Our second resource person is Dr. Anindya Tiwari, Assistant Professor of Law at Hidayatullah National Law University, Raipur, head of the Center for Domestic International Tax Laws. He holds a PhD in International Taxation from NLU Jodhpur, specializes in corporate, business, and international taxes, and is part of the organizing committee in 2025 ALSA Law and Technology Conference in Sydney. We're honored to have you with us today. We are really glad to have you both.
Thank you, Ritika. Thank you so much. Before we begin, I again want to apologize for being late. It's so embarrassing to do this. I'm so sorry to everyone.
No worries, sir. It is fine.
Thank you, Ritika. And good morning, sir. And good morning, Srishti and the entire team. At the outset, a Happy New Year. And today we are going to watch and observe the insightful session. So let's start.
Happy New Year, ma'am. Happy New Year, sir.
Now I would like to briefly outline the guidelines for the presentation and will request all the participants to listen very carefully. Each presenter is requested to strictly adhere to the time limit 8 to 10 minutes. A question and feedback round will follow after each presentation. Participants are requested to maintain decorum and ensure smooth conduct of the session. I say all the best to all the presenters out here. I now invite our first presenter, Dr. Shu, from the Malaysian judiciary to present the paper titled Rethinking the Coroner's Inquest Process to Accelerate Justice Delivery.
Thank you, madam. Good morning and greeting to all. My name is Teo. May I ask permission to share my slide? Okay. Okay.
Yes, dear, you can share.
All right. Okay. My topic is rethinking the coroner inquest process to accelerate justice delivery. Without further delay, I will start right now. For my introduction, I'm discussing the law in Malaysia regarding the inquest proceeding governed by the Criminal Procedure Code under the Section 328 to 341A. Generally speaking, a coroner inquest is an inquisitorial and fact-finding proceeding held to explore the cause of certain or unnatural death, is concerned more with ascertaining the truth as to how the person died rather than assigning criminal liability. There are concerns related to this topic, which is the delay and lack of urgency in investigating suspicious death, in which a focus in this paper. For instance, in the case of Teo Men Gee, the magistrate conducted a lengthy inquiry hearing and had examined 37 witnesses who included 12 experts. And in another famous case, the death of one fireman, the name is Mr. Muhammad Adib, which had become a matter of great interest as it was claimed that his life had been exploited by the many parties that led to a 41-day inquiry involving 30 witnesses who were called to testify and 137 pieces of evidence materials were presented. So due to this issue, under Section 37 Malaysian Code, the role of a coroner, a magistrate, or Supreme Court judge is to investigate when, where, how, and in what manner a person died, and whether any individual was criminally involved. It's established that an inquest proceeding by a coroner conducting in a court of law will deal with all the necessary judicial authority thereof. And due to this, Regulation Number 2 of 2019, which was issued by the Chief Justice, had replaced the previous direction and is currently on use, has stated that the session judges preside over all inquests. This had raised legal concerns of inconsistency as it conflicts with the procedural court, which clearly assign this duty to a magistrate. And with this, it must be recognized that the coroners are not tasked with determining liability or legal remedies. Important to clarify of theft in an inquest. And
Can I please request Dr. Sonia to put their mic on mute? Dr. Sonia?
oh, okay.
Yeah, you may continue, please.
Can you hear me, doctor?
Yes, you're perfectly audible.
Okay. It's important to clarify what cause of death mean an inquest. And cause of death is not limited in what is observed from the inspection of the body and the finding of the post-mortem. And in this context, Malaysia faced a shortage of trained forensic pathologists who already juggles post-mortem examination, criminal investigation, court duties, and teaching responsibilities. So I will go for the recommendations. The recommendation given is to provide an immediate inquest framework, replacing the current practice of calling numerous witnesses to address the identified challenges. Okay. For this active role of the coroner, rather than proceeding to every prolonged inquest, this study recommends establishing a dedicated 24-hour rapid response team comprising 3 rotating personnel, including a coroner, a forensic pathologist, and a prosecutor. This team would function within an ideal coroner office and work as independent investigating officer and forensic science unit. The coroner's mandatory attendance and the death scene support an active role in monitoring and prioritizing the corpse as the most authoritative witness. The corpse is a silent witness who never lies, and the dead body is extremely honestly informative. In a famous book, The Washing Away of Wrongs, written by Song Qi, who had served as a presiding judge in the High Court of the Song Dynasty for several terms and personally examined the crime scenes. Song Qi advocated for careful examination of both the deceased and the crime scenes and to uncover the truth behind death. Although the Criminal Procedure Code does not require the coroner to be physically present at the death scene, this study recommends that coroners attend in cases of unexplained or suspicious death. A preserved crime scene would greatly assist this role, although the coroner currently lacks statutory authority to direct police operation at the scenes. Nevertheless, the coroner present would enhance the integrity of the death investigation process. For the modified coroner office, there are generally 2 models of the coroner system. The first, similar to the Malaysia, is where the coroner is a judicial officer who is legally trained rather than the medically trained, and he is responsible for conducting the inquest as a fact-finding judge. A different approach seen in parts of the United States use a mixed system of the medical examiners and the coroners. The second is the medical examiner system, where the examiner is usually medically trained and often an appointed pathologist. A more practical solution for Malaysia is therefore a modified system in which forensic pathologists collaborate with the coroners to identify and document injuries in the suspicious and violent death and assist in identifying unidentified bodies. In this modified system, any decision by a coroner not to hold an inquest should remain subject to an appeal mechanism in the coroner's office, where the chief coroner serves as the highest authority and the inquest subject to the judicial review. In addition, the coroner office should establish its own independent laboratory information system to manage medical evidence, specimen, and the forensic sample, which will help resolve the logistical issue and ensure impartial forensic work free from the law enforcement bias. In this context, how about the prosecutor? The prosecutor will function more as an assisting officer and not as an prosecuting officer to guide the witnesses in the investigation process when reported and to examine witnesses for the purpose of receiving evidence whenever an inquiry is necessary. In conclusion, a death investigation must be reviewed by the coroner to address the public interest and determine how to prevent similar death issues in the future. The pathologist and the corpse play an important role in the investigation process, since the cause of death is a medical one. In this light, the prosecutor plays their role in observing and addressing witnesses in the investigation process, if any. And this supports the proposed Coroner's Act, which permits the establishment of an independent coroner's office led by the chief coroner as the highest hierarchy, and provides for an appointment of a family spokesperson or legal representative to liaise with the office overseeing the proceeding to ensure the deceased family interest and the public interest. Thank you.
The forum is now open for questions and feedback, if any. Thank you for your insightful presentation, Dr. Shu.
Thank you, madam.
Hi, Dr. Shu. How are you?
I'm thank you, doctor.
You're from Malaysian judiciary?
Yes, I am. I'm currently working as a magistrate in a small district of Alor Gajah in the state of the Malacca, in Malaysia.
Great. I really appreciate your topic because this coroner's inquest process, I think many of us will not know about what is this. So I have a very basic question to you because your recommendations are very noteworthy. But what's about transparency and accountability? Because in legal aspects, what mechanism can be put in place to ensure this transparency in decision making and to provide clear avenues for challenging a coroner's inquest decisions without excessive legal complexity? Because you know our legal process is very complex. So what is your opinion regarding it?
I think we can welcome the procedure of the mediation. One mechanism for the family spokesperson to meet with the assisting official in this context and we discuss and explain to them the report findings and make the thing transparent to the family members of the deceased. And of course, if they feel dissatisfied with the decision, as I mentioned in my proposal, they can file an appeal in the appeal mechanism against or to use the judicial review approach.
Okay, but do you think that in your recommendation you must also provide about the time targets, that it should be mandatory target dates for completing inquest to be introduced? For example, within 6 to 9 months for standard cases, for complex cases more than 6 to 9 months, and what mechanisms can enforce these targets? Because time duration is also a very important factor.
Yeah, agree absolutely with doctor. I will add this in my article.
Okay. All the best. Over to you, sir.
Thank you, ma'am. Thank you, Professor. Thank you, Shu, for such an insightful presentation. Mine is not a question because this is an international conference and we try to understand each other's jurisdiction. We have our issues in our country. Every country has their own limitations and problem, and mostly Asian countries they do share the same kind of issues. So my question revolves around the problem of state side, because you are also representing state, right? So what is the limitation? Pardon?
So I joining this conference on my
No,
personal
I
capacity.
totally I get it, but then you are a magistrate, so henceforth you have some representation of the state at Malaysia as well, right?
Professional experience, if I may, because if in order for me to join any conference, if I need to use my
Official
office
designation, yeah.
at their position, doctor. So this one I join on my own.
Totally
Okay.
get your point. But because you are in the field, you need to you probably have seen what are the limitations that are coming. Because yes, to expect a coroner to be there, it requires so many resources. So how do we tackle the problem of resources that are required to be provided by the state? Because any facility that is required to be ensured by the state will have its own cost attached to it. So how are we planning to you have that cost? Where is this budgeting coming from? Because without money, nothing can be done.
Yeah, true, doctor. So far, coroner is one of our judicial officer, and as I mentioned just now, our legislation expressly stated a magistrate is sufficient to conduct the inquest proceeding. But now, with the practice direction only, and without amending the provision in the legislation, they already assigned to session court judge who to hear the inquest proceeding, and one inquest proceeding really involves so many witnesses. It seems like conducting a trial. So it is the reason why I made this article. I want to point it out to emphasize the role of the coroner is just to determine the method of the death, but not go more to that to find out the liability of who made the offense. So in order to build this coroner office, I think the cost issue, we need to suggest to the Prime Minister Department for them to find out the public interest matter is really important to have this chief coroner to be assigned to handle the coroner matter and to ensure every case unexplained death can be concluded as Madam just now who offer me the solution. We must put the time frame properly. So with the short time frame, I think with the cases being resolved, that also one way of saving the cost. Can I take that, doctor?
It was not a question. It's just that because it's a knowledge sharing platform, we are still trying to understand. So what I see from my state side of view is that we have limited human resource. So having more of a human resource will demand more of finances. So that's why. So do you have in your jurisdiction, do you have the same kind of human resources scarcity or not? This was my general uh, query, not a question to you. It was my personal query that I wanted to understand from your jurisdiction.
As I know, doctor, I don't think it's a big issue as long as we can prove to the stakeholder that it is important to have one office. And maybe I agree with doctor saying we don't started with so many officer to be employed first. Maybe we can make one as higher, and then we try to have 2 to 3 office to try the process out. If I think if the result is good and positive, I think shouldn't be a problem because it will become necessity.
Yeah, thank you so much. That's it from me. Anyone, if they want to have any, not a question, but any knowledge sharing on this topic, they are more than welcome. Thank you.
Thank you, doctor. Thank you.
If anyone have any question for Dr. Shu, they can ask.
Or now we can move to the next presenter.
Yeah, we can move to the thank you for enriching presentation, Dr. Shu. After this enriching discussion, we now invite Ms. Paki Kansal, student, to present her paper titled Cybersecurity and Data Protection Laws in Digital Society. Ms. Paki Kansal.
Hello, good morning to the dignitaries. I hope I am audible to everyone.
Yes, you're audible.
Yes, good morning, Paki.
Good morning, ma'am. Just a minute, I'm just sharing my screen. Hello.
Yes, you're audible. Paki, you are audible.
Actually, when I just shared my screen, my microphone automatically disabled. I'm just trying to tell you. I hope I'm audible now.
Yes,
You are.
yes, you are audible.
My today's topic is cybersecurity and data protection laws in digital society. So, first of all, if we talk about law, technology, and digital society, so digitalization has fundamentally transformed governance, commerce, communication, and social interaction involving artificial intelligence, big data, cloud computing, and also transforming public administration, healthcare, banking, and justice delivery systems. Data has also emerged as the most valuable economic and political resource as government and corporations both usually rely on data driven decision makings. And if we talk about rapid technological growth, which has also intensified risk, as if there are pros to any system or any new innovation, then there are also cons attached to it. So some of the risks that we face with the rapid technological growth are cybercrime, data breaches, identity theft, and it also hampers the privacy. There is erosion of privacy of individuals, of corporations. Also, traditional legal systems were initially not designed for borderless digital activities. And if we talk about cyber security and data protection have become essential part today for the justice delivery system. Now, talking about the importance of cybersecurity in a digital economy, cybersecurity refers. So, what is the cybersecurity? Basically, cybersecurity refers to the protection of digital systems, networks, and data, which prevents unauthorized access and hostile interference, including safeguards digital infrastructure. And the core objective of cybersecurity is confidentiality of data, integrity of information, and availability of systems. Also, cyber attacks doesn't only threaten individuals, it also threatens the economic stability, financial losses, public trust, national security, and democratic institutions. So cyber security today is no longer a technical concern, it is now more of a national security issue. So, talking about data protection and informational privacy, data protection governs how personal data is collected and processed, and it is a right based legal framework basically which protects individual autonomy and preserves dignity and informational self determination. And the modern privacy risk includes digital profiling, behavioral tracking, algorithmic surveillance, and automated decision making. And informational privacy is now recognized as a core aspect of liberty as it has become a major part of everyone's daily life, also, which is linked to human dignity and embedded in constitutional discourse. Data protection laws aim to limit excessive data collection, ensure informed consent, impose accountability on data controllers. Now, talking about the relationship between cybersecurity and data protection. So, basically, cybersecurity and data protection are not conceptually distinct, but are interconnected. So cybersecurity protects systems and data protection protects individuals. So they both work vice versa. So weak cybersecurity often results in data breaches that are financial losses, privacy violations, loss of trust, and weak data protection magnifies the harm of cyber intrusions, including uncontrolled dissemination of personal data, and long-term digital exploitation. Also, modern legal regimes recognize this convergence as breach notification requirements, risk assessment obligations, institutional accountability. And courts now treat data breaches as violations of fundamental rights also. Now, if we talk about the global framework, so if we talk about the European Union, which is GDPR, the GDPR is the most comprehensive data protection law globally, which came in force since 2018 and influences laws worldwide. The core principles under GDPR include lawfulness, fairness, and transparency, accountability, and purpose limitation, and data minimization. Also, there are individual rights granted under GDPR, and GDPR also has extraterritorial application. But one of the lack or one of the disadvantage which we could see under GDPR also is there is no as such criminal provision included in it. It is protecting data of individuals. It is providing accountability and fairness, transparency. It is providing rights, but not as such any criminal provision is there under the GDPR. Also, European Union courts recognizes privacy is essential to democracy and dignity. Now, if we talk about United States and international bodies, so United States follows sector specific approach, and there are multiple acts and regulations for health data, financial data, children's data, that is the Children's Protection Privacy Protection Act for children's data, and state level laws are also there which enhances the protection. Now there are Cybersecurity Information Sharing Act, which encourages public-private cooperation and improves cyber resilience. Also, there are international organizations also which is there for data protection, but the same problem is also there. It is not ratified by many states. It has been ratified by small number of states. Another, that it imposes the accountability, but there are no criminal provisions attached to it, so which prevents or which will create a sense of warning that we should not do it, so the criminal provisions are attached to it. Also, absence of same thing, absence of binding international cyber law remains a challenge. Now, if we talk about Indian legal frameworks, as we all know, Information Technology Act 2000 forms the foundation of Indian legal framework under the cybersecurity. It enables e-governance and criminal. So there are criminal provisions in Indian legal framework. So it criminalizes the cyber offenses, and the 2008 amendments expanded the act with the data protection provisions, intermediary liability, and cyber terrorism. So the key provisions which are attached to it is like compensation for negligence, breach for confidentiality, and the criminal provision. The only criminal provision attached to it is Section 66, which penalizes computer-related offenses. Also, the 2023 Act, the Digital Personal Data Protection Act, it introduced the rights of data principles, data fiduciaries duties, and Data Protection Board of India. So, but as we all see, the criticism or the challenges also attached to it is the include of state exemptions and executive discretion. Now, talking about the role of judiciary in digital rights, the most famous or the landmark judgments I have put here, that are the Puttaswamy versus Union of India case, which recognized privacy as a fundamental right. The Shreya Singhal versus Union of India, which protected online free speech and struck down Section 66A of IT Act. The Anuradha Basan versus Union of India of 2020, which provides with the internet access linked to freedom of expression and internet shutdowns subject to proportionality. Also, Manohar Lal Sharma, the Pegasus case, basically. The surveillance subject to judicial scrutiny and national security is not a blanket of defense. So, if we talk about cybersecurity, human rights, and ethical governance, digital governance increasingly relies on surveillance technologies, which is the predictive policing, biometric identification, algorithmic decision making. Also, risk posed which includes privacy erosion, chilling effect on free speech, democratic accountability concerns. As the more we go towards the digitalization or towards the digital innovation, the more we face privacy concerns or the hampering of privacy of individuals. And also algorithmic governance may reinforce bias, and the international human rights principles apply legality, necessity, proportionality, legitimate purpose, and the ethical governance demands transparency and oversight, which we see nowadays, but not at that level that we could say yes, we have a wholly secured cyber system or a wholly secure digital world. Now, talking about the emerging challenges and future trends, the AI raises serious legal concerns, which we all are seeing nowadays, which is the lack of accountability, first of all, the algorithmic opacity and biasness. The deepfake technologies threaten democracies as electoral manipulation, misinformation, reputational harm. Also, deepfake technologies hamper individual rights also. We have seen many cases nowadays regarding the videos, regarding the photos using the deepfake technologies, and also which also hampers the base that there is the first challenge, that is the lack of accountability, because here we cannot make accountable to any person, so it is very difficult to find the real accused. Also, law often lags behind technology, so there are regulatory gaps, enforcement challenges, such as in the inaugural ceremony. We also find out that the international bodies or the international laws which are there for cybersecurity, but there is very limited ratification by the state. So till the time the states will ratify that law will be very behind the technology or behind the development which we are seeing in technology nowadays. So there is a need for adaptable technology neutral laws. So now talking about the policy recommendations, first of all, there is the harmonization of global cybersecurity and data protection standards. Secondly, strengthening regulatory institutions, that is technical expertise and infrastructure development. Next is promotion of public-private partnerships and mandatory judicial oversight surveillance, which is very important, and increased digital literacy and public awareness, without which nothing could ever happen. The newer the technology is coming, so the more awareness is required for the society, and as the it poses a higher risk of data breaches and sorry.
I would like Ume Pandey to please unmute yourself. Continue, Paki. It was just a false alarm.
Okay. So, lastly, the conclusion to my presentation would be that cybersecurity and data protection are pillars of modern digital society, and legal system must evolve alongside technology, as they both must go hand in hand. If one is lagging behind, then we would be seeing major threats to our legal system, individuals' rights, fundamental rights, human rights. So there should be a balance between innovation, security, and liberty. Also, right-based and ethical governance ensures public trust, and cybersecurity and data protection are moral imperatives of democracy. As both in today's world, in the today's digital globalization, legal globalization, or comparative globalization, which we could say, cybersecurity and data protection with the increasing AI, the need for them is increasing day by day, and it is multiplying with the more innovations or more need, we could say. Thank you so much for the dignitaries and for the participants to listen patiently.
We have to listen patiently, Baki. Baki,
Thank
I
you.
just want a brief introduction of yours because you are a student, right?
Yes, ma'am.
Uh,
So basically, I'm a LLM student,
yeah.
and I'm doing my LLM from Mangalam University, Gurgaon. I have done my undergraduation from Dehradun in BLLB. I have done BLLB,
Okay.
and yeah. So currently, I'm just pursuing that, and I have pursued for like my advocacy, my litigation.
Okay. So I believe that your specialization is in cyber laws, right?
No, I'm currently my specialization is in corporate law, but for this conference, I have done like many articles in that in cyber law. So I was having a keen interest, so I've done it here
Oh,
in
that's great.
cyber law.
Oh, so your topic is cybersecurity and data protection laws in a digital society, right?
Yes, ma'am.
So are you doing a comparative study?
Ma'am, the comparative part is there in the article regarding the Indian scenario and the global world, including the international organizations, international things that are there, international bodies,
Yeah, you have
laws, which are.
presented in your slides. That's why I am
Yes, ma'am.
asking.
Yes, ma'am. So there is a part of it, and also comparative part plus explaining them separately also. So what
Okay.
is.
So, in your conclusion, you have mentioned that there should be a balance between innovation, liberty, and security. So, on this basis, I just want to ask you a very simple question that how do these data protection laws balance privacy and national security?
Ma'am, data protection laws, it is basically dependent upon how it is implemented. First of all,
Hmm.
the data protection and the national security, the data protection laws and the security, how they are being implemented. If the legislation and the judiciary needs to just put it in that way, or have to get it implemented so that the fundamental rights of the individuals, the human rights which are being provided through the international bodies, um, they are just not hampered, or they are just not I would say violated in that sense. Also, the technological advancement which we are seeing, like the deepfake thing which we have seen today, or anything related to AI which is being misused. So I would say that we need to just give rights to the individuals, so that their individual rights and the individual thing is protected. Also, the national securities, like the if we talk about the Aadhaar card case which we saw. So the individuals identity or the individual data was being misused, or was being just disseminated without their permissions or without their knowledge. So we need to just check out on that the individual rights are also being not violated, and the national security, or the need for the national security which is there, like the information of individuals, it is required in many fields. So that is there with the government, but not just disseminated, or not there available for each and everyone around the globe. So it is responsibility of the nation, and also of the implementation agencies.
So, as you know, that our Indian government faced lots of challenges when updating cybersecurity laws. Even still, we are just, in a phase where we cannot say that we are technologically very sound. So, in that case, how can these data protection laws keep up with the fast changing technology? What is your views on it?
Ma'am, the data protection laws, I think that actually, could you please pardon the question? I was just.
No issue, no issue. As it is just a platform where we are just exchanging our thoughts and views.
Yes.
But anyway, you have done a very wonderful, presentation, being a student of LLM, that I must acknowledge. So all the best, Paki. Over to you, sir.
Hi, Paki. Congratulations on taking up such a relevant topic. Uh, Not a query, just trying to understand your perspective on this because you are also trying to talk about invasion of privacy and all things. So it came to my mind because we are talking about the big picture and everything that is covered, but don't you think we are not at all looking towards the invasion that the corporates are doing? Let me just scroll through some of the reels in Instagram, and automatically all my Instagram feed is full of all those kind of reel. Let it be depressing, let it be bike, let it be car, or whatever. एक शायरी सुन लिया तो then automatically everything flows down from that. So don't you think this is also an aspect of privacy that we are probably skipping, we are not taking into consideration? And talking about algorithmic governance, uh, whether informed consent under the new data protection still is meaningful in this platform driven digital economy?
Yes, sir, I agree. The thing we even talk in like if we are talking right now, then our phones must be listening it all the time, and it would show us the same thing. Like if you're talking about cybersecurity, then the next thing would be we would be seeing some courses related to cybersecurity or the data protection. We would be seeing the ads according to it. So yes, the corporation, the lack of privacy which they are showing, I totally agree to it. The thing which I've mentioned in my slides also, that it is the lack of accountability which is the main challenge which we are facing. There are provisions which are present here, where there are laws which we have, but the lack of accountability is the major challenge of even previous times and today also. So that is the thing which the government, or which the policy makers, or which the judiciary needs to work on. As the We have laws, we have much more scope to work on. So I totally agree to this, that algorithmic governance and lack of accountability which I'm saying. So it is very important to just make accountable corporations, individuals, or the accused, or the persons who are doing.
Thank you for your insightful presentation, Paki, and it was indeed a wonderful discussion. I would now like to invite Ms. Komal Yadav, student to present her paper titled Health Surveillance on the Wrist, Safeguarding Democracy and Digital Rights in the Age of AI-Powered Wearables. Over to you, Ms. Komal Yadav.
Well, a very good morning to one and all present here. I would like to share my screen. Is it visible?
Yes, it is.
Thank you so much. All right. So this is the title of my paper. Imagine a device on your wrist that knows your heart rate, your sleep cycle, and even your stress levels. Today's AI-powered wearables, including smartwatches, fitness bands, and rings, continuously monitor our bodies, offering personalized health insights. As one report warns, quote unquote, every day millions of people share more intimate information with their accessories than they do with their spouse. These devices capture body-centric data such as heart rate, steps, sleep, and fertility metrics, and utilize AI to transform raw signals into predictions about health and behavior. Adoption rates have skyrocketed, especially since the COVID-19 pandemic. Yet privacy laws have not kept out that pandemic misuse surged, but current laws offer little protection for consumers who are often unaware how much of their health data is being collected and shared. In short, the risk has become a new frontier for health surveillance, and that raises urgent questions for democracy and digital rights. With this background, I would like to mention that I would be using doctrinal legal analysis as a methodology. And the gap between innovation and oversight is the core problem that I address. My research question is that how do AI-driven health variables affect democratic values and digital? My thesis is without safeguards, this new form of surveillance erodes individual autonomy and undermines democratic accountability. I argue that the pervasive collection of sensitive health data by private and public actors can lead to non-consensual profiling, commodification of personal health, and even coercive control unless checked by law and policy. In the word of technologists, we are witnessing the rise of surveillance capitalism in personal health. Big tech is covering up human experiences as raw material to predict and alter our future behavior. In the age of AI, this behavioral surplus now includes our biometric and physiological data as well. My goal is to show that health variables are not merely personal gadgets, but also potent surveillance tools. I will analyze biometric data trends, the role of AI in processing this data, and the democratic stakes of these developments. I will also highlight three key risks: erosion of consent, commodification of health data, and threat to autonomy, using real-world examples. Finally, I will survey current regulatory efforts such as GDPR, AI Act, and HIPAA, and provide policy recommendations aimed at safeguarding democracy and rights in this new context. Variable devices collect an ever-expanding array of biometric signals. Modern smartwatches can track heart rate, variability, blood oxygen levels, ECG rhythms, sleep patterns, steps, and other vital metrics. Ring-style monitors and tattoos promise glucose or blood pressure readings. Some devices combine built-in AI and cloud analytics to issue health alerts. As one legal analysis notes, wearable health technologies are no longer just fitness gadgets. As they become AI-driven health platforms, they also confront complex regulatory privacy and liability challenges. In practice, these devices blur the distinction between consumer gadgets and medical devices. They accumulate vast streams of data that can be mined by algorithms for personalized insights, but the same stream can also reveal deeply personal patterns. The scope of data is truly personal. Body-centric data encompasses a wide range of measurements, including pulse and respiration, also skin temperature, and various locations and social interactions, which are captured via GPS. For example, fertility tracking apps ask users to input menstrual dates and symptoms, which are then processed by algorithms. Mental health apps also collect mood logs and sleep to gauge your stress levels and depression levels. Even digital medical records can feed into analytic platforms. The result is a detailed physiological and behavioral profile. According to data privacy experts, advertisers and researchers can now fuse wearable data with other sources to build consumer profiles so granular that it could be possible to target specific individuals with tailored messages or interventions. In the parlance of academia, our digital phenotypes are being construed without our active guidance, raising ethical alarms. AI powers this process by turning raw numbers into predictions and recommendations. Machine learning models on these platforms claim to predict disease risk, optimize fitness training, or even detect early signs of illness. But with powerful analysis comes the temptation for misuse. Unless constrained by design, the algorithm behind these variables can become invisible gatekeepers of our health and behavior. I would like to move on to the key risk that I have identified. I identified three interlinked risks from AI-powered variables. First is erosion of informed consent. In theory, users consent to data collection via terms of service and privacy policies. In practice, few read or understand these documents. Consent is often symbolic, a box checked, not an informed choice. Users typically have no reasonable expectation that deeply personal metrics will be sold or shared with advertisers. Indeed, privacy advocates warns that non-consensual data sharing is a big issue, even when it involves biometric and health data. For example, Flow, which is a peer tracking app, it promised to keep menstrual data private, but covertly shared it with Meta. A 2025 jury found that women had reasonable expectation that their sensitive menstrual information would not be disclosed and ruled that Meta acted without their consent. This case illustrates how users may unwillingly hand over control of their intimate data. In short, the burden of consent has shifted. Consumers often do not truly know what they are agreeing to. The next risk that I identified is commodification of health data. Unlike traditional medical records, data from wearables routinely flows into commercial markets. Companies may aggregate and sell health-related data to data brokers, insurers, or advertisers. This transforms personal health into a commodity. Privacy studies have documented the sale of highly sensitive data. For instance, a 2023 study found that data brokers were trading profiles of individuals' mental health conditions, sometimes even including names and address of people seeking therapy. Advertisers price this as behavioral surplus. One expert notes that body-centric profiles are becoming so detailed that when combined with other datasets, they can target specific individuals. In practice, this means your resting heart rate and sleep quality can help insurers calculate premiums or target vulnerable ads. Missing from most laws is any prohibition on using health data for unfair pricing or employment decisions. I would like to move to the third issue, which is threat to autonomy and civil liberties. The most profound risk is that pervasive health surveillance can undermine our freedom and self-determination. Continuous monitoring can subtly influence behavior. Think of step goals that pressure exercise or sleep trackers that guilt users about resting. Beyond gentle nudges, however, data-driven governance can be heavy-handed. The pandemic offered a cautionary tale. China's government used health status apps to enforce lockdown. As one scholar describes, China's health code system, ostensibly for public health, became a panopticon, categorizing citizens into green, which is for healthy, red and yellow requiring quarantine based on their data. This pretense of surveillance as care effectively tied movement to biometric judgments, penalizing travel or healthcare access for those flagged by the algorithm. Imagine a democratic state using similar tools to monitor protesters' stress levels or impose smart quarantine without due process. The erosion of rights could be dramatic. Human rights experts warn that unchecked digital health tools can violate fundamental freedoms of humans. Now I would like to tell that policymakers are beginning to respond, but many gaps remain. In Europe, privacy law is comparatively very robust. The GDPR classifies biometric and health data as special category data, meaning it requires explicit consent and extra safeguards. In practice, this should limit marketing abuse, but enforcement is uneven. The European Union's new AI Act also targets medical AI. Any AI software for health is deemed high risk and must meet strict standards. And the European Health Data Space Initiative, which is operational by 2029, it aims to unlock health data for public benefit while preserving privacy. Under EHDS, individuals will be able to share wearable or derived health data with researchers or doctors in a secure way. In short, the EU is moving towards a model where data flows for innovation, but only under regulated, interoperable, and transparent conditions. Elsewhere, trends vary. Countries like Canada and Brazil have provisions regarding sensitive data, and some Asian regulators are drafting health data rules. International bodies like WHO and UN have published principles for digital health, ensuring consent, privacy, fairness, and equity. For example, Global Ethical Guidelines urges that any personal health data collection be done with fully informed consent. With strong security safeguards, states are called on to regulate the collection of and storage of personal information so as to prevent unauthorized use. Now I would like to bring on the findings. Wearable health tech and AI offer immense promise. Earlier diagnosis, proactive care, and empower individuals. However, if left unchecked, they treat to invert the social contract. Rather than citizen being the means of governance, they could become the means of surveillance. Democracy depends on trust and autonomy. We echo the sentiments of observers who argue that preserving our health data is vital to our democracy, as data shapes public policy, accountability, and equity. Destroying or abusing that data makes it much more difficult to hold leaders accountable, eroding public trust. To safeguard democracy in this new era, I recommend expand privacy rights for bodily data, treat wearable generated data as deeply sensitive. Laws should explicitly cover all body tracking information requiring explicit opt-in consent and prohibiting surprise secondary uses. Privacy policies must be clear and revocable, not hiding in fine prints. Users should have the right to know what is collected and to delete it, paralleling human rights standards on personal data. Next, I recommend limiting commercial exploitation, impose strict constraints on health data markets. We should ban unfair profiling, for example, outlawing the use of variable health metrics to raise insurance rates or deny opportunities without explicit user authorization. Data brokers' inventories must be regulated. Potential models include treating platforms as data fiduciary, which are legally obligated to manage user data in the user's best interest. I also recommend to ensure algorithmic transparency and human oversight. When AI analyzes our bodies, individuals must retain agency. High risk health AI should require human in the loop review, explainability, and accuracy audits. Regulatory bodies should mandate independent testing of the AI functions in health variables. Users should understand and consent any significant inferences drawn from their data. I also propose to bridge regulatory gaps in the US and elsewhere. We need new frameworks to cover consumer health tech. This could mean expanding HIPAA or creating a dedicated Digital Health Privacy Act. At a minimum, enforcement must be strengthened. Regulators should investigate unauthorized data sharing, as in the recent prosecution of Flow that I shared before, Flow Up. And international standards like the WHO and UN principles should be translated into binding safeguards and harmonized globally. Last but not the least, finally, public awareness is critical. Legal and technical experts must educate citizens about the risk associated with digital health. Conferences like this one play a role. By bringing together lawyers, technologists, and patient advocates, we can shape norms. Transparency initiatives like data trust, open source algorithms, and civil society oversights can help keep industry honest. Above all, we must cultivate a democratic consensus that personal health is a domain of freedom, not of domination. Thank you so much.
Komal, can you again
Yes.
please give a brief introduction of yours? Because I can
Yes.
see half of your face. Now I
Sorry,
can
ma'am.
see the full face.
So, ma'am, I'm a final year law student at Indian Institute of Management, Rohtak. I'm pursuing BBA LLB.
Okay.
And yeah, I've also done a course on cyber law, and this topic is very interesting to me because I realized this while doing my research. So I thought of making a research paper on this.
That's great. But from where have you done your course?
Ma'am, Indian Institute of Management, that course, that was a cyber law course from FCRF Academy.
And you are in which semester?
Ma'am, I'm in my last year, like last semester.
5th semester.
Yes, ma'am. We
So
have
you
trimester, sorry, ma'am, we have trimester system. So I'm in 14th trimester. We have in total 15 trimesters.
Okay. So your topic is very broad, very wide. So naturally, we all are using this health surveillance and all this. So just tell me, this wearable health surveillance will increase the risk of social inequality or digital exclusion? What is your idea about it?
Ma'am, for instance, there are now glucometers and other devices. They are like, you can put them on your stomach and they will tell you when your glucose levels are low and when they are high. So the thing is that these instruments, they are very helpful, agreed to that, but not everyone can afford it. For example, in India also, there is a wide gap between rich and poor. So these devices, which are using AI, are also overpriced. So not everyone can afford to use them. So I think that it is same as not everyone has uh, access to technology today, because if you see villages, people do have smartphones, but they are still not digitally literate. So there is a possibility of digital exclusion and also social exclusion, because even traditional healthcare is not able to reach to all of the citizens. So uh, I think that, of course, making digital tools accessible to everyone is a challenge.
You have also stated that democratic consensus. So, in the democratic aspect or governance and power, these AI powered variables or widespread health surveillance, will they undermine these democratic freedoms, such as our consent, our autonomy?
Yes, ma'am, because if you see in policy documents, or even if we are agreeing to any website, we just tick the box. Now, we as consumers, we are not fully informed about what we are agreeing to. So, our democratic, as we see in the GDPR and DPDP Act, consent is of much paramount of importance. Now, if we are agreeing to something without fully informed consent, or for example, I shared the Flow app, they are using your intimate details covertly with Facebook or Meta. So there is a risk, and our consent is, of course, first of all, our consent, we do not know even after if we are consenting, our data is being covertly misused. It is sold on dark web, it is sold to data brokers. There is a risk. So first of all, we must be very careful while consenting to it. And even if we consent, even if we give informed consent, then still there is a risk of it being shared illegally. So, but at least if we make our laws stronger, then this risk can be reduced, and the liability should not be on the consumer itself. There should be strict liability, strict regulatory checks and audits on these insurers and these digital health service providers as well.
But how to maintain an equilibrium between this public health benefits and with personal privacy? Because obviously, if there are AI generated wearables, so everyone will prefer to wear it nowadays, even if it is not affordable by them. But so, how to manage this? How to balance between this public health benefits and personal privacy?
In addition,
Ma'am,
Kumar, before you go ahead, in addition to what ma'am said, there is a problem of people not knowing as well. Because why should I say people not knowing? I did it to myself as well, because I got myself my various tests done, and then I uploaded the same to ChatGPT as well as on Gemini. So as to understand whether the physician is getting the same outcome or not. So these kind of inquisitiveness with the lack of knowledge of consequences, how can we deal with these problems?
this is a very common thing that I believe that most of us now, with the introduction of AIs like ChatGPT and Gemini, we are using them to understand what the doctors are doing. Earlier, we had no idea what they write on the prescription. Now, I read in news, there are even AIs who can.
No. I'm telling you, I may be judged for this nonsense that I did, but then it was not the prescription. I took the medical
Yeah,
report, all
yeah.
the blood test and everything that I got done, and I uploaded it in ChatGPT. And the same I did it in this Gemini. I also did it in that Perplexity AI. I used all three of the AI so as to understand what is there in my blood and how should I go ahead. I also went to the doctor, but then in order to corroborate what the doctor in physical person has said, I uploaded the same in all three of these AI. And they came out with their own analysis and everything. And I kind of gave a thumbs up to my MBBS doctor who did so many things after such labor. But then these kind of problem, maybe because of inquisitiveness, curiosity, maybe because of what not having sufficient knowledge of the outcome. How can we control this? Because now ChatGPT and all these three, they have my personal data. They also know how much iron do I have in my body or not. So uh, can we do something about it? Can we
Yeah.
control human inquisitiveness nature? Curiosity kills the cat, right? So how can we control this?
All right. So, sir, sharing your data to AI to understand it is a good thing. If we are sharing our medical records in order to understand, that is good. AI is meant to help humans. Now, if AI explains these medical terminology to you in easy language, it is good. But the problems comes when it misuses your data. For instance, now ChatGPT Go is for free and Gemini Pro is free for students. There is a reason why they are providing free access to their upgraded versions, because they want to collect data. These algorithms, they work on training data that we feed into it. So as long as it is using the data just to help us, it's good. But when it uses our data to train and even to exploit it, even to misuse it, now when your ChatGPT knows that your blood sugar levels are low or something, it will use it. It will share this data with the capitalism market. They will show you the sugar-free advertisements and everything, and they do it so subtly that you will not even notice, and you will finally fall into buying products. Now, what we can do to protect ourselves is that for every company to, for example, if if Google wanted services, if India wants the services of Google, Google have a certain consent form and everything. For example, even Meta, Instagram. So our government, when they give permission to these companies to reach India for their services, that must be regularized. Like our government should make more bars, high bars, set high bars, that you cannot use our data for commercial ads or these things. And they often make this like, they will say, if you do not give consent of using this data to train our algorithms, we will not give you our service. So in a way, we are helpless because our government ourselves, they are not very efficient till now to make their own AI or something. So we are helpless in that way. But in order to maintain the equilibrium, which ma'am also talked about, I think we as consumers, we as the users, right? There is always, like, we should be informed about our choices and what we are doing. So in ChatGPT also there is a option to delete our history and to delete the data that it collects from you. So I think we can keep deleting that, and we can make sure that our identity and our data is not used against us. So it takes both the government help and also the awareness among users in order to eradicate the misuse of AI.
Yeah, just to let you know and to confess, I have never deleted my history in ChatGPT because it is helping me every day
Yes, sir.
in
Yes, sir.
adding more. So we don't generally do that. But
Yeah, sir. Also, can I add one thing? Sir, every AI stores some information about you, and if you use a new AI and you just feed that data set that it has stored about you, it will talk to you the same way as the previous AI was talking to you. So the actual role is in that information that it stores about you. So if we keep deleting it, I think that is beneficial.
I think the discussion is over. There's one question in the chat for you. Article 51A of 51AH of DPSP states to develop scientific temper. Is it not contradicting to the same if not allowed to develop scientific humanism to be understood and used judicially? Impulsive buying or purchase is human attitude with respect to other beauty and health products also.
Yeah, and this is the loophole that they are trying to exploit. They know that we are very impulsive, and with the introduction of social media, we have become more impulsive. For example, you know why what's the reason behind this cybercrime? They will give you like 50% discount, click here, links like that, 50% discount on your beauty products, and you will impulsively click on it without thinking, without blinking your eye, because we are so impulsive. And I know this DPSP, you are correct in pointing that out. I agree with you, but it requires awareness amongst ourselves, that we do not act so impulsively, and also we need a logical, critical thinking, rational mind, that what is it that we are deciding to buy. Is it, for example, if your AI know that you are conscious about your beauty, it will show you beauty products. And in a way, it is good because you have a variety to choose from. But you must draw a line between where it is helping you and where it is misusing. If you are buying one cream, it's fine. But if because of that implicit nature, you are buying 50 different creams because each one gives one more benefit, then it is exploitation of yours, not just helping.
Thank you for your insightful presentation, Komal. It was quite a wonderful discussion. I would now like to invite Mr. Ayush Verma, research scholar, along with Professor Sudarshan Verma, Head Department of Law, to present their paper titled Courtroom to Governance, the Interplay of Public Interest Litigation and Policy Making. Mr. Ayush Verma. I think he is not present here. I now invite our next paper presenter, Miss Ashi Loya, student, to present her paper titled Public Interest Litigation as a Catalyst for Policy Reform. I think she is also not here. Yeah, she is here.
She's here, but she's not audible.
You're not audible, Ashi.
Yeah, I have a request. I request all the presenters, rest of the presenters, please not to read out. Just give us a vivid idea of your research work.
Ashi, you can start whenever you are comfortable, but
No, you're not audible.
we can have the next presenter. We'll have Ashi at the end.
Yeah, okay. I now invite Miss Bhumika Sharma and student Miss Sania Parvez to present their paper titled Evolving Labor Rights in the Global World.
Good morning.
Good morning. You're audible.
Wait, share screen.
Sania, we would appreciate if you switch on your camera. So,
Yes, sir. Awesome. Good morning to all of you. Myself, Shania Parvez. I am BLLB third year student, and my topic is evolving labor right in global world. The labor right are closely connected. Second. The labor rights are closely related with human dignity, social justice, and economic development. World. The labor right are the right provided to a worker to ensure fair treatment, safety, and dignity at the workplace. This right are protect from working labor's condition. Labor right are considered of human right because every worker deserves a respect and security while earning for a livelihood. Basic labor rights are included right to fair wages so that worker can get a maintain decent standard of living. Worker also have the right to safe and healthy working condition and other important rights including reasonable working hours, weekly holiday and freedoms from the trade union and protection from the child labor and forced labor. International Labour Organization. The International Labour Organization was established in 1919 with the objective of promoting social justice and promoting and improving social labor condition across the world. It is the specialized agency for United Nations and the ILO of Unite follow a unique tripartite system where government, employer and worker all participated in decision making. The ILO sets an international labor standard through the convention and recommendation. This standard guide different countries in framing their labor laws. The organization also promote the idea of decent work, which means employment with dignity or equality, fairness, and social protection. Our fundamental labor rights recognized by ILO is International Labour Organization for Fundamental Labour Rights. This include freedom of association, collective bargaining, and elimination of forced labor, allegations of the child labor, elimination of discrimination in in different employment areas. These rights are universals, should apply in all worker globally. In today's global world, the labor right faces some challenges leading to a job insecurity. Many workers are temporarily in contract basis. Migrant workers often face exploitations and poor wages and lack of legal protection. The technology has changed the nature of work. Automation and have the reduced the traditional jobs. The gig economy has created a new forms of works like delivery partner, freelancers, and the worker often do not receive social security. To protect labor rights, the labor law must be strictly enforced. Social security benefits should be extended to informal and gig worker. Should be encouraged to join and trade union. Awareness uh, and the government play a crucial role by framing workers friendly labor policies, ensuring proper implementations, and judiciary also protect labor right by interpreting laws, ensuring justice. And the conclusion is कि labor right are essential for social growth and social economic growth. uh, this labor law involved the protection from traditional modern forms of employment and also strength society. Thank you so much, ma'am.
Sania, right?
Yes, yes, ma'am.
You are a student of third semester.
Yes, ma'am.
In which institution?
Ma'am, Sharda University.
Oh, Sharda University. Firstly, Dr. Bhumika is your professor?
Yes, ma'am.
Okay. Um, I have a doubt about your title, very frankly speaking. This
Okay.
title is incomplete. Can you please tell me the recent labor codes in India?
Labor. No, ma'am. I didn't
Because
know.
I think your topic is regarding labor laws,
Yes,
right?
ma'am.
And you must know the recent labor codes. And your slides have not moved. We are just able to see
Okay.
about your evolving labor rights in global world.
I'm really sorry, ma'am. It was my really sorry.
No, no, it's okay. No need to say sorry, my dear. But whenever you are presenting in an international conference, you should be aware that you are presenting and accordingly you are also speaking.
Okay, ma'am.
Okay. Because today you are reading out, so you are unable to go through that. Your slides are in a very static mode. Okay. So just one question, answer me that how has globalization changed this labor rights, nature of work, labor laws? What is your view?
Mm,
I would better give you a suggestion, my dear. You must just work on your title at first.
okay, ma'am.
Just know the labor law, labor codes, and then you go through your research work. That will be more useful to you.
Okay, ma'am.
All the best.
Thank you, ma'am.
Ritika, you are on mute.
Sorry, extremely apologize. Asha Loya is ready to be present.
Hi, I hope I'm audible.
Yes, you're audible.
Yes, you are audible.
Okay, thank you. Please give me a minute to share my screen.
Okay.
Um, wait, do we see do you guys see the screen?
Yes,
We
we
can see
see.
Canva.
Okay, just give me a minute, please. Uh,
Yes.
right, the screen's visible.
Maximize it.
All right, ma'am. All right. I guess we're good to go now.
Yes.
All
Great.
right.
Ashi, be brief and do let us know what is the outcome and contribution of your research.
Sure, sir. Sure. Good morning, respected members of the bench, distinguished dignitaries, and fellow delegates. Much of today's discourse has centered on innovation, artificial intelligence, digitalization of courts, and the future of adjudication. However, while we look ahead to emerging technologies, it is important for us to remember, pause, and acknowledge one of the most profound innovations the Indian judiciary has already given us. An innovation not driven by codes or algorithms, but by constitutional conscience. That innovation is public interest litigation. The Indian constitutional democracy functions upon two interrelated doctrines: the doctrine of separation of powers and the doctrine of checks and balances. Power is distributed among the legislature, the executive, and the judiciary. The constitution mandates constitutional harmony, where each organ acts within its domain while remaining accountable to the constitutional vision of justice, equality, and dignity. Within this framework, the judiciary occupies a unique position. And as the guardian of the Constitution and the final interpreter of law, it is entrusted with safeguarding fundamental rights and ensuring supremacy of the law. Public interest litigation emerged precisely at the point where this constitutional responsibility intersected with governance failure. PIL was born out of the stark reality that constitutional rights, though beautifully articulated, remained inaccessible to vast sections of the society. Procedural rigidity, economic barriers, and the narrow interpretation of locus standi reduced justice to a privilege rather than a right. By relaxing locus standi, PIL transformed access to justice from individual entitlement to a collective constitutional remedy. However, the true constitutional significance of PIL lies not merely in access to courts, but in its ability to act as a catalyst for policy reform. In India, judicial precedents occupy a place in the legal system. The ratio decidendum of the Supreme Court judgments is binding upon the other courts and often fills legislative and administrative vacuums. Through PILs, courts have repeatedly converted constitutional values into enforceable standards that operate in effect as public policies until formal legislations have been made. This catalytic role is best understood through judicial precedents. In Hussain Ara Khatun case, the court did more than just order the release of under trial prisoners. By recognizing the right to a speedy trial as an intrinsic component of Article 21, the judiciary redefined criminal justice administration. This judgment compelled the state to reconsider bail policies and procedural delays. Similarly, in labor and economic governance, PIA judgments expanded the understanding of public interest. In the Akhil Bharatiya case, the court treated labor welfare and public property not as a private dispute but as matters of constitutional concerns. In Vishaka versus State of Rajasthan, the Supreme Court formulated binding guidelines on workplace regarding sexual harassment. These guidelines were not symbolic. They governed workplaces across India for 15 years and eventually shaped the Sexual Harassment of Women at Workplace Act. Here, PIL operated as a bridge between constitutional rights and legislative actions. Environmental governance presents another compelling illustration. Through the MC Mehta series, the judiciary articulated doctrines such as sustainable development to compelling executive agencies to adopt cleaner mechanisms to ensure accountability to the governance. What makes PIA uniquely effective as a policy catalyst is the judiciary's use of continuous mandamus. By retaining jurisdiction and monitoring compliance, courts ensure that constitutional directives did not remain on paper. This sustained oversight transformed PIL from an episodic intervention into a mechanism for long-term policy implementation. At the heart of the process lies the power of judicial precedents. In India, precedents are not merely persuasive, they are normative. The ratio decidendity of PIL judgments often operates as guiding framework for governance, compelling executive action, and shaping legislation priorities. However, this expanded role of PIL has not been without criticisms. Concerns regarding judicial overreach, frivolous petitions, and misuse for private or political interests are valid and must be acknowledged. Yet, these concerns do not negate the constitutional value of PILs. Rather, they highlight the need for judicial restraint, bona fide scrutiny, and procedural discipline. When exercised within constitutional limits, PIL does not undermine the separation of powers. It strengthens it. By holding the executive accountable to constitutional standards, PIL reinforces democratic governance. In conclusion, public interest litigation represents one of judiciary's most transformative contributions to the Indian Constitution. It has reimagined access to justice, expanded participatory democracy, and most importantly, acted as a catalyst for policy reform. In an era captivated by technological innovation, PIL reminds us that the most enduring judicial innovation is one that ensures the Constitution is not merely interpreted but lived. Thank you.
Ashi.
Yes, ma'am.
You are a student of?
Ma'am, I am a second year student of Amity University, Haryana.
Maneswar.
Yes, ma'am.
So what is PIL?
Sorry, ma'am?
What is PIL? PIL.
Ma'am, public interest litigation is a formal way for anybody who is not individually aggrieved to file a petition before the court of law on matters that affect the public at large. For example, environmental concerns, human rights violations, social welfare.
Have you heard the term epistolary jurisdiction of PIL?
Yes, I have, ma'am.
What is it?
Please give me a minute, ma'am.
Be comfortable.
Sure, ma'am. This is my first ever conference, so the Zoom and the mic issues just messed all of it up and they like ruined my confidence.
No need to be missed. You are giving a wonderful presentation.
Thank you.
Mesmerized.
Thank you so much, ma'am. So with regards to the epistolary jurisdiction, I believe that they refer to the court. The court considers informal letters or any medium of information which the courts receive as eminent evidences for them to take the suo motu cognizance over cases and build them into formal litigations before the court of law.
So what is a SAL? SAL?
Ma'am, I'm sorry, I have not heard of the term SAL before.
So you must know this because it is social action litigation. Because when you are talking about PIL, you must know the other term as well. So I have a very easy question for you. That is, what role do our civil society and media play? Because nowadays media is very proactive. So what role they play in translating these PIL outcomes into real policy reform? Because as you have mentioned the term PIL as a catalyst.
Ma'am, so I believe that the media in itself is a very powerful tool to persuade the general society to do or follow anything. And India has a very vast history of converting PIL judgments into formal legislations like the Vishaka case. So I believe if the media constantly reminds us on how we have such important legislations like the prevention of sexual harassment at workplace, the general society will realize how important PILs are and not overlook them as mere sources of contributing information to the court. So I believe that if the media constantly reminds us on how important PILs are and how easy it is for general societies to file a PIL before a court of law, the general society will gradually bridge the gap between the unawareness.
Can you give me an example?
I cannot think of any innovative example immediately right now, ma'am. But if if we constantly like social media is a very easy platform for us to persuade things. If we have some channels or media channels that tell us on how easy it is to file a PIL, maybe show us how to file a PIL, and maybe show us the repercussions of filing a good PIL and how that it helps the general society, it would work.
Okay. All the best, Ashi.
Thank you so much, ma'am.
Over to you, sir.
I have no question. Thank you, Ashit.
Thank you.
Thank you, Ashi, for your wonderful presentation. I now invite Ms. Akasta, and research scholar, along with Mr. Vishwas Puttaswamy, in charge principal, to present their paper titled From Classroom to Policy Room, Cultivating Policy Awareness in Law Students Through Contemporary Legal Education.
Very good afternoon, one and all present here. Am I audible?
Yes, you are.
Yes, Akshata, you are audible.
Yeah,
And
can I
good
share?
afternoon.
Yeah, good afternoon. Can I share my PPT, ma'am?
Yes, yes. You have a co-presenter also, right?
Yes, ma'am. I have a co-presenter. One minute. Ma'am, my PPT is...
You just go for the share button, Akshata.
Or Akshata, you can directly present without PPT as well.
Hi. But if she has prepared, sir.
Yeah, I have prepared, ma'am.
Because I'm getting message that we are overlapping on a different
Yes.
distance, so maybe.
Okay. If that's the case, I'll directly go through with my PPT. No issue. So my topic is From Classroom to Policy Room, Cultivating Policy Awareness in Law Student Through Contemporary Legal Education. Basically, I am the political science faculty who is working in a law college, and my name is Akshita Puapa, and I'm doing my PhD from Jain University, Bangalore, and also I'm working as an assistant professor in Soundarya College of Law. When it comes to the introduction part, so if we look into majority of the colleges, they are always following the old legal system, the subject which we are following right now also. The legal education has traditionally emphasized courtroom advocacy, statutory interpretation, and judicial prudence. And while these foundation remains virtual, in role of legal professionals has expanded significantly in 21st century. Lawyers today actively contribute to the public policy formulation, regulatory design, governance reform, and advisory role within government and international institution. And what is the need for policy awareness in legal education? Modern government require a legal professionals who understand not only the letter of the law but also the policies that shape its implementation. Every public policy derives legitimacy from the legal framework, whether in healthcare, education, environmental studies, or a protection, or a taxation, or anywhere, digital regulation, or anywhere. The law is playing a dominant role in everywhere when it comes to the policy making. And policy awareness law student can identify, not only they are not only useful to prepare the policy, and also they are very useful to identify the gap between the legal provisions and the social relations, access the impact of the government decision, contribute to legislative drafting, and safeguard the fundamental rights during the policy preparation. and contemporary trend in legal education. Now we can see the university are integrated interdisciplinary approaches that they have combined the law with the political science, with economics, with sociology, technology, environmental studies, as well as they are introduced BCom also in law. And digital transformation through the legal technology, e-government tool, and AI based research has further reshaped pedagogy. Experiential methodologies such as legal clinic and also policy internship, and also when it comes to the mock parliament, moot court competition, these kinds of the experiential learning are shaping the law. And also the real world government challenges also they are facing in it. And additionally, globalization has increased comparative legal studies, international collaboration, and participation in the traditional policy framework. So because of that reason, they have introduced more practical subjects in the law. And when it comes to these strategies to foster policy awareness, so policy awareness can be strengthened through the targeting curriculum reform that introduce public policy, government studies, and legislative drafting as core or elective subject. And also policy lab, research center, legal clinic enables hands-on engagement with the policy analysis and social issues. And mandatory internship and government bodies, legislator and regulatory agencies, and NGOs also bring the theory with the practice. And role in the national building, so policy literate law graduate play a critical role in the national building. They enhance democratical governments, bridge the gap between the constitutional ideas and social realist, and support economic and regulatory reform, and address emerging global challenges such as climate change and cybersecurity. By fostering youth leadership and civic engagement, policy oriented legal education empowers studies to become the agent of the social transformation. When it comes to the conclusion part of this paper, by bridging the classroom and the policy room, so if we have a direct connection with the policy room as well as a classroom, so legal education can produce further lawyers who are not only skilled advocates but also effective policy makers and architecture of the just and a progressive society. So this is the reason why we always this is the reason why we always should have a connection between the classroom as well as the policy room. So with this, I would like to conclude my paper, as well as I also wanted to thank the organizing team for providing the opportunity to submit my paper.
Thank you, Professor. Thank you so much. I have no question.
Okay. Can I ask a question?
Yes, ma'am, yes.
So you are a professor of political science. That means you are teaching BA LLB students, right?
Yes, I'm teaching BA LLB students.
So your topic on legal education, I have just a very normal question, that how this legal education will balance between professional neutrality and social responsibility.
So when it comes to, we teach the BA LLB, we will teach them political science also, we'll teach them sociology also. When it comes to the sociology, it will speak about the society, what is the relationship between one person and another person. As well as when we teach the political science also, we will teach them a society, how the society came to force, how the state came to force, and what was the behavior of the humans during the early time, and what is now, how they are behaving and all. So these kinds of the basement what we are providing them, that will always make them to understand the society. On a basis of that, it will make them to understand the law subjects.
Okay. Thank you, Akshita.
Ma'am, thank you.
Thank you, Akshita, for your wonderful presentation. I would now like to invite Professor Dr. Divanshu Srivastav, Professor of Law, along with Dr. Purva Dikshit, to present the paper titled Forging Policy Reforms, Planners and Legal Architect, the Flip Side of India's Legal Education.
Thank you, Ritika. Good afternoon, panel members. I'll just take a minute to share the screen.
Good afternoon, Dr. Apurva.
Good afternoon, ma'am. I hope the screen is visible. All right.
Yes.
Good afternoon, everybody. The title of the presentation is intentional because when we speak of lawyers as policy planners and legal architects, we are moving beyond the conventional image of lawyers as dispute resolvers alone. Indian legal education has produced excellent litigators and judges, but the governance ecosystem today requires something more. Now, laws increasingly shape legislations. There is no doubt about that. They design the regulatory framework, advise executive agencies, and participate in international negotiations as well. Now, the role requires different orientation. Why do we say so? Because one that treats law are not merely as doctrine, but as an instrument of policy as well as institutional design. Now, this presentation asks how education, legal education specifically, can consciously prepare students for these roles rather than leaving them to acquire these skills informally and unevenly after the graduation. Now, understand the concept of beyond courtroom advocacy. Now, Indian legal education has historically been courtroom centric. There is no doubt about that. This was appropriate in a post independence era or phase where access to justice and constitutional adjudication were paramount. However, governance today functions largely outside the courts. Now, laws are framed through policy processes, they are implemented through administrative discretions, and operationalized through the regulatory institutions. Now, courts intervene only when these systems fail. Despite this reality, our pedagogy right now remains heavily focused on the part of appellate judgments, doctrinal mastery, as well as we're only sticking to the fewer parts. Now, students are rewarded for producing the legal outcomes rather than understanding the institutional processes. This results in graduates who are technically proficient but are often disconnected from how law operates in everyday functions and governance. The core challenge is the policy sensitive imperative. Now, this gaps bring us to the concept of policy sensitivity. Rather, a policy sensitive lawyer understands how the law operates within the economic constraints and also political priorities, institutional capacities, and social hierarchies. Law is never neutral text, okay, and it is always embedded in the context. Now, such a lawyer reads a statute and asks not just whether it is constitutional, but whether it is implementable, equitable, and sustainable as well. Now, they anticipate unintended consequences rather than reacting to them after the harm occurs. So, the basic paradox is that many law graduates already occupy the policy framing roles, yet law schools rarely train them to explicitly train them for this responsibility. Now, spaces where policy sensitive lawyers actually matter. There are three paradigms which we have figured out. First one is the legislative drafting. Now, poorly designed statutes create ambiguity, excessive legislation, and administrative paralysis. Lawyers trained in policy thinking can improve legislative quality before the problem arises. The second paradigm is the bureaucratic and regulatory governance. Ministries and regulators rely on legal advisors to interpret mandates as well as manage discretion and balancing competing interest. Now, the doctrinal expertise alone is insufficient here. This third paradigm is the pillar is the social transformation. Now, while I talk about the social transformation, we are able to understand the part of social engineering or as well as social transformation is India's developmental state. Law is central to welfare delivery, inclusion, and redistribution. Without policy awareness, and legal interventions may unintentionally reinforce this exclusion. There is NEP reform, which is a structural opportunity for all of us. Now, National Education Policy 2020 represents a significant shift in the educational philosophy as well. Its emphasis on multidisciplinary learning aligns directly with the demands of policy-oriented legal education. I know we are not directly bound by the law schools, are not bound by the NEP, but policy challenges do not respect disciplinary boundaries. They require engagement with economics, political science, technology, and ethics. So for law schools, NEP should not be treated as a compliance document. It invites rethinking of what constitutes a core legal knowledge and professional competence. The challenge lies in ensuring the interdisciplinary is a substantive rather than symbolic only. Um, what we also need to understand is that emerging domains in the legal education, let's understand emerging governance challenges illustrate why doctrinal alone is not sufficient, is rather insufficient, I would say. AI governance raises a lot of issues regarding the surveillance, algorithmic bias, accountability, and state power, none of which can be resolved through privacy law alone. Now, climate and environmental law engagement with the scientific data and international negotiations and development trade-offs can be a good combination. Now, federalism today involves fiscal transfers, institutional negotiation, and cooperative governance as well. Now, not just constitutional interpretation. These domains demand integrated as well as policy-oriented training. Now, there's also a part of experiential learning through clinics. While I talk about clinics, clinical legal education is being there, and we're nowhere through this presentation we are trying to say where it is not happening, but the kind of force and the kind of pressure it should have, it is not being there right now. It's one of the strong, like clinical legal education, as I said, it's one of the strongest pillars of the foundation for the policy sensitivity. When students work in legal aid clinics, they encounter welfare schemes, administrative delay, digital exclusion, and procedural opacity as well. Now, these experiences reveal how policy failure manifest as legal disputes. And students learn that many cases are actually the symptoms of deeper governance problems and issues. Clinics through this encourage students to think upstream towards the policy design and reform rather than the downstream of litigation alone. I'm so sorry. There is one more part which I wanted to talk about, the praxis in action, in the sense that mediation simulations are there which expose students to negotiation. It compromises, an institutional problem solving. We also need to understand that community outreach programs reveal structural exclusion, and legal aid clinics demonstrate how abstract policy languages translates into lived access or denial of these experiences. We're not denying to the part that it has not been happening. There are a lot of national law universities which are promoting these kind of, several law schools have demonstrated actually that policy-oriented legal education is both feasible, right from NLSIU to all the other national law schools. It is a open forum wherein people are exercising this, but not all law schools in full totality are being following that. Now, there are certain barriers as well. What are the barriers? Because despite these successes, structural barriers persist. Now, what do we have to do? What is the problem, core problem? That's the faculty expertise. The faculty's expertise in interdisciplinary and policy-oriented teaching remains uneven. We might be having specialized law-related expertise, but we will be lacking in interdisciplinary part. There's pedagogy in many institutions remain textbook-driven and exam-centric, which does not touch upon the part of policy-centric. Institutional linkages with policy bodies are often informal and short-term. We might have an MOU, we might have a short-term program, we might have a lecture series, but it remains stick to that only. Nothing further outcomes comes into picture. In some contexts, political or commercial pressures undermine the academic journey. It might happen in some places. And also ignoring these constraints is superficial reforms. Now, what could be done? Let's talk about the pathways form, what exactly can be done in future, reform pathways. Meaningful reform must be structural and sustained. Now, while we talk about interdisciplinary electives, which I'm sure a lot of law schools must be propagating right now, should be integrated into the core curriculum. Research labs should be there to train the students to write policy briefs, regulatory notes, and impact assessments as well. Law schools should institutionalize actually the engagement with the legislatures, regulators, and policy bodies. And these reforms are going to help the students to transition from legal interpretation to institutional design. There could also be a part of safeguarding the capacity building, in the sense that reform also requires safeguards. While we talk about academic freedom is essential for critical policy engagement, and our faculty needs continuous professional development. How do we do that professional development? To keep pace with the evolving governance challenge, ever evolving everything, because it's the two professions, doctors and lawyers, who, if we stop reading, will not be up to date to the profession right now. So we need to keep ourselves updated every now and then. Regulatory bodies must also be supporting enough for innovation rather than impose rigidity and uniformity. Now, the future vision, we wanted to take a pause and reflect about what could be done further. Specifically, three pillars are essential here. Augmented funding, sustained funding for faculty development should be there, research infrastructure and clinical programs. Secondly, technology-enabled pedagogy, including digital platforms and AI-assisted learning. We did have heard about a lot about AI in today's session. So if done properly and done in moderation, AI is specifically is going to be the future. And rather, it is the future right now. Now, public-private collaboration with ministries, think tanks, and international organizations. And without these risk reforms remains remaining elite and geographical remains uneven. Through this, let me conclude with this. I'll stick to the time because I think we are running short of time already. India's democratic resilience depends not just on good laws, but on lawyers who can actually design, critique, and reform policy responsibly. Now, reimagining legal education as a policy incubator does not dilute the legal profession at all. It strengthens the governance as well as it deepens the democracy. So we move from producing the interpreters of law to the architects of public institutions. I think on that note, I would like to end here. Thank you so much for your time.
We are supposed to ask questions because otherwise it will be unfair for the other participants. So it's a well presentation. Really, I like your flipped side, especially the flipped side of legal education. Just tell me in one sentence or two sentences that what's the present legal education curricula and the realities of the district court, the disconnections.
And what basically is happening, if we talk from the perspective from the time I'll go back to the part of where I was interning in a district court, whatever I learned, and I'll be very quote unquote, I'll be using this platform, whatever we studied and whatever is happening in the court is completely different. There are poles apart. If I know on paper that section specifically this and this talks about this particular provision, but while I talk about the drafting part, it does not match with the provision because the language in textbook and the language on a maybe contract remains completely different. If you're not going to amalgamate these two ends, it is going to be impossible for a law student. Rather, it does get impossible. I'm sure we see our friends who are in law firms. They keep on telling us maybe a student is from a very top national law school or from a private law school. They are unable to build the connect between textbook and the proper contract which happens on paper. So the disconnect is something which we're talking about, that it is not impossible. And we are not also saying that it is not being happening at various law schools. It is something which is missing at a larger area.
Yes.
And it is not an unachievable target. So private law schools like where I work can also integrate. And we are working, we're taking baby steps, but we are reaching there. And that is what the need of the time is right now. And that is the entire purpose of having this research paper.
Great. Thank you.
Thank you, ma'am.
Hello, Professor Purva. Just one contribution.
Yes.
National law schools and almost all I'm only talking about good private law schools. They're only catering to, let's say, 10% or 20% of the gentry. And I'm being very generous when I'm reaching 20%. The other 80 or 90% is still facing the problem of having regular classes. We all know how the teaching structure works. So is your presentation only limited towards the sample of the elite or the better premium law schools, or if you have suggestions for a global or for a national level workout scheme? I'm so sorry, I have a sore throat.
No problem,
So-
sir. I understood your question. Is there something which you would want to add to it?
I believe you got my idea.
I did. So the idea is to take just an example that it is an achievable target. And it is not something, it does not involve a lot of funding if it's starting with the preliminary stage. I know I did mention about as a suggestion that if funds are being infrastructure.
Funding is something that all the bodies are generous. Let's say we are also talking about established central universities and state universities. The minimum basic problem is getting at least 60% classes, because Bar Council criteria
Correct.
requires 60% classes, right?
Correct.
So,
Correct.
so we know how things are managed. I'm not taking the big NIRF names, but we do know how things are working.
Right. Right.
And in that sense, private universities, some of the private universities are doing outstanding by ensuring that the classes are running. Because I've also worked in private university, and I know how classes are ensured. So where we are talking about classes and the basic, the difference, the difference and the depth of the difference is very huge. And I totally get it when you say that we have to have more industry centric idea. We can have more additions to to our collaboration. But do we have any practical outcome that we can provide, practical suggestions that can be done to bring this aspect into our regular legal education?
Sir, I understand your question and the perspective. I will definitely take into account while finishing up this research paper, making it publishing ready. The idea behind having this research is to understand that we can have smaller targets. We're not propagating or promoting anything which is very hi-fi and which is very unachievable. We are talking about simple changes in the sense that if I want my students from a law school, from a very small law school in a very small state and a very small city, I would want them to interact with the person who's practicing law rather than the person only who's teaching law. If I make a simple change, if I include one person from a legal practitioner into my classroom, it is going to bring a smaller change. Now, with this smaller change, it is going to have a larger impact. So I'm not talking about bringing an educational shift in a jiffy, because that is impossible. Overnight changes do not happen, but small steps contribute to larger implications, and that is the idea. Through this presentation, if
So
I am able to,
let's hope we all get to see that butterfly effect sooner or later. Yeah. Thank you so
yes,
much.
sir, I'm an unabashed optimist, so I'll still promote that it is going to be possible.
It's better to
So
be
let's keep
optimist
our
because
fingers crossed.
pessimism has never won a war. Yeah. Thank you.
Absolutely, absolutely. Thank you for your insight, sir.
Thank you for this enriching presentation and this insightful discussion. I sincerely thank our esteemed resource persons, respected presenters, and all participants for their valuable contribution and active participation. With this, we come to the conclusion of session 1. I would also like to appreciate the enthusiasm of effort of those participants who are engaging with an international academic platform for the first time. I would also like to inform everyone that the result declaration session will be held at 4 p.m. Kindly stay informed through the official WhatsApp group where all further updates and information will be shared. Thank you once again. We look forward to your continued participation in the conference.
Thank you, Ritika. Thank you so much for being an outstanding coordinator here. Ritika, one question. Where should I share this mark sheet that we have been filling parallelly?
Our host.
Sir, the mark sheet, you can share it to me or you can share it on the group itself.
I'll do that.
So I will be there. Thank you so much, sir. Thank you so much, ma'am, for being
Thank you so
here
much,
today.
Srishti.
And thank you,
Thank you, Ritika, and thank you, Srishti. Thank you, sir.
Ma'am.
thank you so much. Thank you so much for all the participants who has patiently waited for all our sessions. So thank you so much. Thank you so much, ma'am and sir. Thank you.
Okay. Thank you. Bye.
We are about to start our second session in just 5 minutes. Ritika, could you please message Iksha once? Iksha, you may please start with the session.
Okay, ma'am, just give me a minute.
Yes. I request all the participants to switch on your cameras while presenting. So,
Good afternoon, everyone. I warmly welcome everyone to the second International Virtual Conference on Reimagining Justice, Law at the Crossroads of Policy, Tech and Sustainability, organized by Vedseadus Legal in collaboration with Management and Science University, Russia. My name is Iksa Gaur and I'll be the moderator for today's session. Before we begin the presentation, I would like to briefly outline the guidelines for today's session to ensure smooth and professional conduct. Each presentation is strictly limited to 8 to 10 minutes, and all the participants are kindly requested to adhere to the allotted time to ensure the smooth conduct of the session. The question and feedback round will be after each presentation, and I would like to have the liberty to introduce our resource person for this session. We are privileged to have two eminent academicians and legal scholars, Professor Mohammad Nizam Ashraf Khan, Professor of Law and Head IBSL, GD Goenka University, Gurugram. Dr. Khan holds over 12 years of academic and administrative experience and has more than 30 publications to his credit. His areas of interest include intellectual property right, taxation law, and corporate law. He has delivered lectures in several faculty development programs organized by reputed institutions such as IIT Guwahati and has received multiple national and international scholarship and research grants. And we have Dr. Manvendra Singh, Assistant Professor, School of Law, Sharda University, Greater Noida. Dr. Singh is a dedicated academician and a champion of legal aid and human rights. With over 7 years of teaching experience, he had conducted more than 100 legal awareness drives on issues such as prisoner reform, cybersecurity, domestic violence, and consumer rights. He has received several prestigious recognition, including the Governor General Legal Aid Award 2018 and the National Educational Excellence Achiever Award 2022. He is also actively associated with District Legal Aid Authority, Gautam Nagar, Delhi. We are honored to have both of you with us today. And with this, I invite our first presenter to kindly begin the presentation. I request all the presenters to remain attentive and adhere to the session's guideline. Thank you, and I wish everyone a fruitful and an engaging session. Our first presenter is Miss Sophia, and she's going to present a presentation on the title "The Right to Water in 21st Century: Management of Water Resource, Privatization, and Protection of Right of Vulnerable Communities." Miss Sophia, you can start. A I think we do not. Miss Sophia is not here. Wait. Yep. Okay, so we can start with Miss Srijita Sen. Srijita.
Hello, hello, hello,
Okay. So okay. So we
hello,
can start with hello. Okay. Let's
hello.
let's welcome Miss Srijita Sen. She's going to present a presentation on a title "Ethical Challenge of Generative AI and Deepfake." You can start, Srijita.
Srijita, can you please share your screen? I think there is some technical issue, Iksha. Can you please move on to the third presenter? We can take Srijita's presentation at last.
Okay. Then okay. So let's
Hello,
welcome
ma'am. Can you hear me?
Yes,
Hello,
I can hear you now.
ma'am. Actually, there was a sorry for the technical issue. There was a little connection problem. Can I just present?
Yes, you may present it, and before starting, you can please switch on your camera. Yes.
I'll share my screen. Just give me a sec. Yes.
Your name?
Srijita Sensor.
Okay.
Is my screen visible to everyone?
Yes.
Ma'am.
Visible.
Okay. Okay, so may I start?
Yes.
So good afternoon, everyone. Good afternoon, everyone. My topic for the presentation for my paper is ethical challenges of generative AI and deepfakes. So, good morning, respected panel members and the participants. Today, I'll be speaking about the ethical challenges that is posed by generative AI and the deepfakes. It is basically a technology that has the power to create reality, but also to distort it. It can create the reality and can also distort it. So we now live in a world where seeing is no longer like believing. AI can generate voices, faces, and events that never happened. And this, basically, this issue raises a serious concerns, ethical, legal, and social concerns. As I am from a legal background, my name is Srishti Sen. I'm studying from Christ Academy Institute of Law, Bangalore. I'm currently enrolled in a 5-year BLLB course. I'm in third year. So I have worked with the social campaigning. Like I've seen where this major problem of the actors, the Bollywood industry that they are facing. There was a major case related to the defects of the Bollywood industry. So to start with my presentation, I would like to go to the introduction. Is my slide visible to you all, sir?
Yeah.
Hello.
It is. Yeah.
Yes.
Please go ahead.
Okay, so what is generative AI? So generative AI has moved it has moved beyond the research labs into everyday life. It has been with us in our everyday life. It can create hyper realistic images, videos, voices in seconds. While this innovation supports creativity and accessibility, it also enables deepfakes. So as these voices and videos can be accessible by the AI, by that program, by that code. Basically, AI is a code that has been generated by the software engineers. So while this innovation supports creativity and accessibility, it also enables the deepfakes, content that can mislead, manipulate, and harm. Yeah, this the contents that is being created using AI can be a threat to the society. So the basic key idea is to think about the ethical risk is not just technological. It is about identity, trust, and democratic stability. I just there was a presentation just before some time where she was speaking about the TPSP Act, the personal laws that has been implemented, that has come into action from this era. So, with thinking about that law, we should also take into consideration about this, that how it can be a problem to the identity, trust, and democratic stability. So this was the introduction. My purpose of the study is understanding technologies, exploring ethical challenges, examining real world impacts, and discussing findings and recommendations. This is the objectives of my study. I have chosen this topic to focus on 4 goals. First, to understand how generative AI and deep fakes work. Second, to examine the ethical challenges they create. third, to analyze real world consequences, and finally, to suggest the recommendations and ethical solutions. So, what are generative AI and deepfakes? Generative AI refers to systems that can create original contents from prompts. Famous thing we can see in ChatGPT that is used majorly everywhere. What we do, we just give a prompt and then the things are given. So deepfakes are one such output where a person's identity is digitally replicated. So we have to understand the intent of the code, that it is so technologically it is so advanced that it can even like create a replica of the person. So that is deepfakes. We can say a notable example there is the cloning of Sir David Attenborough's voice, which raised a serious concerns about consent and misuse. What is alarming in that situation is such technology now requires little technical skill. So when creation becomes effortless, misuse can be inevitable. Misuse becomes inevitable. So this is basically like the to I try to understand what is deepfakes and AI, how generative AI can be a threat to the society. Next is yeah this Next are the key ethical challenges. So the key ethical challenges I have taken consent and identity, misinformation and trust, bias and fairness, privacy and security, and accountability and void. Accountability void. So the first ethical issue is consent and identity. People's faces and voices are used without permission, violating personal autonomy. So, a people, it is like used without their information. Even I myself can upload Shah Rukh Khan's photo and then give a prompt and then create his replica. His voices can also be replicated. Second is misinformation. Deepfakes have been used to manipulate political narratives, fabricate academic material, and distort public discourse. So, what like misinformation is basically deepfakes. Deepfakes is just a name that is being given to this concept. It is, but it basically does. It just manipulate the political narratives and fabricate the academic materials. The third is bias. AI systems often replicate societal prejudices, resulting in discriminatory outcomes. AI, what is how biasness works in this? AI AI models often AI models often inherit and exacerbate existing societal bias, leading to discriminatory outcomes in critical sectors such as hiring, healthcare, and justice. Even AI can, I have seen cases where the documents are being fabricated using AI. We being in a legal profession, I have come across many cases in my during my internships where I have seen that during the hiring process, even there is a CV checker, for ATS friendly CV checker, so that is also being used by this can be done by this generative AI. So, and finally, there is an accountability gap. It is very much unclear whether responsibility lies with the creator, platform, or developer. During my this paper, I have come across many articles and studies where I have read that it is still not yet found that from where is the source, who is the source, is the problem lies with the creator or the platform itself or the developer who has created this generative AI and deepfakes. So this is what I have gone through. These are the ethical challenges. And then I'll be speaking about the real world impact, cases, and consequences. I have taken celebrity impersonation, education, and educational harassment. So, like these are not the theoretical risk. Deepfakes have caused reputational harm to public figures, psychological distress among students, and political misinformations during elections. This we can see it has raised a serious issue and concern in India, where election commission was very much into this, and people were making false voter ID cards and even information submitting to the authorities, but it was done through generative AI. So this is how it is being played in this real world now. Also, there
Srijita,
was a famous
sorry for
case.
this. Hello, Srijita, sorry for this interruptions. You are
Yes,
running
sir.
out of time. Kindly conclude.
Okay, sir. Uh,
Come to the
Humble
conclusion part.
request to the person those who are hosting the event, kindly manage the time, behave like a timekeeper. So just inform the candidate timely. 2 minutes are left, 2 minutes are left. So we can ask time on the in the framework, and we can ask the question within the time limit.
okay,
Okay.
sir. Okay.
Otherwise, presentation is very good. We will come to this point after completion of your presentation.
Sir. So I would like to conclude my presentation by just suggesting some of the recommendations. I would like the authorities to take into consideration that there should be a consent protocol system where like this is taken through the DPSP Act. There is a consent protocol system, also mandatory labeling, bias detection and mitigation, global AI literacy, international standards, responsible research. All this I think it is necessary for ethical AI use. And to conclude, I would like to say the challenges before us is not to slow innovation, but to guide it responsibly with human dignity at its core. Generative AI is not inherently unethical, but unregulated use is dangerous. Ethical governance, transparency, and public awareness are key to ensuring AI strengthens society rather than undermines it. Thank you. Thank you, panel members, for your attention. I look forward for your insights on how this can be done and feedback.
Yeah. Thank you. Thank you so much, Srijita, for this insightful presentations on this much needed topic. So just tell me one thing. You were just talking regarding the recommendations and you mentioned one act with respect to consent. What was that? DPSP
Personal
Act.
laws, DP, personal laws.
Sorry,
Sir,
you were
the
saying
personal laws that has been implemented now.
you mentioned that with respect to consent is required. Which act you were saying that ki under that act the consent must be required? What was the name that you mentioned the act? I heard whether it was like I heard it wrongly. DPSP Act you mentioned?
Sir, yeah, DP Act. Like
Yeah,
I
it is
wanted to say
DPDP Act.
about the
Yeah,
Digital Personal Data Protection Act. I wanted to say about this.
yeah. I thought that you wanted to say that, so that is why. All right. So may I ask one question?
Yes, sir.
Okay, so I'll be just due to this short of time, I'll be just asking one simple questions related to the responsibility part on this deep sake. So deep fakes nowadays there is a lot of buzz with respect to all these AI-driven deep sake, right?
Yes, sir.
Deep
Yeah.
fakes. So
Yes, sir.
what do you believe that existing legal or ethical frameworks which we are having till today are capable of ensuring the accountability without compromising the innovation also? Or is a fundamentally new model of responsibility required? And who should bear that responsibility? Whether it should be developers or the platforms or the end users. What do you think?
So, in my opinion, I think as AI is just and like it is just a enriching topic now. It has just come up in this era. So I think there is a need for a new reformative system, like new panel system where this sector can be taken care properly. Like we have different laws for it. So I think there should be more stringent laws to this. And like as sir you said that who should be responsible for this issue. So I basically think the user, the developer, and the governance system, three should work hand in hand. Only then this misuse and the accountability gap can be reduced, and something can be done with it. Otherwise, like, from everybody have to be cautious how they are using it, who is taking it. So for that, I think there should be a strong stringent laws where this all sectors can be handled.
All right. Thank you. Over
Thank
to
you.
you, Manvin sir.
It was a wonderful presentation, Srijita, and you covered almost each and everything in your presentation. And the question is already asked by Professor Nizam sir, that I just want to ask the same question. What are the challenges? And you very beautifully answered the question. And whenever you just do any presentation, you are a law student. It's my suggestion to you that please come with certain case laws. Some case laws, you mentioned one real evidence, the name of one person, but you can come with, because there are a lot of things has to be done from last few days regarding the deep fakes from last few months, and it's a very emerging field. So definitely it's very new for everyone, like you. Even I am going to read about this thing, a lot of about this particular thing. And thank you, for
Thank you, sir. Thank you so much.
Okay. Next, next, I would like to call our next presenter, Miss Khushi Rani, and she's going to present the presentation on a title: "Is Law Biased Against Men in India?"
Am I audible, ma'am?
Yes, you may start.
Greetings to the panel. My name is Khushi Rani. I'm from Chanakya National University, Patna, second year student. I'll be presenting my paper on "Is Law Biased Against Men in India?" Is my screen shared?
Yes,
Yeah,
it
yeah,
is
it's
visible.
visible. Just start the slideshow.
Wait, sir. Is it visible, sir?
Yeah, now it's visible. Not that one, just next to zoom out. Yeah, fine. Thank you.
My topic is law bias against men in India? India actually believes in equality. Our constitution clearly says that everyone is equal before the law, no matter what's their gender, what's their caste, creed, race, etc. For a long time, society has focused mainly on a crime against women, which is important and even very necessary. But we often forget or often ignore that is the men also can also become a victim of violence, harassment, or the false cases, which is actually happening in today's India. Because of the old thinking, men are usually seen as offender and women's as a victim. This mindset has actually influenced our law system, as well as it has also led to the problem in its implementation. So my research asks a very simple question: are our laws truly equal for everyone? Because it's our constitution also in article 14 or 18, we talks about the right to equality. My questions relies here. Now, talking about my question here, India laws aims to protect the people from injustice. But in some cases, these laws are gender specific, meaning they mainly protect women. Here we need to know what law means. In jurisprudence by the Austin or Aristotle or the H.L.A. Hart, we have seen that laws cannot be defined into simple terms, but rather it's a very complex system of rules, principle, and even a command from a state in order to protect the citizen, in order to maintain a kind of a society where there is a peace in the society and deliver the justice encompassing the status. Here, when a man is accused in some cases related to the rape, domestic violence, or dowry, he is often assumed to be the guilty from the beginning. But what the principle of our constitution says, or the many judgment which has been given, even innocent until proven guilty. This is the term which has already been used here. That says it does not always work equally for men here. This create a fear, misuse of a law, as well as the way sometimes we see the justice in our state. Here, what I have already stated, the innocent until proven guilty, the term which is mentioned in my research paper in a thoroughly here. Now, when we talk about the role of the societal pressure or the stereotype that we often have in our mindset, the society plays a very important role in order to shape the laws. Men are always seen as strong and financially stable, and women are often being considered as a weak and dependent. Because of this, there are many traditional things which we have often seen, that alimony, men are usually expected to pay maintenance even when the wife is earning. Here, a lot of questions are in the high courts of many states, or even in the Supreme Courts, where a lot of judgments has been stated that alimony have to be given to those person who actually needs it. But what we see that men are usually expected to pay the maintenance. Now, the second one is the child custody. My research paper focus on this. The court often give child custody to the children, to the mothers, assuming they have the better caregiver, while fathers are ignored. Thirdly, the domestic violence laws mainly recognize women as a victim. Men who faces abuses were rarely believed and been often mocked by the society. And my research paper shows that according to NCRB data, approximately 81,000 men have faced the domestic violence in our country even. And many have, this has led to the suicides also. Now, talking about the further slides, it talks about the rise of the men rights movement. Because of these problems, men rights groups has also emerged in India. These groups do not impose or oppose women rights. They respect their rights, but they simply demand a fair, equal laws for everyone. They work to raise awareness for the male victim, demand gender neutral laws, and provide legal and emotional support. This is very important in order to balance the legal system in a country, because we often see that these are the laws. My research paper has shown that the way the laws has led the gender inequality in this system. Now, further, my research paper shows about the rise of the false cases. Here, one of the serious issue in my research is definitely the misuse of the protective laws, which has been made in order to protect the women. False cases, the number of acquittals has increased after 2023, showing many cases are not genuine. False cases harm innocent men and also weaken real cases of victims. My research paper do include the two case laws along with one Atul Shubha's case laws even, where when he committed the suicide, then there was a protest that took place, and the female was being acquitted. Female was already found the guilty, but right now no one is talking about that case, and that women has already been came out from the jail, and only the charges has only the fine has been imposed over that women. Secondly, now the fake dowry case, or the fabricated dowry cases, which is actually happening. Husband and their families faces arrest, social pressure, or the social shame and emotional trauma because of their fake dowry cases. And thirdly, the false domestic violence or claims. Some such cases damages a men reputation and family life. Even if the case is later proven guilty, misuse of law hurts both men as well as it actually hurts the genuine women cases also. When we talk about the fake law rape cases, law of rape cases has increased nearly 70%. This also subvert the cases which is actually true, and this is in our society. Now, what are the reforms that my paper said? The first reform is definitely the rape laws. It only says rape laws should be recognized male victim too, because they can also become a victim here. Secondly, the Dowry Act re-evaluation. This talks about the strict action against the false cases, which is actually happening in our society today. Thirdly, the penalties for fake rape cases should be considered here. Reportedly, as stated, more than 70% the false cases has led, and this actually affect the cases which is true even. So there should be penalties for fake rape cases. Fourth, the alimony reform should be taking place in modern world economic dynamics. We also need to put alimony to the females also, and this actually creates a gender equality in a society. Fourth, the child custody should, fifth, the child custody should focus on the child welfare, not gender specific. Law should protect victims, not to be misused as a weapon by the any gender. Now, what are the suggestions other than the reforms can be done? The first one is the sensitizing the judiciary. This is important because whenever judges or police or officers, investigation authorities or any, they play a very crucial role in this, even because the already the precedent has been maintained and the judges follow the same thing. So this should be changed. Implementing regular training for judges and law enforcement in gender sensitivity, addressing the social
Sorry for
bias
interrupting,
and
Kushi.
ensuring the fair legal interpretation.
Sorry for
Hello.
interrupting, Kushi. You should, I think you should conclude.
Okay. Secondly, the enhanced legal education and the public awareness should be created. In conclusion, my paper talks about the that in Indian law should be Indian law should not be unfair. It should be work together, uplifting women's status also, as well as to the men development and support also. They should lead to the men traumas too also. Thank you.
Yeah, yeah. Thank you, Kushi. Thank you for this presentations. It was nice presentations. I have one small question, as your topic is related to this, is laws are sufficient related to this male, right? So is there any empirical data regarding the misuse of the laws or for the protection of those? Is there any empirical data where we can say that there is the misuse with respect to the all these things which are available in form of laws?
Indeed, sir. According to the NCRB data, which I have already stated, more than 70% of the rape cases has led to the false rape cases, and even the way the suicide rates has been increased after the Atul Shabazz cases. The lot of research has already taken place, and where it has stated that more than 81,000 men has actually committed a suicide because of the domestic pressure that they get, which we often ignore as a stereotype, being as a traditional society, that men cannot become a victim of being harassed, or domestic violence cannot happen to them.
All right, all right. So how do you distinguish between protective discriminations and systematic legal bias against men?
Sorry, sir.
How do you distinguish between protective discrimination and systematic legal bias?
Protective discrimination, those discriminations which has been given to the female, but they are misusing it. This was given in order to protect them. This was given in order to make sure that their justice is being provided. But nowadays they are misusing for their own benefit. Now, when we talk about the system one, also the system has understood the traditional values thing. Now they often consider that if there is a female there, the female will not be being considered as a criminal there. Rather, the male will be the one who will get all the offenses against him, and this create a very stereotypical mindset in their judges or the policies, and which in one of the reforms which I have also said that in suggestion one, that it should enrich ourselves that gender equality should be there in both the terms in order to protect the women also, and the protective discrimination should not be there, as well as the systematic discrimination.
All right, Kushi. Thank you for this responding my questions. So over to you, Manvin sir, if you have any questions.
Thank you. It was a wonderful presentation again, and the best part is with the presentation that a female is asking about men's right. So, we need more female like her. So, because it's a very vulnerable topic. So, it was a wonderful presentation. I have no any further question. We can move further.
Thank you, sir.
Okay. Okay. Now I'd like to call our next presenter, Ms. Dimple Vyas, and she's going to present her presentation on the title Artificial Intelligence as a Catalyst for Reducing Animal Cruelty, a Pathway Towards Sustainable Development.
Very good afternoon to everyone. Myself, Dimple Vyas. I am a research scholar from Vikrant University, Gwalior. My topic of my research paper title is Artificial Intelligence as a Catalyst toward Reducing Animal Cruelty, a Pathway toward Sustainable Development. Sir, I would like to present the paper without PPT because there is some technical issue while sharing my screen. So if you allow me to present my paper, I would like to share.
Do you have means your PPT is ready, but due to this connectivity issue, you are not able to share it?
I would take just 5 minutes to present my paper properly.
All right. I think your net is not stable. Your voice is breaking.
There is some issues. So can I proceed further?
Yeah. Go ahead.
So AI plays a very transformative role in enhancing, monitoring, ethical governance, and sustainable practices across the agriculture, wildlife protection, and detecting the illegal trade to prevent the animal cruelty to support the sustainable development. Why animal cruelty is a sustainable issue, as it directly has an impact on biodiversity and the climate changes. It's very important for us to prevent the cruelty against animal to balance the ecological system. Ethical governance can help us to reduce the animal cruelty, as UN has 17 sustainable development. Indirectly, there are 4 sustainable development goals which help us to reduce the animal cruelty. That is 12, which talks about which are responsible for responsibility for the consumption of renewable and sources. Second, life below water and life on the land, and life and environmental protection. So that's how the animal cruelty plays a very important role in to support the sustainable development. Application of AI can help to reduce the animal cruelty. First, smart monitoring. Second, wildlife conservation by putting the AI drones to detect the illegal trading. Third, the ethical governance AI detector, which can help us for the smart farming. Fourth, that is very important for the to stop the factory farming. That's how application of AI has been done by the multiple countries. I would like to mention in India, wildlife protection, we have put AI drones in Gujarat to detect the illegal trading of animals. Secondly, by the Australia, AI drones were also being put up for the wildlife conservation. Third, that is Europe, who has put smart farming initiatives to reduce the animal cruelty. My topic of the methodology which I would adopt in this research paper would be qualitative and explorative, as I would go through the literature review as well as the case laws. There in present in India, we have seen cases that is relocation of the stray dog, that is in WP number 5 of 2025, whereby Supreme Court has ordered to relocation of the stray animal and to prevent us from the rabies and all. While this order was made and was being same stayed by the Supreme Court, when it was being objected by the PETA and other organizations, as relocation of dog and sterilization is not an option, while a proper shelter law and system can help the animal cruelty, because it's very important for us to maintain the ecological system. And my case study would be of A.R. Nagarajan versus Union of India, and current case laws, that is relocation of the stray dogs versus in Union of India 2008. Gauri Moleki versus Union of India's case, which has specifically emphasized that animals should be recognized as the legal sentient being, so that we can balance the ecological system as well as the help to support the sustainable development. It is very important for us to prevent the animal cruelty, and AI can help in reducing the animal cruelty. So it's very by smart monitoring, by reading the education, by providing the AI education, so that we can understand how animal cruelty to by prevention of animal cruelty we can help to ourselves to reach the sustainable development. Thank you so much, sir.
Yeah, Dimple, your voice was breaking, so there was a disturbance, so we could not hear it properly. But overall, as we gather, that your topic was a good topic and related to the themes. So thank you for these presentations. So we don't have any questions. We can move to the next
Okay,
presenter.
okay.
I would like to remind all the presenters that the time limit of 8 to 10 minutes is strictly to be followed, and I request everyone to kindly conclude within the allotted time. And next, I would like to call the next presenter, Ms. Renu Basu, and she's going to present a presentation on title "Conjugal Visit: A Step to Visit to Protect Human Dignity in Jail."
Yes, sir. Good afternoon, everyone. Good afternoon, sir. My name is Renu from Guru Gobind Singh Indraprasth University from New Delhi. Share my PPT. My topic is a presentation topic. एक second.
You are not audible. Renu, your mic is off. Please unmute.
Good afternoon, everyone. My name is Renu from Guru Gobind Singh Indraprasth University, New Delhi. My presentation topic is conjugal visits, a step to protect human dignity in jail. First, एक second, just a minute. First, we will start from introduction. Conjugal visits allow allow prisoners to meet their spouses in private. They help maintain family and emotional relationship, and these visits reduce stress and support and mental. एक second. Yes, sir. Mental well-being of the prisoners. Conjugal visits promote human dignity and a human prison system. Next slide. Meaning and concept of conjugal visits. Conjugal visits allow prisoners to meet their spouses in a private. They help keep family bonds strong and sports emotional well-being while respecting human dignity in a jail. Next slide. Importance of a conjugal visit. Help prisoners stay connected with their spouses and family and reduce stress, loneliness and emotional problems, and sports good behavior and positive attitude in the jail, and help prisoners return to society after release. And next is respect the human dignity of the prisoners. Next slide is a global practices international perspective. International Human Rights Framework, UDHR 1948, ICCPR 1966, and National Mandela Rules. First start UDHR. Article 1 is all human beings too are born free and equal in a dignity. Article 16 is a protection of the family as the neutral unity of natural unity of society. Next is International Convention on Civil and Political Rights 1966. Article 10 is prisoners must be treated with a humanity and a respect for dignity. And Article 23 is a protection of a family life. And UN standard minimum rules from treatment of a prisoners. National Mandela rules say is stress on maintaining family relations and social integrations. And next, encourages is regular family contact. Next slide is a country-wise global practices. Country-wise global practices allows is US and Europe, UK, Canada, Germany, Australia, Brazil, France, Denmark, Russia. Many countries allow conjugal visits, but India, some state allow conjugal visits. Punjab, Delhi, Madras, Maharashtra. First start. Countries allow conjugal visits. United States is a conjugal visits permitted in a limited state, earlier in the California, in New York, Mississippi, and Washington, Connecticut, and now is a United States is a family visits, and objective reduce recidivism and promote family responsibilities. Next is Canada introduced PFV, yani private family visits. Prisoners allow extended visits in a private settings. Next is recognized as a part of the rehabilitation policies. And France में इंट्रोड्यूस किया जाता है कि फैमिली लाइफ यूनिट्स जैसे VFM short form, and allow prisoners to stay with their family from several hours or day and focus on respective family life and human dignities. And next is a Brazil conjugal visits is a legal rights available to the both male and female prisoners linked with the constitutional values of dignity and equality. Maximum में conjugal visits recognized as a basic prison's right and seen as a tool of maintain social and family stability. And South Africa is a limited but progressive recognition of family visitations rights based on constitutional commitment to human dignity. Next is a condition and eligibility for conjugal visits only for a legal.
Sorry to interrupt. 5 minutes are left now.
Good conduct peoples and permission of a prison authorities required, subject to security and safety rules, allowed from a limited time period to hours in 2 months. Conjugal visits in India. Conjugal visits in India allow starting phases of Punjab, Point state. Since 2022. Implementation detail is the first state is official permitted in the Punjab. Conjugal visit in a selected prisons. 15 सितंबर स्टार्ट 2022। विजिट पैरामीटर्स है सर इसका कि गुड बिहेवियर पीपल्स को अलाउ किया जाता है 2 आवर्स के लिए अलाउ किया जाता है 2 मंथ्स में। एंड सिक्योरिटी मेजर्स से एक्सक्लूड किया गया हाई रिस्की क्रिमिनल्स को रिक्वायर मैरिज प्रूफ एंड मेडिकल इसमें मेडिकल सर्टिफिकेट की रिक्वायरमेंट रहती है। इसमें लैंडमार्क केसेस है कि जसवीर सिंह वर्सेस स्टेट ऑफ पंजाब 2014 द कोर्ट हेल्ड दैट द prisoners retain fundamental rights including to right to maintain family and conjugal relations and urged the state to allow conjugal visit to protect human dignity and the sports many states allow in the Madras state. Next is a benefit of conjugal visits. ये help करते हैं maintain family and marital bonds में, support mental and emotional well-being of prisoners में, and encourage good behavior and discipline in a jail, and aid in rehabilitation and social integrations, and uphold human dignity in basic rights में. एंड नो प्रॉब्लम्स क्या क्रिएट हो रही है कि नो क्लियर लॉ, कोई लॉ नहीं है, दिस इज ए नॉट ए फंडामेंटल राइट्स ऑन ए दिस इज ए नॉट ए फंडामेंटल राइट, इंडिया इज ए नो प्रॉपर रूल्स एंड कंजुगल विजिट्स, डिफरेंट कोर्ट व्यूज, सम कोर्ट अलाउ अदर डिनाई, जैसे पंजाब में अलाउ किया गया है, मद्रास, दिल्ली एंड महाराष्ट्र में, बट इंडिया के अदर कोर्ट्स में नॉट अलाउ दीज कंजुगल विजिट्स। लैक ऑफ स्पेस, prisoners or crowded, no private rooms, सिक्योरिटीज रिस्क एंड कॉस्टली है ये सर, और अनइक्वल है, एंड फैमिली इशू no clear law in India for conjugal visits. Courts give mixed decisions. Some allow, some do not allow. Other countries.
I think you are running out of time. You should conclude.
Okay, ma'am. Other countries allow Indian still debating problems or creating cost and securities. Since more a benefit than a right to in India. Conclude my paper. The conjugal visits help protect prisoners' dignity and family relationship, even though they are not a legal right in India. They help in rehabilitations. A balanced and regulated system can make a prison for humane. Thank you.
Yeah. Renu, thank you so much for this insightful presentations. I think there was some technical glitches, but we got your point overall. I have one simple questions to you.
Yes, sir.
In your view, how can this conjugal visits can be implemented without compromising this prison security while upholding the human dignity also?
Not understand, sir. Repeat the question, sir.
How can this conjugal visits can be implemented without compromising the prison security while upholding the human dignity?
No, sir. No, sir.
How can this can be implemented? Like you mentioned all about this consumers visits, the problems, the benefits, the challenges, the loopholes.
Yes, sir. Yes.
So how
Sir,
it can be implemented?
Sir, without law and prison authorities not progress, not सर हम उनके बगैर कर ही नहीं सकते सर, ये है ना सर। लॉज जब लॉ ही नहीं बना तो हम आगे कैसे बढ़ सकते हैं सर उन चीजों को लेके। लॉ बनेगा तो तभी तो थोड़ा इसके ऊपर हम आगे बढ़ सकते हैं सर इन चीजों को लेके। ये सर एक्चुअली में सर मेरा एम्पिरिकल है, थोड़ा मैं जेल जाके स्टडी करूंगी, थोड़ा और जान पाऊंगी इसके बारे में।
All right. So you want to say that there is some legal requirement, so law must
Yes,
be
sir.
there, then only it can be possible.
Yes. Yes.
All right. All right. Thank you. Thank you for these presentations. I
Thank you,
think
sir.
there is no more questions, so we can move to the
I
next.
have one very simple question to you.
Yeah, sorry, sir. Yeah.
No,
जी जी जी
actually,
सर।
some network issue is there, so I reconnected.
जी जी
Do we have any provision in our recent law, our recent criminal law over the conjugal visits?
Uh, no, sir. I am not visiting in the jail. I'm from मतलब सर डाटा कलेक्शन के लिए सर मैं जेल जाऊंगी सर उसके बाद मैं रिफ्रेम करूंगी बट जसवीर सिंह स्टेट ऑफ पंजाब का केस है इसमें ये रिफ्रेम सर इसमें माना गया इसमें कंजुगल विडिट्स को अलाउ किया गया था सर
आपने सर का
कोई
क्वेश्चन नहीं समझा बेटा, सर ने क्वेश्चन क्या
मेरा
किया?
सवाल ये है कि कोई लीगल प्रोविजन है, कोई धारा है, कोई सेक्शन है?
नो 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 सर नो सर अभी इसके ऊपर
अच्छा
कोई
अच्छा,
भी कंजुगल
अभी
ये
कोई लॉ
आर्टिकल 20
नहीं।
सर
अभी जो
एक्चुअली
नया
में सर
बना
ये
उसमें
आर्टिकल
भी नहीं।
20 हाँ जी सर अभी कोई लॉ नहीं बना सर ये आर्टिकल 21 के अंदर ही काउंट किया जा रहा है वैसे तो सर
आर्टिकल
लेकिन इसमें
21 तो आर्टिकल 21 इज द फादर ऑफ ऑल राइट्स। दुनिया में जो भी कुछ है, राइट टू स्लीप से लेके राइट टू नॉन स्मोकिंग तक, सब आर्टिकल 21 में ही है। वो तो
हाँ
हम
जी
उसमें
सर
कवर आ जाएगा। ठीक है,
हाँ जी सर
थैंक यू थैंक यू थैंक यू बेटा।
जी ओके सर थैंक यू सर
Next, I would like to call Ms. Parul Shukla and Dr. Santosh Kumar Tiwari. They are going to present a presentation on a title, Regulating Artificial Intelligence in Healthcare, Ethical Challenges and the Need for Coherent Legal Framework.
Good afternoon, everyone. My name is Parul Shukla, and I'm a research scholar. I'm pursuing my PhD from Gautam Buddha University, and I'm also an assistant professor of law in Marwadi University. Uh, just a second. So, one sec. Right. So today I'm going to present on the topic regulating artificial intelligence in healthcare, ethical challenges, and the need for a coherent legal framework. Uh, uh, India faces plethora of healthcare challenges, including inadequate healthcare infrastructure. Just a sec. uh, Including inadequate healthcare infrastructure, shortage of skilled healthcare professional, and a growing burden of the diseases. The incorporation of AI in AI technology in healthcare, it offers a glimmer of hope. The COVID 2019 pandemic also highlighted the status of healthcare infrastructure in India. So somehow it paved the way of integration of AI technologies in healthcare. Niti Aayog, in one of its report, AI for All, has projected that AI in healthcare is going to uh, strengthen Indian GDP by three manfold. How AI is being integrated in healthcare or how it is helping in healthcare, I am going to give two examples. Uh, AI tools like Cure AI and NMI Health Analytics, these tools are helping to diagnose the TB and breast cancer at a very early stage. And the second one is e-Sanjeevani. It perform in specialist consultation to the rural and underserved population. Now, moving forward, the ethical challenges. I'm so sorry. Yeah. The ethical challenges of AI in medical practice. The first one is autonomy and informed consent. Uh, the first thing here is the decision. AI reaches to a decision by running an algorithm on a set of data, but there is also a problem of black box of AI. So many a times, even it is very difficult for the doctors to understand that how come an AI has reached to a particular conclusion. So, if the patient is not being informed properly or is not being satisfied that why this medical decision is good for them, the entire principle of informed consent fails here. The second one is bias and discrimination. As we all know, AI requires a large data set to produce the output, but this data set is from the developed countries, and if an AI algorithm run on a data set of UK and US, the output which it is going to produce may not be suitable for Indian population, keeping the uh, social and social and structural challenges in India. The third is transparency and explainability. AI is integrated in healthcare, but it lacks the principle of transparency. And the last one is doctor AI relationship. When a doctor suggests a treatment to a patient, the doctor also take care of the uh, certain personal issues of the patient, and doctor understand the patient by the virtue of being a human connect. But the decisions predicted by given by AI, this lack this human insight or the human connect. Now, what are the legal vacuum and accountability crisis? The first core pressing issue is the liability issue. As we all know, our in like BNS says that to commit a crime, a mens rea we have to justify mens rea. But in the case of AI, that it is very difficult and impossible to decide liability, because whom should be held liable if a robotic during a robotic surgery a patient loses all his life, or a medical decision is being wrong because of an algorithmic bias? Will the doctor be held accountable, or the hospital who have deployed that robotic surgeon, or the company which have done the coding and made that robot? This is the first thing. And the second legal gap here is, as medical negligence is a fault based and human centric, there is no scope for a semi automation or a our medical negligence talks about the negligence conducted by a human, but there is no rule or no law if a negligence is conducted by a machine. This is also another big question which need to be answered. Now, moving forward with the international and regulatory approaches. As we know, AI is being integrated in healthcare and it is being used all over the world. But what is the regulatory approach towards it? WHO and UNESCO has come up with the non-binding ethical principles and the guidelines which focus on human right, fairness, and accountability. European Union is the first country in the entire world which has come up with the EU AI Act, which is a risk-based act which categorizes the risk into the 5 category, and medical AI is being categorized as a high risk. And in US, they have come up with an FDA which regulates AI as a medical device. This is the framework which is being dealt in the international approach. Now coming to the India, in India our position is very weak because we are having only two things at point on point at the particular time. One is the ICMR ethical guidelines for AI in healthcare, which has come in the year 2023, which are again non-binding and which emphasizes fairness, safety, accountability, and transparency. And another one is Digital Personal Data Protection Act of 2023, which is data centric, which talks about the protection of data, but does not talks about how AI in healthcare should be regulated. So, right. So my entire thought to on this problem is that India as a country where AI is being deployed and used, healthcare data means a very sensitive and personal data. We need a coherent legal framework, specific sector related framework for AI, which is going to address the issues which I have pointed in my previous slide. With this, I want to uh, conclude my presentation. Thank you.
Yeah, thank you, Parul, for this insightful presentation. So, as your topic is related with this healthcare sector of AI, so I have one simple questions related to patent. So, how do this patent protection of AI-based healthcare algorithm be justified?
Your question is, if AI is the inventor, so can that be granted a patent in India as per the Indian Patents Act, right? Is this the question?
Like you said, like you said that this healthcare algorithm is there.
Right.
So if that AI-based healthcare healthcare algorithm is there. So how can the patent protection can be given to this AI-based healthcare algorithm, and it can be justified
To
when
answer
ethical
your
obligation.
question, in US, in one of the recent cases, US court have agreed that AI can be the inventor, but when it comes to the India and as per our Indian Patent Act, still to be an inventor, the first requirement it should be a human. So right now in India, we are not recognizing AI as an inventor.
Can you tell the name of that US case where US has decided that AI can be the inventor?
Sir, I cannot recall it.
Where have you read this one?
Uh, sir, one of my colleague was making his research proposal. So his topic was this, like why AI cannot be an inventor. So in that we discussed it, and there I have seen it.
As far my knowledge, there was a case related to this dishwashing invention of dishwasher machine. There were two inventions, but this US Patent Office, they have rejected, and they have only said that the only the human creations can be the inventor. So till now, they are also not settled on this point. So there is a lot of what you can say that the changes can happen in future. So that let's see what happens. So all the countries are thinking or making some policy related to that regulate. All right. Thank you. Thank you, Parul, for this presentations. Over to you, Manvin, sir.
I have one question to you, Parul, that which particular prominent areas where we can use AI in the healthcare? Because the using of AI over the healthcare, it may be a beneficial, or it may be a disastrous. Because
Sir, the like AI is being used in many areas, but as far as I believe, the two prominent areas where AI is very like AI have shown the remarkable result. The first one is the diagnostic and prediction, like how I was telling you about in my presentation about Nirmai Health Analytics. It's a startup in Bangalore, and in India, still the breast cancer is being tested by manually touching. But this Nirmai Analytics, they ask the patient to go for a thermal imaging, and by running the algorithm on the thermal image of the breast of a woman, they predict the cancer way in advance. Like the example is 30 years before the cancer is going to like if the occurrence of cancer is after 30 years, they are predicting it now. So this is the one, like in India, this chronic illness like cancer, the first point is the patient get to know at a very later stage, and when the treatment start, the time is already over. So the very how crucial AI here is, it's detecting at a very earlier stage, and even before the tumor or the cancer starts building up, and then suggesting the line of treatment. That is the first thing. And the second core area which I believe is R&D. uh, like for research and development, we require a huge number, large set volume of data, and it is very difficult to manage all this data. And even if it comes with our even medical record, see, as now AI, now we all are having our digital health ID, which is same like an Aadhaar card. So, like if you have gone to several hospitals in your entire lifespan, rather than you preserving your prescription, it is all being preserved at a very one point, which is again digitalized. And once you take admission in any of the hospital, the doctor can see your all your past medical history and records in one click, and then can suggest your treatment. So I believe these are the two very core areas where AI has shown remarkable results, as per me.
thank you, thank you. Wonderful answer.
Thank you, sir.
Last, we have Ms. Suvigya Saxena and Dr. Lakshmi Priya, and they're going to present a presentation on the title Healthcare Governance in India, an analysis of law and policy at the crossroad of justice.
Thank you. Am I audible clearly?
Yes, sir.
Yeah. Yes. Good afternoon, everyone. Good afternoon, esteemed faculties present and the fellow presenters. Please allow me to share my screen. Is my PPT visible?
Yeah, now it's visible. Please go ahead.
Okay, sir. So yes, good afternoon, esteemed professors and the fellow presenters. My name is Suvigya Saxena, and I'm a PhD scholar of law at Uttaranchal University, Dehradun, uh, under the supervision of Dr. Lakshmi Priya Vinjamuri. She is the professor of law at Law College, Dehradun, and I'm going to present my topic on healthcare governance in India and analysis of law and policy at the crossroads of justice. We have seen enormous growth in the healthcare sector, especially in the past decade, and all the efforts that the government has made was just to ensure social justice so that fair and equal access to healthcare is ensured for the last citizen of this country. And under the initiatives, we have seen the National Health Policy was rolled out in 2017, which focused on achieving universal health coverage through principles of affordability, accessibility, and equity, laying the groundwork for a more just healthcare system. We must have also heard about the term Ayushman Bharat. So this is the umbrella term under which basically it is the umbrella scheme under which various initiatives have been launched, and this aims at achieving the universal health coverage in India. Three prominent schemes are Ayushman Bharat Pradhan Mantri Jan Arogya Yojana. Then there is Pradhan Mantri Bharatiya Jan Aushadhi Pariyojana, which is PMBJP, under which Jan Arogya Kendras, the generic medicine stores, have been established. So, and then there is Ayushman Bharat Digital Health Mission, which is also the NDHM, National Digital Health Mission. So, just a brief about both the not the three of them, but just the two of them. The Pradhan Mantri Jan Arogya Yojana is a flagship scheme providing health coverage of 5 lakh rupees per family annually for secondary and tertiary hospitalization to over 500 million beneficiaries. That is 50 crore beneficiaries, enabling a cashless treatment across a vast network of public and private hospitals. And it covers 1900 plus or approximately 2000 medical packages, medical treatments. And side by side, we have Jan Arogya Kendras. There are 16,000 plus outlets in India currently running in 25 to 2025, which sell generic medicines at 50 to 90% lower costs to the people, which has reduced the out of pocket expenditure of the citizens to an estimate of 70%. So these are very great initiatives by the government uh, to ensure social justice. But there is another aspect that we need to look upon, that is whether substantial justice is ensured or not, and that we will be talking about in this particular paper. Uh, just to brief the healthcare jurisprudence in India under the Indian laws and regulations, we can see that the right to health is it's not just a policy objective but a constitutionally protected right under Article 21. Then we have various other articles under the directive principles there are key pronouncements of the Supreme Court, which includes Paschim Banga Khet Mazdoor Samiti and the Olga Tellis versus Bombay Municipal Corporation, and Mohinder Chawla. So all these landmark judgments, they are there, that emphasizes the importance of healthcare with respect to the right to life in India. Then, talking about this legal framework, so despite a constitutional backing, the practical framework remains fragmented, comprising various statutes like the Clinical Establishments Act, National Medical Commission, then Consumer Protection. Then there are NHA rules and guidelines, NDHM guidelines and policies. So, and it's all fragmented, and it often lacks a cohesive integration addressing a particular issues. Um, then moving further, what are the challenges that we face, or that we can talk about under the Jan Arogya Yojanas and the other initiatives that the government has taken, specifically to the PMPG, the Jan Arogya Yojana I'm talking about. So there are significant gaps in grievance redressal mechanisms. When we are talking about substantial justice, we also need to look into grievance redressal mechanisms, which undermine the promise of equitable health care. Uh, when we the prominent challenges that we can look at is the inequitable access. So basically, there is a lack of awareness among the beneficiaries. The people are not aware that there exists a grievance redressal mechanism also. First of all, we need to understand why is a grievance redressal mechanism required. It's like in a broader perspective, we can think that thinking about enforcement of fundamental rights without the existence of Article 32. So that is quite impossible. Similarly, without having a proper grievance redressal mechanism, any good initiative or policy will lack implementation, effective implementation. It will lack effective implementation. And studies have suggested that 85% of the population, the beneficiaries under the scheme, are actually unaware of the existence of
Sorry
such
to
grievance redressal.
sorry to interrupt, but Shubhagya, I think you are running out of time. You can just wrap up this your presentation.
Okay, sure.
Okay.
I'll just do it. Um, so yeah, so I'll just give a brief overview of the grievance redressals. So there is a 15 days time under the policy, which says that if a grievance is registered, so it should be wrapped up in 15 days time. But how it will be done, that there is no procedure described therein, which erodes the public trust. Then yeah. Specifically in the state of Uttarakhand, we have different challenges. Uh, there are remote access barriers like the tribals, the hilly regions. Um, they face severe access issues, twice the rate of treatment denials. In the district of Chamoli, it struggles with infrastructure overload. Then such kind of things exist in the high altitude states like Himachal and Uttarakhand. Specifically, I'm talking about Uttarakhand here. Then what are the pitfalls if we look at? So
Yeah,
basically,
Suvigya, yeah,
yes, sir.
you can just come to the conclusion.
All right, all
What is
right.
your conclusion and
Yeah,
suggestions? If you
basically suggestions I'll be talking about. So we simply suggest two reforms. That is, one is statutory and regulatory. So they need to be a special enactment for monitoring and regulating of grievance redressal mechanisms. And regarding the regulatory part, there must be timely and quality audits by independent authorities. And awareness drives must be there for the generic medicines. Stricter regulations for medical practitioners to ensure prescription of drugs and not specific branded medicines. That's all. These are the references that I'm taking into, and that's all from my side.
okay, Okay, all right. Thank you, Suvigya, for this wonderful presentations. So I have one question. Like, given this India's fragmented healthcare governance across the union, state, and private sector, how can the law realistically reconcile constitutional commitments that have been given under Article 21 and Article 47? With market-driven healthcare delivery without diluting this accountability or access to justice for marginalized patients.
So actually, since healthcare is the concurrent subject, so a central legislation could be worked out in this respect, apart from giving states specific autonomy to adjust to their requirements, and a proper legislation can be made which allows, which actually have a kind of a statutory authority that actually monitors the kinds of grievances that are registered.
Okay, all right. Thank you. That's all from my side. Over to you, Manmin sir. So I think there is no more questions. So we can conclude here. Thank you, Suvigya.
Thank you,
Okay.
sir.
As we come to the conclusion of the session 2, I would like to extend my sincere gratitude to our esteemed resource person, Professor Mohammad Nizam Ashraf Khan and Dr. Manvinder Singh, for their invaluable insight, guidance, and thoughtful observation, which greatly enriched this session. And I also congratulate all the presenters for their well-researched paper and meaningful contribution. And I thank the organizing teams and participants for their cooperation and discipline.
Thank
Thank you,
you, Iksha.
everyone.
So can we leave now?
Thank you so much, sir. Thank you so much for
All right,
joining
all right.
today. Thank
All
you.
right, Srishti, thank you for giving this opportunity. It was really wonderful that you are organizing such an important topics, the conference on such important topics, and the presenter was really good. So
Thank you so
all
much.
the best for this. I'll be sharing the score sheet. So
Yes, sir. Thank you so much.
thank you.
Thank you, Srishti, for inviting me for the second international virtual conference. And it was a pleasant experience. The scholars were wonderful. And there are many paper that is on AI and healthcare. So they all are the emerging fields. And definitely will come with some, publication out of this conference. Then it's a wonderful initiative. This is my suggestion only.
Yes,
Uh,
sir.
Otherwise, your team play a wonderful, organizing a wonderful event at the beginning
Thank
of
you
the
so much.
year, and I hope that at the end of the year, by the end of the year, we are having more event like that. Thank
Thank
you.
you, sir.
Thank you,
Thank
everyone. Thank you.
We will be starting with the third session in just 5 minutes. Uh,
Good afternoon to all the distinguished guests. respected resource persons, fellow participants, and dear students. A very warm welcome to the second International Virtual Conference on Reimagining Justice, Law at the Crossroads of Policy, Technology, and Sustainability, organized by Vedseadus Legal in collaboration with Management and Science University, Russia. I am Anjali Patil, a core member of Vedseadus Legal, currently pursuing my BLLB from Pimpri-Chinchwad University, Pune. It is truly an honor and a privilege for me to serve as the moderator for this session. Thank you, ma'am. Before we begin, the paper presentation for session 3, I would like to introduce our resource persons, Dr. Soumi Chatterjee, ma'am. She is a researcher and academician. Yes, ma'am, you're audible. She is an author, researcher, and academician, and the founder and CEO of SRTD Group, LLP, and Vidhi. She holds a BLLB honors from Rajiv Gandhi National University of Law and a PG diploma in corporate laws from the Indian Law Institute, an LLM in business laws, and a PhD on the socio-legal study of the misuse of anti-dowry laws. She has practiced before the Delhi High Court, worked as assistant legal manager at Tata Teleservice, and served as assistant professor at reputed institutions, including Noida International University and GLA University, Mathura. Dr. Soumi Chatterjee is a certified trainer in gender sensitization, diversity and inclusion, and POSH, also awarded by Institute of Scholar in 2021. After from the facilitator at Vidhi Seva and Samajik Uttahan Samiti and the editor-in-chief of Doon Journal of Multidisciplinary Research. We are truly honored to have you with us today, ma'am. Now we have our second resource person, Dr. Raman Bharadwaj, is a dedicated legal academic researcher and mentor with over a decade of experience in teaching, research, academic leadership, and litigation. He is currently served as assistant professor of law and academic coordinator of G.H. Raisoni University, Nagpur, and is also CEO of Better Law. His focus on personal law reforms, interfaith marriage, and the Uniform Civil Code, with publication in Red Law Journals, and awarded-winning researcher Dr. Raman Bharadwaj usually contributes as a judge and resource person at Moot Court and National Conference, and the editor of the Swami Vivekanand Advanced Journal for Research and Study, recognized as top voice in mentoring and LinkedIn. He is deeply committed to shaping future legal professionals. Sir and ma'am, we are privileged to have your presence with us today. Now moving forward to the paper presentations, I request all participants to strictly adhere to the allotted time. Before we proceed, I would like to outline the guidelines for our presenters. All presenters requested to strictly adhere to a limit of 8 to 10 minutes. A brief question and feedback round with follow immediately after each presentation. Okay, now we'll start with our first participant, Mayank Maheshwari. Mayank Maheshwari, we will
Good
start
afternoon,
with
everyone. Hope I am audible.
Yes, sir.
Yeah. Allow me to share the screen. Just
Name is Mayank Maheshwari.
yes, sir.
Okay. Allowed. Yes, your screen is visible.
Okay, sir. So, good evening, esteemed guests, fellow presenters, and the organizing committee members. Today, I am here to present the research on law as a catalyst for socio and economic policy reforms. I am Mayank Maheshwari, a student of the Alsing College, second year philosophy department. So, this presentation examines how law plays an active role in shaping social and economic policies in India. Instead of treating law as a mere system of punishment or dispute resolution, the study shows how constitutional provisions, judicial interpretations, and welfare laws help reduce inequality and promote justice. The research focuses on how law becomes a driving force for policy reforms. Law is not limited to courts and punishments. It gives direction to government policies related to food, education, employment, and health. Pound believed that law should actively shape society. According to him, law balances competing social interests and brings social changes. In India, this idea is reflected in laws abolishing untouchability, preventing child labor, and promoting gender equality. Law is therefore not passive, it actively reforms society. And according to Pound, law functions as a tool of social engineering. Law performs three major functions, which is normative, instrumental, and protective. Firstly, it establishes values like justice, equality, and dignity. Second, it provides tools to design welfare programs. Third, it protects marginalized groups such as women, workers, Dalits, and the poor. These functions make law central to policy reforms. Austin described the Indian Constitution as a social revolution document. This means it was designed to perform society by removing caste, hierarchies, poverty, and discrimination. Fundamental rights and directive principles together to guide the state to create welfare oriented policies. The preamble of the Indian Constitution provides three types of justice for the people of India: the social justice, economic justice, and political justice. The preamble promises justice in three forms. Social justice aims to reduce caste and gender inequality. Economic justice ensures fair distribution of resources. Political justice guarantees participation through universal adult franchise. All policies must align with these constitutional goals. The, the rights provided in Article 21 are further extended in the form of right to life, right to livelihood, and right to right to education. The different Case laws, including Menka Gandhi 1978, established that procedures must be just, fair, and reasonable, opening welfare-based interpretations. The right to food during the drought faced by the state converted food schemes into legal entitlements. Starvation constitutes constitutional failure. The case law Puttaswamy 2018 recognized privacy as fundamental rights, which list addressing digital welfare mechanisms. And Olga Telly's case law 1985 integrates right to livelihood to right to life. Eviction without rehabilitation violates Article 21. India, a nation with a different type of socio-economic disparities, includes economic inequality. Economic inequality is shown by different numbers, which says that a small amount of population has a large amount of wealth of the country, and the informal sector of the country employing 90% of the workforce. Social stratification or social inequality in the base of caste-based exclusion persists persists in India till now, even after the law implementation. Gender wage gaps in informal sector is a common practice faced, which shows that the wage paid to the women is a lot less than of the men's. The digital data divides excludes many from welfare benefits. This shows the limits of legal reforms without strong implementations. Equality and affirmative action. Article 14 guarantees equality, but equality does not mean treating everyone the same. EP Royappa held that arbitrariness violates equality. Indra Swani justified reservations to correct historical injustice. Law supports substantive equality through special measures. Policy instrument or welfare laws which provides the rights to the people and are called as social and economic policy reforms includes NFSA National Food Security Act 2030, Manrega Manrega 2005, and Right to Education Act 2009, and also the direct benefit transfer schemes of the government. These laws convert welfare into legal rights. NFSA ensures food security. Manrega guarantees employment. RTE promotes education. DBT improves efficiency and education. However, implementation issues reduce their effectiveness, showing a gap between intent and reality. The implementation paradox includes corruption, bureaucratic delays, and weak monitoring. Even strong laws fail due to poor implementation. Corruption causes leakage, delays reduce benefits, monitoring is weak. As said by B.R. Ambedkar in a way of warning, constitutional morality requires ethical governance, not merely legal text. Laws without implementation betray constitutional promises. Global and technological dimensions. International human rights law recognize socio-economic rights. Indian court use these norms. Technology improves delivery but can exclude the poor, and the sustainable policies must balance welfare with environmental protection for future generation.
Sorry
The
to
policy
sorry to interrupt. Kindly please conclude. I request all the presenters to adhere to the time limit.
Yeah, sure, I'm concluding. The policy recommendations and the conclusion includes strengthening the infrastructure, improve literacy, and ensuring accountability. Reforms must focus on capacity building, digital and financial literacy, transparency through social audits, and strong grievance redressal system. Law has the power to transform society by institutionalizing justice and dignity. However, rights without implementation remain hollow. True reform requires constitutional morality, administrative strength, participatory governance, and inclusive technology. Thank you.
Hello, Anjali. Anjali, am I audible? Hello.
Yes, Shubham, you are audible.
Okay.
Yes. Anjali, please move on to the second presentation.
Srishti, are we supposed to ask questions at
Yes, yes.
right now?
Yes, ma'am, you can.
Yes,
Yes, ma'am,
ma'am,
you
I'm
can
so
ask
sorry.
questions, Mayank.
Okay. Raman sir, do you have any question or shall I ask some questions?
You can ask me.
Okay. Mayank, it was well spoken. Congratulations.
Thank you.
Raman, what I felt was that, when you are presenting for a conference and writing for a research paper, okay, you need to focus on one thing, pinpoint what the issue is, right? So you spoke about policies, you spoke about various principles, you started with jurisprudential principles and stuff, and you spoke about various policies. So generally, I want to know your opinion on, and you also spoke about castes and other system, right? So do you think equality and inclusivity are the same? And if so, how does the law address these structural inequalities in societies like gender, class, and say, for example, disability maybe? So there are inequalities,
Yeah,
right? You spoke about inequalities.
yeah.
So first, is equality and inclusivity same? And the second is, how does law address these structural inequalities in society that exists in the form of caste, gender, class, like that, like so on?
Yeah, so equality and inclusivity, maybe they are not same, but can complement each other in a way. If the equality provides the equal rights or equal distribution, on the other side, if the equal rights and equal distribution of the things will be there, the society will include the persons having because it is based on caste and it is based on gender, and if the rights are equal, the inclusion will be directly or the complementary or the consequence of the equality. And
Second one.
coming to the second question, can you repeat the second question, please?
But my second question is, how does law address these structural inequalities in society like caste, gender, or say that specifically caste, when you as you mentioned the caste in your slides?
So as but the law has its provisions and policies based on caste, but as per the it depends on the implementations of the policy, which is focused in the paper as well, that the implementations of the laws in the form of policy in the societies make the law ineffective or effective. The laws are still existing on the inequality on the basis of caste or gender in every field, but it is the basis that the awareness of the laws and the implementation of the laws can make even the existing ones effective. Thank you.
Mayank, may I?
Yes, sir. Yes, sir.
Am I audible to you?
Yes, sir.
Mayank, as your topic is like law as a catalyst for the social economic policy reform. So, is there anything like a welfare state still existing?
Sir, kindly can you please define the question?
You are saying the law is acting as a catalyst for the social change, right?
Yeah.
So, is there still the existing the concept of social this welfare state? Like you have discussed about the various caste system, all.
Yeah.
The,
So,
yeah.
yeah. So there is a welfare state, or can say a need of a welfare state. It's not completely in India. There is not caste. Maybe the caste inequality is decreased till an extent, or the gender equality is decreased till an extent, but still the cases are sustaining. And on the other side, the uh, most vulnerable inequality, or the most vulnerable thing in the Indian state, is the economic inequality or the economic disparity, which shows the need of the welfare state, where the where the welfare is needed.
I think Sir is going through some network issue.
Thank you, Mayank. There is a disruption in the network, right? Thank you.
Thank you, sir. Thank you, sir. Thank you.
We can have the next
Anjali,
participant.
please modify.
Yes, our next presenter is Diksha Sharma. She is presenting on the topic Regulating Big Tech in India, Corporate Governance, Challenges in Data Protection and Competition Law. Diksha, you may proceed with your presentation.
Okay. Am I visible?
Yes, yes.
Okay, okay. So, good afternoon, everyone. I'm Diksha Sharma, a fourth year BLLB law student at Sharda University. And today I'm going to present my presentation on regulating big tech in India, corporate governances, challenges in data protection and competition law. So coming to the introduction of my topic, the rapid rise of the, as we all know, the rapid rise of the big tech corporations such as the Google, Meta, Amazon, and Apple has redefined the nature of corporate governance in the digital economy. And these platforms enterprises no longer operate merely as market participants, but as infrastructural gatekeepers controlling access to data, the digital markets, the consumer behavior, and the public disclosure. In India, where there are over 850 million users are digitally connected platform-based services, mediate a majority of online commercial transactions, social interactions, and the information flows. However, Indian regulatory responses remain fragmented across the corporate governances, data protection, and competition law, each functioning within their own doctrinal silos. So this disconnect has enabled systematic digital harms such as the data monopolization, the algorithm self-preferencing, the exploitative consent practices, and the exclusionary market conduct to persist without effective board level accountability. Now, why? What is the problem now? Why am I researching on this problem? Because the corporate governance's norms focus mainly on the financial disclosure and shareholder value maximization. Their main focus is the monetary profit, but they ignore the digital risks such as the privacy erosion, the algorithmic discrimination, the data manipulation, the self-preferencing practices, and meanwhile, the directors rarely held accountable for these digital compliance failures. Now, my objective of this research is to analyze the corporate governance challenges posed by these big tech platforms in India and to examine the impact of the DPDP Act on corporate compliance architecture, to evaluate the effectiveness of competition law enforcement in addressing the data-driven abuse of dominances, to assess the adequacy of the director duties under the Companies Act 2013, and to propose a harmonized governance model integrating the corporate law, the data protection, and the competition regulation. Now, we all know that in India is a huge data economy. We have more than 850 million internet users and over 70% data transactions mediated by these platform ecosystems such as the Google, the Meta, the Amazon. Google independently controls the 95% of Android's OS system, operating system, and the Meta dominates the social media engagement through its apps like such as the Instagram, the WhatsApp, the Facebook. So market power now is driven by the data, not the physical assets. So coming to the DPDP Act, what are its key features? Now the first is the consent-based processing. Section 6 requires the free, informed, and ambiguous consent with easy withdrawal. But in CCI versus Meta 2024 case, we have seen that WhatsApp was fined 213 crore for forcing the bundled consent for data sharing, demonstrate that consent mechanisms in dominant platforms often operate coercively in practice, and uh, other than the section 6, under section 8, data fiduciaries are obligated to often operate coercively in practice. And they the section 8 ensures that data accuracy, implement reasonable security safeguards, and report breaches. However, the Star Health Insurance data breach case in 2024, it exposed the sensitive medical information of millions of policyholders, revealed how technical compliances without governance oversight fails to prevent large-scale harm. Section 11 to 14 grant user right of access, coercion, eraser, and the grievance redressal. Yet in 2025, the Editors Guild of India publicly flagged gaps in grievances redress mechanism affecting the digital media users, and it highlights the weakening in rights enforcement. Furthermore, to enhance obligations such as the appointment of data protection officers and independent audits, the Act imposes no express duties on the corporate boards or the directors for privacy failures, as reflected in the absence of board level liability, even after the Meta WhatsApp penalty. Thereby, it clearly demonstrates that the DPDP Act standing alone is insufficient to address the systematic governance failures in big tech enterprises. Now, if we talk about the competition law enforcement in India, as the Section 4 of the Competition Law 2 seeks to curb abuse of dominant positions by digital platforms, particularly where market power is reinforced through the control over data and network effects. In the landmark case of Google versus Android case, 337 crore for forcing the OMEs. The CCI imposed a penalty for forcing the OMEs to pre-install Google's proprietary apps, thereby it distorting the competition in the mobile operating system market. where the Google commands nearly 95% of market share in India. So this was also followed by the Google Play billing case, where a further 936 crore penalty was imposed for imposing unfair payment conditions on app developers, limiting the alternative billing system. And similarly, as we have talked about the CCI versus Meta 2024 case, WhatsApp was fined 213 crore for mandating the data sharing with the Meta entities, combining the privacy violations with the competitive harm. While there's this another case, Make My Trip Georgetown case in 2023, the CCI found deep discounting and exclusive agreements to be exclusionary conduct pursuing the competition in online travel markets.
Diksha, please conclude. Hello, Diksha.
Yes.
Please conclude.
Okay. So, looking all these regulations, my core argument here is that the big tech regulation in India must shift from a reactive penalty-driven model to a preventive board-driven approach. And existing frameworks under the Competition Act, SEBI and DPDP Act provide a foundation but are inadequate for addressing the complex data-intensive and platform-driven risk of the digital economy. And effective governance requires anticipatory oversight, accountability at the board level, and integration across the corporate data protection and a competition law to ensure the directors not only comply formally but also effectively safeguard stakeholders and fairness. Now, there are these enforcement gaps that I have told that exposed enforcement. Digital competition law committee report also finds that current framework reactive and not preventive in digital markets. There's no structural remedies, there's no algorithm audits and no board compliance certifications. As in comparison to the European Union, their laws such as the GDPR and the Digital Markets Act, the Digital Services Act, they are more stricter as in comparison to DPDP Act. And my recommendations is to make a mandatory board level technology ethics committee. We could have made the algorithm transparency audits, risk based digital compliance reporting, harmonized enforcement across regulators, continuous digital risk training, and stakeholder inclusive governance, mandatory AI and data breach reporting frameworks, and internal ethics and compliance innovation labs. So these will strengthen the corporate accountability. It will reduce the privacy and antitrust violations, fairer the digital markets, and it will promote the sustainable innovation ecosystem. In conclusion, I would say the digital economy presents unique opportunities and risks that traditional corporate governance frameworks alone cannot address. To ensure responsible growth, big tech regulations in India must be preventive, board driven, and integrated across corporate data and competition law. By adopting proactive oversight and transparent practices and harmonized enforcement, we can create a balanced ecosystem that protects the stakeholders, promotes fair competition, and fosters sustainable innovation for the future. These are some of the references, and thank you for patiently listening to me, and please feel free to ask questions or share feedback. Thank you.
Hello, Diksha. Am I audible to you?
Yes, ma'am.
Am I clear? Okay. Great presentation, wonderful topic. You spoke a lot about accountability. You spoke a lot about algorithms and AI, right? And so, because today is the age of when we are using a lot of AI, when we are dependent on a lot of algorithms that we run and we try to understand. We still are in an age of understanding how AI works, how data should be protected, and a lot of stuff is going on, right? It's very new for everybody around, even for the corporates, right? So, what is your opinion or view on, like, in case of accountability or responsibility, corporate accountability or responsibility, who bears it for this kind of an algorithm? If in any case there is an algorithm harm, okay, some harm is done to the algorithm, so who bears the responsibility? Management, it's the corporation itself. Who do we put the accountability on?
Uh, Ma'am, in this particular case, I would say if uh, if there is a very active high level fraud, then the directors must be held accountable. And if the algorithm risk is not that much of great level, then the management should be held liable. In case of directors, the doctrine of corporate veil must be incorporated, must be uh, must be put to unveil their corporate liability. And if there is no high risk in the algorithm, then the management should be held liable. Hello. Hello.
Yes, Diksha.
Am I audible?
Yes.
Yes, Diksha, you are audible. I believe there is some network issue.
Yes,
Sir,
Diksha, uh, may I ask a question?
Yes, sir.
Diksha, how can this Competition Commission of India address this algorithm collusion by this big techs? What is your suggestions on this?
Mm,
How they will regulate this?
uh, so I think the CCI must follow it should have uh, spread the awareness among the customers which are using these apps, and it should make the more strict laws to regulate, and the to it could have the enforce the some rules and regulations, so that so that to manage that no harm is done to the users, to check if there is any self-preferencing or algorithm audits. It could have made the committees for each companies, for each big tech platforms for auditing the algorithm risk.
So means you are saying that there should be awareness programs from by the CCI, right?
Yes, and there should be committees on to audit the algorithm risk.
Okay, right. Thank you.
Thank you, sir.
so our next presenter is Harshita Kamaryal with the topic Law and Technology Transforming Justice Delivery. Harshita?
Yes, ma'am. Am I audible?
Yes, you are audible. You can start the
Okay.
presentation.
Okay, ma'am. Wait, let me share the screen. Mm. Is it visible, ma'am?
No.
Not
Okay. Okay, ma'am. Just wait a second. What's the problem? Okay. Hello.
yes, Harshita.
Okay. Now is it visible?
No, you need to do the entire screen option.
Okay. Wait. It's facing a problem on it.
Okay, if the panel allows, you can proceed with without the presentation, and you can just proceed with your presentation.
Okay.
PPT.
Okay. Wait. You are shared.
Yes, now your screen is visible.
Okay, okay.
Yeah.
Okay. So good afternoon, everyone. Ma'am, am I visible also?
Yes, your video is off, but still you continue your presentation.
So good afternoon, everyone. This side Harshita. I am a law student, BLLB honors of fourth year, and I am from Sharda University. So today I'm going to present my topic, law and technology transforming justice delivery. So I'm gonna introduce my topic. So justice is the foundation of every democratic society. For the centuries, legal system has functioned through traditional method like courtrooms, paperwork, and manual procedures and physical hearing. While the system upheld the rule of law, it also faced serious challenges such as delays and high costs, limited access of to the common people, and overburden of the courts. So, if we see in the 21st century, as there is the changes as the technology has been came up, so we have seen a rapid growth on it as it has begun to redefine the ways of how the justice should be delivered, and the integration of law and technology, how it has emerged as a powerful force in the transforming of justice delivery system. Today's now digital court, artificial intelligence, online dispute resolution system, and blockchain technology has been introduced, and also the smart contracts also. They are already reshaping the legal practice across the world, including India. So after the COVID-19 pandemic, if we see that the it has accelerated the transformation, virtual hearing, e-filing cases, online legal services, and AI-based legal researches, because essential tools for ensuring that justice continues even during the global disruptions. Technology has made the justice system more accessible, transparent, efficient, and inclusive, especially for those people who are marginalized and remote communities. However, the transformation also raises important legal and ethical questions, issues and related to the data privacy, algorithm bias, regulatory challenges, and human control over the technology demand careful examination. Therefore, the presentation explores how the evolving relationship between law and technology is transforming justice delivery, while emphasizes the need for a balanced approach where technology serves as a supportive tool, not as a replacement of judgment. So, my purpose of the study would be here how it has enhanced the justice delivery, improved judicial efficiency, expand access to justice, and how it created the legal challenges in the Indian judiciary. Objective of this study is to examine the evolving relationship between the law and technology. This study also aims to understand how the technology advancement are influencing the structure, functioning, and the efficiency of legal system. To analyze the role of emerging technologies in justice delivery, it also specially focuses on the artificial intelligence, blockchains methods, smart contracts, and also the online dispute resolution which has been introduced, and how these all the technology which are introduced are reshaping legal procedure and courtroom processes. To evaluate the impact of technology on judicial efficiency and accessibility, and also to identify the benefits and limitation of the technology integration in the law, to examine its ethical, legal, and regulatory challenges, and also to propose a balanced and sustainable approach for the future. So let us see the how the justice system has been evolved. So from if we see from the past, there were the traditional system like the traditional models of the physical presence and tangible documents, and often resulting in the systematic inefficiency. There was also paper-based procedure where court historically managed an immense volume of the physical files, the manual tracking of the prone document, which might lose, damage, and significantly administrative delays might also have been occurred, where the long delays of the cases, backlogs, with the system also has been faced the high cost of the litigants, like a litigant faces the very expensive cost of the legal fees, physical paperwork, and repeated travel of the travel costs from one place to another. And also it has the limited access for the marginalized groups, particularly for the rural and remote areas which struggle with the geographical distance and lack of information about their legal rights. Now if we have seen further how the traditional justice system was there. Now if we see after like in 21st century, when the AI and technology have been came across the law, so how this has transformed. So now we will see the technology driven justice system, where the digital courts and paperless ecosystem has been initiated in digital courts to 2.1, which allow the judges to access all the cases related to documents, evidence, aiming for complementary paperless court environmental work. By the late 25th, over 597 crore pages of the courts recorded has been digitalized in Indian alone. E-filing and virtual hearing also has been introduced for the Supreme Court, High Courts. So it has given a very brief, or you can say wide range of the options of the accessibility to the common people of for the people who've been facing problems for the travel and who cannot appear in the court. So the virtual hearing, e-filing has also been introduced for them. And AI assisted research and operations also, like legal research tool has also assisted, which analyze the vast legal database, extraction of precedent, translating judgment into legal languages. And there are also online dispute resolution mechanism, which digital mechanism resolve the disputes, especially e-commerce or family matters outside traditional courtrooms. And also support for our marginalized groups, like Telelaw connect disadvantaged citizen with the legal advice via common service center has also been introduced for the villagers, bypassing geographical and financial barriers. So the role of artificial intelligence, we will see, then we can see the artificial intelligence has there a big role for the legal researchers, which AI help them for research, where the many platforms have given AI powered researchers, which has replaced the traditional keyword searches, and also contextual querying, which users can ask complex questions rather than just entering keywords, receiving precise answers with direct link to verified case laws. Multilingual support tools like Supreme Court Vidic Anuvad software has also been introduced, which is machine that assisted translation of the tool that use artificial intelligence to translate judicial document, order, and judgments. There also we have seen the case analysis. AI also analyzes millions of previous ruling to extract key points of the law, relevant precedents in the seconds, and structural breakdown system like IDRAF in India has also automatically structured a judgment into a core components, issue, decision, and reasoning and facts. Predictive analysis, judicial behavior modeling. AI has also analyzed specific judges' past ruling to identify tendencies and preference, helping lawyers to tailor their arguments more effectively. Risk assessment. These models also provide percentage-based estimated of winning, potential damage amount, and the likely duration of the trial, which helps the parties decide it whether to settle or proceed to the courts. So it also reduces the human error in the time. It is the time saving also, we can say. AI has reduced documentation and research time by 50 to 70%. It also error prevention by cross referring drafting against massive legal database, and AI flags and citations error and contradictory legal languages and are common in the manually researches when we see. um, So we see the blockchain and smart contract methods also has been introduced in the legal forum. So this the integration of this blockchain act as a decentralized immutable digital ledger that ensure the data integrity and transparency. It is immutable evidence. Once evidence, example photos, document, or sensor data is hashed and recorded on the blockchain, it
Harshita,
becomes
please
a
continue.
temporary proof. Oh, yes.
Harshita, please
Please continue.
conclude your topic.
Okay. So basically, if we see there are blockchain smart contracts and also online dispute resolution, which has been introduced to it, which is like a AI generated only, which AI helps to do transformation help and in the legal system. So basically, we will go towards the disadvantage and the challenges. We have seen many challenges like data privacy, security risk, and algorithm bias in the fair concerns in the AI, if where AI has used on any judgment or any research or something like that. And there should be a and there is also a lack of clear regulatory framework which has not been given by the government yet. There is a ethical concern, human concern, and digital divide and accessibility inequality. So we have seen that if the AI in one place, which helps a lot to us, in other place we see that there is also ethical challenges also and legal issues also we have faced. So according to me, there should be a need for a balanced approach where technology is supporting the tool, which act as a technology as a supporting tool but not as a replacement for human. There should be a need of legal reforms to match technology growth, strong regulatory frameworks of the AI and digital system, ethical governments to ensure fairness and accountability, and inclusive policy to bridge the digital divide. So, conclusion, law and technology are reshaping justice delivery. Technology improves efficiency, accessibility, and transparency, no doubt. It raises also legal challenges and ethical challenges also, and it requires a balanced integration of human wisdom and technology. Future justice depends on the responsible innovations. Thank you.
Okay. Hello, Harshita.
Yes, ma'am.
Wonderful presentation.
Thank you, ma'am. Good afternoon.
Um, Harshita, you spoke a lot about blockchain, right? So, can you tell me what exactly is blockchain and how does it
Uh,
work
Ma'am,
when it comes to
blockchain is a new
that?
technology which has been introduced in like we see blockchain and smart contracts. Blockchain is kind of a ledger which is introduced where the information has been kept in the AI, which cannot be changed if once like any contract has been done or something. So the information has been kept in the blockchain method, which cannot be transmitted or transferred somewhere, and which cannot also be changed. So it act as an evidence. Like for the further thing, like if something transaction has been made or done. So this blockchain method is basically help for the evidences purposes only, which help.
Can you give me a very like live example of a blockchain use? A very
Uh,
common example.
uh, Common example of it. I'm like how.
Common example where blockchain system is being used.
Like ma'am, it has been introduced in India and Indians judicial system. So there it might have been used somewhere in the courts itself for keeping the information on it.
Okay, thank you.
Okay, thank you, ma'am.
Hi, Harshita. As
Yes.
your as your topic talks about the law and technology transforming justice delivery, right? You have talked about the like this digital evidence, right? So what do you think how the due process and the privacy be safeguarded under this in this technology world, in this justice delivery system by the use of technology?
So can you repeat once?
I'm asking how can we safeguard the due process of law and privacy while using AI in the justice delivery system?
Okay, so if we are using AI in judicial system, so the like we have seen the challenges also have been faced like algorithm bias and data privacy. So that to prevent the due process of the law, so I guess in my opinion there should be a regulatory framework, like a governance should be made, like who set the guidelines of like what extent if we are using AI and if we are using somewhere, so at what extent we can use it, and if it is crossing that limit, so it comes under breach of our privacy or not. So there should be a perfect guidelines and framework should be made by which the due process of law can be managed and regulate.
So it means that the data collection will be made lawful for this.
Yes, so it should be lawful.
Okay, thank you.
Okay, thank you.
Now moving forward, our next participant is Shubham Kumar and Piyush Pandey, titled
Gautam,
Cybersecurity and
Gautam,
yes भैया कर रहा.
Piyush Pandey and Shubham Kumar.
yes. So my topic is cybersecurity and data protection law in a digital society. Respected chairperson, honored panelists, respected professor and dear colleagues, good morning, good afternoon, good evening, everyone present here. It is a privilege to stand before such a London gathering and speak on an issue that quietly and powerfully affects all of us, cybersecurity and data protection. Yes, Gautam, this space. Today, our lives are deeply intertwined with technology, from online classes and digital payments to social media and e-governance. The digital world has become an extension of our everyday existence. However, with this convenience comes vulnerability. Every click, every login, and every digital footprint carries with it a legal and ethical responsibility. As law students and future legal professions, we not merely observers of the transformation, we are participants in shaping how law responds to it. My purpose today is not to overwhelm you with technical jargon, but to reflect on why cyber security is fundamentally a legal and constitutional concern, and why the role of law in the digital age has become more important than ever before. Gautam, page 2. Why cybersecurity matters to law? When we talk about cybersecurity, we often imagine hackers, firewalls, or data breaches. But from a legal perspective, cybersecurity is about protecting people, their privacy, dignity, freedom, and trust in institutions. In India, the recognition of the right to privacy as a fundamental right marked a turning point. Personal data is no longer just information stored on a server. It represents individual autonomy and personal choice. When data is misused or leaked, the harm is not abstract. It is deeply personal. Cyber threats today also extend beyond individuals. Attacks on banking system, hospitals, government portals, and even electoral processes raise serious concern for national security and democratic stability. Question: how much surveillance is justified? Who is accountable when data is compromised? And how Do we have balanced security with civil liberties? Cyber security law, therefore, is not only about punishment after damage, it is about prevention, responsibility, and right protection. Page 3, Gautam. Practical and legal challenges. Despite growing awareness, the legal framework around cybersecurity continues to face real challenges. One major issue is that technology evolves faster than law. By the time legislation is drafted and implemented, new forms of cyber threats often emerge. Another challenge lies in jurisdiction. Cybercrime do not respect geographical boundaries. An offense may be committed in one country, affected a victim in another, and involve servers located elsewhere. Traditional legal concepts struggle to adapt to this borderless reality. There is also a noticeable gap between legal rules and technical understanding. At the same time, excessive state surveillance in the name of cybersecurity can undermine personal freedoms if not guided by constitutional safeguards such as proportionality, transparency, and judicial oversight. Conclusion and personal reflection. To conclude, cybersecurity and data protection are no longer optional concerns. They are essential to the functioning of a modern constitutional democracy. For law students like us, this field offers a unique opportunity. It invites us to think beyond traditional legal boundaries, to engage with technology, and to contribute meaningfully to policy, litigation, and research. Thank you. Next, Pius.
Am I audible? Am I audible?
Yes, yes, Pius.
A very good, a very warm good evening to all. Building upon the foundation laid in the first part of this presentation, I will now examine the Indian legal framework governing cybersecurity and data protection, and also will analyze its practical and constitutional dimensions. India's approach to cybersecurity and data protection has evolved through a combination of statutory laws and constitutional interpretation. The primary legislative foundation in this area is the IT Act, that is Information Technology Act 2000, and the IT Act addresses cyber offenses, electronic records, data security obligations, and intermediaries liability. It provides both civil and criminal remedies for offenses such as unauthorized access, hacking, data theft, and identity fraud, which is too common in this time, thereby forming this initial legal response to cyber risk. However, with this rapid expansion of digital platforms and large-scale data processing, the limitations of a sector-specific and offense-based framework became evident. So, in 2023, the Digital Person Data Protection Act 2023 came, which represent a significant shift towards a comprehensive rights based on data protection regime. The DPDP Act regulates the collection, processing, storage, and sharing of personal data, recognize the right of data principles, and also imposes a clear obligation on data fiduciaries to ensure lawful, fair, and secure data processing. To operationalize this framework, the proposed DPDP Rules 2025, which is presented in, I guess, September 2025, which aims to prescribe procedural mechanisms relating to consent management and grievance redressal, and also the data breach reporting, and also the compliance standard. Together, the DPDP Act and the proposed rule seek to strengthen the transparency, accountability, and enforcement in India's data governance framework. At the constitutional level, the right to privacy has been recognized as an intrinsic part of Article 21 of the Constitution of India. This recognition imposes a positive obligation on the state to ensure that any data collection, processing, or surveillance satisfies the test of legality, necessity, and proportionality. Thus, cybersecurity and data protection are no longer merely statutory concerns but constitutional imperatives. Moving further, it is important to understand how specific statutory provisions reinforce this framework. Provisions under the IT Act, such as Section 43 and 66, addresses unauthorized access and computer-related offences. Section 66C and 66D deal with the identity theft and online fraud, while Section 72 penalizes breach of confidentiality. Section 69 of IT Act grants surveillance power to the state subject to the legal safeguards, and Section 79 governs intermediaries' liability through a condition of conditional safe harbor regime. Similarly, the DPDP Act contains key provisions governing lawful processing, consent requirement, obligation of data fiduciaries, right of data principles, penalty for non-compliance, and the establishment of Data Protection Board of India as an adjudicatory authority. These provisions collectively demonstrate India's transition from fragmented regulation toward structured data protection. At this point, it is also necessary to address the role of private actors in data governance. Corporations and digital platforms as data fiduciaries exercising significant control over personal data. However, issues such as consent fatigue and informational asymmetry and weak accountability mechanism raise serious concern regarding the effective protection of user rights. While users are formally granted consent-based controls, the practical imbalance of power often undermines meaningful autonomy. From a comparative perspective, international data protection principles emphasize lawfulness, fairness, transparency, purpose limitation, and accountability. India's framework shows growing alignment and global best practices through comprehensive legislation and right-oriented regulation. Nevertheless, effective implementation requires stronger enforcement mechanism, constitutional capacity to ensure compliance, and deterrence against violations. Based on this analysis, the study highlights three key findings. First, cybersecurity plays a crucial role in protecting democratic governance by ensuring trust in digital institutions and public infrastructure. Second, data protection safeguards individual dignity by preserving privacy, autonomy, and personal freedom in the digital sphere. Third, although India's legal framework is progressive, but it requires doctrinal clarity and enforcement coherence to respond effectively to evolving technology risks, which is coming in few years, like mainly the AGI. But accordingly, this paper suggests a rights-oriented regulatory approach that places individual dignity at the center of data governance. There is a need to shift from reactive enforcement towards a preventive and transparent governance, strengthen regulatory and adjudicatory institutions, and also promote public awareness and participatory engagement in data protection processes. To conclude, cybersecurity and data protection are no longer technical or peripheral concerns. They are fundamental to justice, constitutional governance, and democratic trust in digital society. While India has made significant progress through legislative reform, the effectiveness of this framework ultimately depends on the strong enforcement, institutional resilience, and informed citizenry. Thank you.
Piyush, may I ask question?
Yes, sir.
I'm audible? Yeah. As your topic is about cybersecurity and data protection law in Indian digital society, right? So my question to you is, can this not audible?
Sir, your voice is not clear.
I'm audible now?
Yes, sir.
So my question to you is, so the cybersecurity can be viewed as a national security primarily, or it's just the fundamental obligation? What do you think on this?
Sir, kindly repeat the question. Your voice is not clear.
My question is, like this, you are talking about the cyber crime, cyber security in India. So it can be viewed as a national security or fundamental legal obligation for a person. But the question is like this, आपका जो साइबर सिक्योरिटी कंसर्न जो है आपका, वो नेशनल सिक्योरिटी इशू है या सिर्फ आपका एक पर्सनल पर्सन का ऑब्लिगेशन है?
Sir, you are not audible clearly. I have heard only half question. Whether you are asking it's for only merely citizens or it's for national security. Am I right?
Yes, please.
Yes, sir. Sir, it's for mainly both, but in the concern, it's more for the citizens because citizens plays important role in making government and forming government. Because what government make laws, it's for citizens. It's like it 80 to 90% is for citizens and 10 to 12% it's for national issues. But mainly in cyber security issues are held means we need new laws for for international level. Like in national level we have IT Act, DPDP Act, and mainly new laws which are yet to come, and new DPDP rules which were framed in this year recently. But for international concern, we need laws.
I have posted my question in the chat box.
Yes, sir, I would like to answer your question. Should cybersecurity in India be viewed primarily as national security issue or as fundamental rights obligation? Sir, I would like to say it's for both. So because the Supreme Court has constantly held that rights such as the right to privacy under Article 21 can be restricted for reasons like national security, public order, or sovereignty only if such restriction is lawful, necessary, and proportionate. This means the state must act as a valid under law for a genuine security purpose and only to the extent strictly required. At the same time, citizens have fundamental responsibility to respect the security and integrity of the nation, which justifies reasonableness and reasonable surveillance or data collection in exceptional cases. Therefore, the constitutional position is not a conflict between national security and fundamental rights, but a balance where security measures much coexist with legal safeguard to prevent arbitrary or excessive state action towards the citizens or people of the India.
Okay, let's moving to the next participant. We now invite our next participant. She's actually from Moscow, Russia. I invite Olga Kadlina to present paper titled Interference Factor as Extralinguistic Components in Conducting Master Classes to prepare law students for speaking in international events. I think she's not here.
Anjali, next.
Okay. Our next participant, Riya Yadav, presenting research paper on when individual liberty meets public interest, examining policy making through the lens of constitutional morality in India. Riya Yadav.
Anjali, please proceed further. I think Riya Yadav is also not here.
Okay, ma'am. Next, I would like to invite Animul Islam Molla to present his research paper on balancing individual rights and collective interest in policy making. Animul. Aminul. Aminul.
अनिमुल इस्लाम मुल्ला, आप हैं मीटिंग में? हेलो हेलो अनिमुल, आर यू इन द मीटिंग?
Hello, sir. Hello.
Yes, yes.
Yes, sir. Yes, sir. We are present. Okay. A very good afternoon to the respected chairperson, distinguished panelists, fellow researchers, and dear participants. I am Natasha Nazmi and my co-author Aminul Islam of Center for Legal Studies, Girijananda Chaudhary, are presenting on the theme Balancing Individual Rights and Collective Interests in Policy, a subject that lies at the very heart of constitutional governance and democratic policy making. In every constitutional democracy, the state carries a dual responsibility. On one hand, it must protect individual rights such as liberty, dignity, privacy, and autonomy. On the other hand, it must promote collective interests like public order, national security, public health, and social welfare. The challenge arises when these two interests come into conflict. This tension is not merely theoretical, it plays out daily in policymaking, judicial decisions, and governance. My presentation explores how the Indian constitutional framework, judiciary, and policy mechanisms attempt to strike this delicate balance. Now, the next topic is the slide visible? Hello. Hello.
It's not visible, Natasha.
Okay, ma'am, just give me a minute.
I'm trying to share the screen, but it's not working. Ma'am, I'm trying to share the screen, but it's not working actually.
You can present without a PPT, not an issue. Please go ahead.
Okay, sir. So the next topic is conceptual framework. Sir, is it visible now?
Yes, visible.
Okay. So the next topic is conceptual framework, individual rights and collective interest. So to begin with, it is essential to understand the conceptual foundation. Individual rights are primarily protected under Part 3 of the Indian Constitution, which includes Article 14, right to equality, Article 19, fundamental freedom, Article 21, right to life and personal liberty. Over time, Article 21 has evolved from a narrow provision into a source of positive entitlements, including the right to privacy, health, education, livelihood, and dignity. On the other hand, collective interest refers to societal goals such as public order and morality, national security, public health and welfare, economic development. The Constitution recognizes that absolute individual freedom is not possible in a society. Therefore, reasonable restrictions are permitted, particularly under Article 19, Clause 2 to Article 19, Clause 6 to ensure collective well-being. Now, the next topic is what are the inherent tension between the two? The inherent tension arises when state policies, though aimed at public welfare, limit or restrict individual freedom. For example, surveillance for national security may affect privacy. Development projects may displace communities. The key constitutional question is how far can the state go in restricting rights without violating their core essence? The Supreme Court has consistently held that fundamental rights are not absolute, but restrictions must be just, fair, and reasonable. This principle was clearly articulated in Maneka Gandhi versus Union of India, 1978, where the court ruled that any law affecting personal liberty under Article 21 must pass the test of fairness, non-arbitrariness, and due process. The next topic is constitutional scheme in India. The Indian Constitution does not view rights and duties in isolation. It is given under Part 3 of the Indian Constitution, that is fundamental rights, which protects individual liberty. Directive principles of state policy, Part 4 of the Indian Constitution, which promotes social and economic justice. Although directive principles are non-justiciable, the Supreme Court has repeatedly emphasized that they are fundamental to governance. In Kesavananda Bharati versus State of Kerala, 1973, the court held that the balance between Part 3 and Part 4 forms part of the basic structure of the Constitution. Thus, individual rights and collective goals are not antagonistic, but complementary, and constitutional harmony must be maintained. Over to you, Aminul.
Yes, thank you. As my co-author has already presented the first part of this presentation, next point is that the judicial interpretation of reasonable restrictions in balancing the public individual interest with the community interest. The important thing is that the restrictions which are put by the government and these restrictions are reasonable or fair, it can be decided by the judiciary or judicial interpretation. The case law, the state of Madras versus V0, the Supreme Court uh, has interpreted the reasonable restrictions, or that the restrictions which are put, these are reasonable or not. It was interpreted by the Supreme Court. The court held that the reasonableness must be judged by considering the nature of right infringed, the purpose of the restrictions, the extent and the urgency of the evil sought to be reminded. There must be, the Supreme Court already mentioned here that there must be a rational nexus between the restriction and the objective of the restrictions. The next point is that Article 21 and the emergence of the substantive due process. When we talk about the Article 21, we have to mention about the Maneka Gandhi case. The Maneka Gandhi case limited the state power to restrict liberty in the name of collective interest, and it linked Articles 14, 19, and 21 into a golden triangle. But post Maneka Gandhi case, the scope of Article 21 was broadened, such as the prior to Maneka Gandhi case, the right to life was only included the physical body, but after Maneka Gandhi case, the right to life included both the right to life, the dignityful life, health, education, clean environment, right to privacy, etc. And the next point is that doctrine of proportionality, which was propounded in 2016, formally accepted by the court in Modern Dental College versus State of Madras. And the court recognized that the policy measures affecting rights must be carefully calibrated to avoid excessive intrusion. In case Puttaswamy versus Union of India, the right to privacy was recognized by the court, but the court has also mentioned that there must be if the proportionality test is satisfied, then only the right to privacy will be recognized. The judgment is particularly significant in the digital age, where collective interests such as security and welfare often conflict with personal autonomy. And the next thing is that the public interest litigation and collective welfare. In environmental jurisprudence cases such as MC Mehta versus Union of India, PIL has used to protect environmental rights. While PIL has advanced collective interest, courts have cautioned against its misuse for political motivations also. And the public interest litigation emerged as a judicial innovation. It has expanded the concept of locus standi and enabled courts to address issues affecting collective welfare. And the next, policy making in contemporary India. During the time of health emergency or during the public health, the government used to formulate some rules and regulations like put the lockdown during the time of COVID-19 or travel restrictions or vaccination. The vaccination policies actually done for the welfare of the society or the community, but it may influence the fundamental rights or individual rights also. Apart from that, the development and displacement. Regarding development or infrastructure development, it can help for economic growth, but it may also displace the vulnerable communities. Sometimes the environmental degradation can also be done for the development of society, development of urban area. Judicial intervention synthesizes rehabilitation of those persons, those people, or consent and the fairness must be maintained in developmental process. And the next, constitutional morality and democratic governance. Sometimes the minority rights is being recognized by the court, where those rights may not be accepted by the society also. But to protect the minority rights, in Navtesh Singh Johar versus Union of India, the court has recognized the rights and constitutional morality has upheld there. And the next, lastly, the conclusion. The Indian Constitution experience demonstrate that the balance between individual rights and collective interests is not static, of course, but the Constitution actually seeks to ensure that neither personal liberty nor the social welfare is sacrificed at the altar of the other. And the judiciary has played a pivotal role in maintaining the equilibrium between these two. The main aim of Constitution is to uphold both the personal liberty and also to welfare or community development, and it is the duty or responsibility of the judiciary to maintain the equilibrium between these two. Thank you, ma'am.
Thank you, um, Aminul and Natasha. Good topic. Raman sir, if you want to ask any question, please go ahead, sir.
Yes, Natasha, Emilio, very nice presentation. Am I audible to you now?
Yes, sir. Yes, sir.
Am I audible? Yeah.
Yes, sir.
Nice presentation, both of you. Topic is balancing individual rights and collective interest in policy making. So my question is that you talked about this proportionality doctrine, right? Doctrine of proportionality. So is the
Sir,
doctrine
actually,
of
you are not audible
proportionality
to us.
an adequate safeguard for balancing the individual rights? Now I'm audible. Hello, am I audible now?
Yes, sir. You're audible now.
Your voice is breaking.
I'm
Actually.
asking.
Yes, sir.
I'm asking. Is the doctrine of proportionality is an adequate safeguard for balancing the individual rights?
Yes, sir. Yes, sir. I think the doctrine of proportionality actually balance the individual rights and the collective interest of society.
I written the question chat box.
Yes, sir. Sir, I would like to answer your question. Sir, am I audible to you?
Yeah, you are.
Okay, sir. Sir, actually, the doctrine of proportionality, I will not say the adequate, but it will play an important role in policy making or balancing the individual rights and collective goals in contemporary policy making. For example, sir, I would like to mention here regarding the Aravali case, which is going in contemporary time. Like, Aravali, cutting off Aravali is not exactly, I will not say this is a good decision by the government or bad decision, but there must be a proportionate benefit or merits or demerits. If the cutting of Aravali leads to more harmful situation in surroundings, then the cutting of Aravali is not good. But if the cutting of Aravali is not harmful to the society, or it can protect the environment or pollution of Delhi, then the policy making authority can make a policy by proportionating the merits and demerits of Aravali cutting and the pollution which is going on in Delhi. That is why, sir, I think it's not adequate. I will not say it's adequate, but it can play an important role in balancing the collective interest and the individual rights.
Okay, thank you.
Aminul,
Yes, ma'am.
I want to ask you that when you're balancing these individual rights and
Thank you, Abhinav.
collective,
Thank you, sir.
yes. So when you're talking about balancing between individual rights and collective interest, so as I was just saying on one of your earlier presentations, this is the age of AI, data and everything, right? So in this age, so for example, the government is taking our data. for some kind of purposes, like say they're taking our information, say in Aadhaar card, for example, right?
Yes, ma'am.
So I want to understand, in your view, to what extent the government can go or should go, okay, to make, and will the individual, even if the individual rights is being hampered, is that justified for a collective interest or for a larger scale interest? For example, say if my personal rights are, or maybe say collectively 10,000 people, their rights are they're suffering, right? But when we look at, say, a population of a lakh or 10 lakh people, right? So I'm talking about the proportionality or the balance here. Are you getting my
Yes,
question?
ma'am. Yes, ma'am. Yes,
To
ma'am.
what extent the government should go in to keep that balance, even if our rights are being hampered? For example, the Aadhaar card system. They're taking our information, our fingerprint, our face, our phone number, our address, everything is with the government.
Ma'am, according to my view, I think that if my information is being used by the government regarding anything, if that kind of information, when it will be there in the hand of government, and it is not be a punishment for me, it will not hamper my innocence. If I am innocent and I do not have anything to pay, but I become the victim of this, then this is not legal, or this is not, I don't think this is very perfect decision for the government to access my privacy or access my data. If I am innocent, and if after taking the information, if I become the victim or vulnerable, then I think this is not the right thing to share my data or take the data from me. That's my opinion.
Thank you.
Thank you, ma'am.
Okay, let's move to our next participant, Anshul Sharma, presenting his paper on reimagining the criminal justice delivery system in India, historical foundation, constitutional commitment, and contemporary pathways. Anshul Sharma. Anshul Sharma.
I think Anshul is absent.
Yes. Yes.
We shall conclude then.
Yes, ma'am.
Yeah, please conclude, Anjali.
Thank you to all participants for your insightful presentation, and to our respected resource person for their valuable guidance. We request everyone to please remain patient and wait for the official declaration of results, which will be announced shortly. Regarding the result, the official result declaration session will be held
5 o'clock. Thank you so much, everyone, for joining in. Thank you, Somi ma'am. Thank you so much, Raman sir, for joining in here today and assessing our participants. We will be giving out the result in just 10 minutes once we calculate this session, and we will be out with the results. So just wait for 10 minutes and we will move on.
Thank you so much for having me for this invitation. It was lovely to hear such wonderful presentations, and through these conferences, it's not that the participants who increase their knowledge, it's also we who get to experience a lot of different topics, and we also get to learn a lot of things. So thank you for giving me this opportunity. It was wonderful. Thanks a lot.
Thank you so much, ma'am.
Thank you so much, ma'am.
Ma'am and sir, please share your score sheets with me on the number.
I have already shared with you. Please check on your WhatsApp.
Okay. Okay, so we are back with the results. I'm here to announce the results for all the three sessions. So for session one, the winner for the best presenter is To Shu Yi. Shu ma'am, are you here?
Yeah, I'm here. Thank you.
Congratulations for becoming the best presenter for the first session. Uh, Now we have a tie for second session. For the second session, we have two best presenters. One is Khushi Rani and another is Parul Shukla. Khushi Rani and Parul Shukla.
Yes, ma'am.
Congratulations for being the best presenter for second session.
Thank you, ma'am.
For session three, we have the best presenter as Animul Islam Mullah and along with the co-presenter Natasha Nazmi. Animul?
Thank you, ma'am. Thank you.
Thank you. Congratulations for becoming the best presenter for this session. So, on behalf of Vedseadus Legal, I extend my sincere gratitude to all our participants for being the part of this second international virtual conference on reimagining justice, law at the crossroads of policy, tech, and sustainability. Your active participation, thoughtful engagement, and insightful discussions truly made this conference meaningful and impactful. We are deeply thankful to all our media partners, Satawa Legal Consultancy, Vidhi Varta, Better with Law, and BHEL, for your constant support for helping us amplify the reach and vision of this conference. I would like to express my heartfelt thanks to our conference conveners, Dr. Ankita Upadhyay, Dr. Manvendra Singh Manav sir, and Miss Nadia Fatima ma'am for their guidance, engagement, encouragement, and continuous support throughout the planning and execution of this conference. A special note to and appreciation goes to my dedicated team members, Shubham, Vidhi, Gaurav, Astitva, Piyush, Aditya, and Gautam, who was behind the scenes efforts, ensured everything which is managed smoothly. I sincerely thank all our moderators, Sainoor, Iksha, Ritika, and Anjali, for conducting the sessions with professionalism and grace. This conference would not have been possible without each one of you. Thank you for all your commitment, teamwork, and belief. I may be leaving some names or I must have forgotten some names. I am apologetic for that. If by mistake I have left any name, I have left any person. I'm grateful to all of you. Thank you so much. Thank you so much for being here today and being a part of this conference. Thank you so much, everyone.
Thank you, ma'am. Thank you, everyone.
Thank
Thank
you.
you, ma'am.
Thank you.
Thank you, ma'am.
Thank you so much, everyone.
Can we get the recordings?
Yes, we will be putting this recording on our YouTube page. You can check that. It will be uploaded tomorrow. So you can check that from there.
Certificates?
Certificates will be given to the participants within 10 days. Please stay tuned on the WhatsApp group for all other informations.
Thank you.
Thank you so much.